Tēnā koutou katoa, and welcome everybody to this hearing under the Resource Management Act in respect of a application by RS Sand Limited to establish and operate a sand quarry at 77 Newcombe Road, Cambridge. My name is Richard Blakey and I'm the chairperson for this hearing, and I'm joined by Nari Phillips and Tim Manukau. We've been appointed by the Waikato District, the Waipa District and Waikato Regional Councils as independent hearing commissioners to hear and determine this application. At this point, I'm going to hand over to Jo Greed from the council, sitting at the back there. She's just going to run through the housekeeping matters for this venue. Thank you, Ms. Greed.
Thank you. Morning, everyone. As I said, I'm Jo Greed, so I'm the governance manager here at Waipa. We've got Deb Holmes up the top there and Zoe Vincent here and running technology. So if there's anything you need at any time, just approach one of the team. Just in terms of housekeeping, the toilets are just out on the foyer, off to the right. There's water out in the foyer as well, and tea and coffee. Just a note, cell phones, make sure they're all turned off. We are live streaming, recording the session today, so I do ask that when you speak, can you please use the microphones? They are okay to stay in situ. You don't need to move them when you talk. But when you're finished speaking, can you please turn them off? Because if we have more than one on at a time, we get feedback, so that would be great. There is guest Wi-Fi available if you need it. So on the guest login. So in the event of the fire siren going off, we will follow my team. We will congregate out there in the car park. We'll go out the door behind me. But any concerns about the facility or any questions, just come and see us. And if you've got anything to hand up to the commissioners, can you please hand that up through Deb's Holmes? And if you haven't already, can you please sign the attendance register, which is located on the table by the door. But any questions at any time, just approach one of the team. Thanks.
Thank you, Ms. Greed. Now, a hearing schedule was circulated on Friday and updated last night, so it's very current. Just to highlight the process, I think most people here are probably familiar with it, but just to highlight a few matters, the applicant will proceed to present their case. Submitters will then be invited to speak to their submissions and evidence. It's likely tomorrow. Council officers will then have an opportunity to respond to matters heard. That's likely on Friday morning. And the applicant then, of course, has a right of reply. There is no cross-examination, but we can ask questions of participants, obviously. And yes. So we have agendas from both councils, which include their respective Section 42A reports, and both recommend that consent be granted subject to conditions. We may ask questions about the conditions through this hearing, but that does not presuppose that consent will be granted. We have received and reviewed the evidence from the applicant and submitters. That includes the rebuttal evidence that we've received in the last day or so. So thank you for that. We also undertook a site visit yesterday, a joint site visit of the panel members. We were assisted in that regard by Quentin Budd of Waipa District Council. Thank you, Mr. Budd. And that was both in terms of his liaison role between us and the applicant and submitters, and in no small part to the fact that he was able to provide a four-wheel drive so that we could see the sites from the Powell property. Now, we've issued 3 sets of minutes prior to this hearing. Those have all been complied with, so no further issues arise there. We just record here there were some late submissions from Hermaine Krutzman and Peter Spiller. Those have been recommended to be accepted by the council, and we understand the applicant has no opposition to that either, so those will be accepted. Now, just to go to attendances, if we just start with the council first, if you could introduce the team that we have here. We know we've got some that are on call. We could just run through those. Who would like to lead that off? Okay, thank you.
Good morning, I'm the Quentin Budd, Manager of District Plan and Growth at Waipa District Council.
Morena, my name is Todd Whitaker. I'm a independent planning consultant and I provided the Section 42A report on behalf of Waipaha District Council.
Good morning, Stuart Penfold, reporting officer for Waikato Regional Council.
Brent Vile, supporting officer for Waikato Regional Council.
Dave Manser, landscape architect for the applicant, did the landscape and visual assessment.
Yes, so we'll come to the applicant shortly. Thank you. Who have we got it back there?
Good morning, Cameron Ender.
Yes.
Transportation.
Should just point out, I've got Mr. Peter Stacey down back there for Waikato Regional Council, we're specialists. And we have Mr. Glenn Pope online for erosion and sediment control.
Right, who was that? Sorry, just remind me.
Mr. Glenn Pope.
Yes, okay, thank you. Mr. Whitaker, I understand you have some availability constraints. Is that was for tomorrow? Is that right?
That's correct. So,
Ms. McConaughey, can I just clarify? I understand your counsel for both councils. It was indicated that you might be presenting legal submissions. Is that the case? And if you could just clarify the manner in which or the purpose of those.
That may be the case, and it is largely dependent on the applicant's legal submissions and any matters that arise in the course of the hearing. So the council will present on Friday morning. If there's legal submissions, the intention is that would respond to anything raised by the applicant, and that could be done on Friday morning, or any questions that the panel may have. Thank you.
Okay. Do we have any submitters here as yet this morning? Yes. Welcome. Who do you? Oh, right, Mr. Power. Yes. Oh, okay. Thank you, and thank you for making property available for us yesterday. That was very helpful. Yes. Okay. That's all we have. Right. Mr. Matheson, I'll hand over to you. Introduce your team. We've received your legal submissions last night. Thank you. And a physical copy today. So no doubt you'll take us through that this morning. And I understand from that too, that there's updated conditions, but you'll be presenting those as part of at the end of your case. Is that correct? Or was it as part of your reply?
Yeah, so where we're at is because just the order of the reasons that we don't get into the Waipaha conditions came later, so they got responded to separately. Mr. McDee's evidence contained just one regional council condition. Otherwise, we'd be proposing just provide a full set of it. And then there's one amendment to the landscape plan stage,
That's fine. I mean, any questions that we have are based on the last sets that as per the applicant's conditions to date. So, all right, I'll hand over to you.
Tinakwe, commissioners, sorry. Oh, sorry.
Apologies. Is that better? Tinakwe, commissioners, Morena Tato, everyone, Bell Matheson, counsel for the applicant. So I have people at the front desk and then a lot of the people at the back. Not sure how many you want me to introduce. Maybe I'll just do this lot and then introduce them as we come along. Kurt Hine, so he'll be giving evidence. Christian McDean, whose evidence you would have read. Mr. Dave Mansur, landscape architect. Mr. Arthur Fulton is beside me. He won't be giving evidence, but he's been involved since about 2019. So he's got all the answers, or there to kick me if I don't get it right. So he's sitting there. I might just quickly run through the rest, and if people can stand up, then you'll know who everyone is. Mr. McGrath, Lawrence McGrath, Economics. Michael Hall, Transportation. Jeremy Hunt, Ag First, Highly Productive Land. Mr. Reese Heatley. Noise, Andrew Curtis, Air Quality. Andrew Holland. So he'll be here a little later. Claire Holbrook, Hydrogeology. I haven't seen Dr. Baber. Is he there somewhere? Yes, there he is. Yeah, Matt Baber, Ecology. Mr. Gary Kessels, also Ecology. I saw him. Sean Keith won't be here, I don't think. No, so that was the one we had taken as read. And Christian McDean we've introduced.
Can we just check from that list, Mr. Campbell Stewart?
Oh, yes. Was he not on
there we
there?
go.
Oh, yeah, okay.
Sorry,
Yes,
Mr.
so
Stewart.
he
but
is
you
also here.
didn't make
Well
it.
done. Apologies, we'll add him in. Yeah, so erosion sediment control. Thank you. Right, I shall start. So thank you for advising you went on a site visit. That's going to hopefully put things in context for you. Starting at 2.1, the project you would have seen described in the AE and the Section 42A reports. In summary, it involves the development and operation of a sand quarry intending to extract about 400,000 tonnes a year for about 25 years. Just pausing there, you know, the thing with quarries is it's about, one never knows, it might go quicker, it might go slower, and that comes down to the discussion on term that we might need to have. You can't be precise about these things. So that's why it's deliberately about. The quarry is located about 3 kilometres to the east of the Cambridge town centre. You would have seen access off Newcombe Road. There's proposed to be a main pit area of 23 hectares that will be progressively extracted and rehabilitated. So you'll see from it's probably easier if you have the amended landscape plan, and I can discuss this at the same time. So this is the plan in front of you. So it's got draft on it. Actually, Mr. Powell's will be interested in this. I have sent one to the council, but just primarily involves concerns there. So the original proposal, as you may have had explained to you on site, or you would have read from the application documents, the Karapiro stream is effectively cut a gully. The proposal would have been to go to the edge of the stream and then move back southwards towards State Highway 1, removing the sand as you go in various stages. And if you look at the bottom cross section, you'll see there it's got stage 1, original stage 1 in red, and then stage 1, stage 2 through the line. So what's now proposed, and Mr. Mansell will talk to this more, but just to highlight it now to think about, you'll see there's 2 sight lines that probably should be SIGHT rather than sight lines, but you'll know what I mean. So there's 2 sight lines, one from down the bottom of the stream and one from up on top. So the bottom of the stream, did you go down to the bottom? Walk along the stream? Yeah. So you would have seen there, you get a view up, and then from the top, that's the back of 42 French Pass Road. So the purpose, the original plan would have been to have the stage 1 flat at the bottom. There's now proposed to leave a very substantial mound ridge there. That will be removed, but it will be stage 5, so right at the end. So the proposal is still to remove it, but it will be removed at the end. And primarily that's to do with usability of land, retaining the productive capacity of the land because it's flat. So, but the idea is that that's the last to go. So in terms of the adverse effects on immediate neighbours, there will be a period of effects when that's removed, but that'll be at the very end of the project. So it's still proposed, the important points are it's still proposed to be taken out, but it will be in year 20 something, maybe. There's obviously quite a lot of resource in there, but Mr. Hunt from Ag First can speak to it from a usability perspective. It's obviously much more usable and productive as flat land than a 20-metre high mound with 1 to 5 slopes.
Can we just ask a
Yep.
question at that
Yep.
point, because it's this quite a significant change
Hmm.
to the proposal, and I'll just check with panel on this as well. Can you just be clear that the mound comes out as part of stage 1? It's still cut off as per the, no, it's not. So I
So,
thought you said
yeah.
it's going to be reinstated to that.
No, sorry if I wasn't clear. So the area in yellow will stay at stage 1. It's a bit hard because the amended stage 1 plan, which because it's a black dotted line on a black line, it's a bit hard to see. But effectively, the original stage 1 will go up and over the mound and then down, and you'll see there the line referring to amended stage 1 cut. Yeah.
So I just want to clarify, so this, so what, how long,
Well, it's the full width, isn't it?
it is the full width, which is how long?
It's the full length of the original stage 1.
Yeah,
Um,
which can you remind me how long linearly that is, if you don't mind?
sorry, I don't have that as
Oh, you don't
as
have
a dimension.
You
Yeah,
can come back to you on that.
I'm just trying to visualize it in relation to what we saw yesterday when we were, especially when we were down right by the stream. And how much of that you're going to be retaining, and also how does that influence when you remove vegetation in particular? I guess I'm particularly interested in that because obviously your assessment, I know we are jumping right into things, Chair, but this is, as you say, quite a change. How does this affect your vegetation clearance, your rehabilitation, your compensation? That's what I'm interested in exploring more, whether that doesn't have to necessarily be now, but it's just sort of something to me that strikes me as quite a significant change. So.
In terms of the length, if you're out there yesterday and you're standing down in the bottom of the gully and you would have looked up and you would have seen a small gully that runs up. Sorry, it's a small gully that runs up between the processing area and the stage 1. So it's from that all the way along until the pine trees.
Okay, yeah, I think that's Gully E. I think that was called in the maps. Yeah, Gully E. And then the really big one beyond that is Gully F. Yeah.
Yep.
Yep.
So,
Okay.
so the entire grassed face
Okay,
of the gully wall.
grassed.
Yep.
So there's some forest.
Yes, that's
Towards
the end of
the-
stage 1 didn't extend into the forest.
Okay. Thank you.
I think it might be, what we'll do is we'll actually get that plan marked up with the bund on it, so you can see which area of the perimeter boundary is we're talking about. That would probably be helpful in retrospect, and then you'd be able to see it exactly. So I'll get that done for you.
I think it's not to say that this is a negative in any way. We're just going through our mind. What's going through our mind is the flow-on considerations in terms of, I guess, a few things, but there'll be changes obviously to the hydrology issues, the erosion sediment control, possibly all to the benefit.
Yeah.
But also how much then does that affect what's required in terms of compensation and mitigation planting?
Yeah.
And so forth. So I guess we'll be hearing about that from your various witnesses today.
Yeah, I gather it's about 207 metres, if people want to make a bit of a note of that, but we'll get that accurately. Yes, absolutely. And I think it's probably worth noting there again, without going into the entrails of it, yesterday was the first time that Mr. Mansurg had been able to get on site. And it was Monday. Yeah, Monday, sorry. Monday was the first time he was able to get on site. And so it was at that point that it became, and as a good expert witness, he said, look, there are some issues here. What could we do? And the applicant urgently had a chat because we thought it was more helpful to try and get something drafted up and put on the table for discussion. So, and we've briefed to the extent we've been able to, well, we have briefed all the experts and they will be able to talk to you about the matters you've raised, Commissioner. Yes, so, and then you'll see, so there's a main pit area, and then this is at B of my submissions, 2.1B. There's a proposed 4 hectares for processing, stockpiling and sorting. Ecological restorations proposed over an area of 14 hectares. The quarry proposes to operate 10 hours a day, 7 to 5 weekdays, and 5 hours, 7 to 12 on Saturday. No activity on public holidays. Quarry movements from the site are capped at a maximum of 400 movements per day. So that's heavy vehicle movements, not utes and whatever else, although there wouldn't be a lot of those. Movements is 200 trucks in, 200 trucks out. So 2 movements. So yeah, just to be clear that sometimes, and I think to be fair, there's been some confusion in the community about that. 400 movements, people think that's 400 trucks. That's 200 trucks going in, 200 trucks going in. The average number of daily movements is more likely to be half that, i.e. in the order of 156 trucks, i.e. 78 trucks arriving and departing over that 10-hour period. Again, one can't be precise at all, but that's the best guess we have. Can quickly probably move through the 42A reports. Both recommend that consent be granted. With the one caveat from Mr. Whitaker about the potential impacts of trucks through Cambridge, which we'll come back to, that's at 3.1. 3.3, just talk about some of the discrete areas of further work. There was initially a discussion about the need for additional works to provide for pedestrian or cycling safety on the old State Highway 1 route through Cambridge as a result of quarry truck movements associated with the proposal. And commissioners, you would have gleaned from the submissions and the evidence that one of the issues at the moment is how do trucks go north, and do they go through down Newcombe Road, down the old T-Rail Road, Carter's Flat, Victoria, Queen Street, and then on at Hautapu interchange. Do they do that? How many are going to do that? And more importantly, what's the effect of doing that? As you'll know, as you would have, I'm sure, driven through there when it was the old State Highway 1, that received a lot of vehicles over many, many years. And you would have seen when you, no doubt, did you drive through there on the way there? Yeah. So you would have seen the nature of the activities adjacent. There's another issue so that's one issue for discussion, and there's some Cambridge community groups who have an interest in that. The Miller's property, which if you can just probably easiest to see on the diagram, the plan that you've got there. So 41 Newcombe Road, you'll see in the top left-hand diagram, you can see it on that plan. So under section location NTS, so that plan. So the Millers is just up to the left. I think there's 2 residential dwellings on that side. So they're the closest neighbours. So that's the Millers property. The proposed term of the consent is also in dispute. There was an issue about the trigger action response plan for potential dewatering effects as between NZTA, the Regional Council, and the applicant. I think that's now fully been resolved with the amended condition that's in Mr. McDean's evidence. Really just to help set the scene in section 4.1, 4.2 to 4.5 and 4.6. I've set out what are likely to be the key issues at 4.7. And I'll talk through those, so I won't go to those. Turning to 4.8 of the submissions, I don't think there's really any dispute about the archaeological evidence. The ecological evidence certainly is between the experts. There doesn't appear to be any dispute. I noticed the Royal Forest and Bird Society have asked for 10 minutes. I assume that's not expert evidence because it wasn't pre-circulated, so we'll have to. I did ask whether they had any concerns, and I'm not quite sure what's going to get raised, but we'll address it when it's raised. The geological evidence, there isn't any debate. There was geological evidence raised which addressed the percentage of respirable silica versus non-respirable silica. So I think that issue's been addressed and is agreed between the parties. So although there was geological evidence raised, that's not in dispute in terms of the percentage. And the planning evidence, there doesn't appear to be any real dispute about the planning evidence. The only other planning evidence is Mr. Crisp for a submitter, and his focus was on trying to extract new on-ramps out of NZTA, which NZTA aren't keen about. 5.1, probably is worth just setting the scene here at 5.3 and just quickly running through these. I guess that comes down to the 3 Supreme Court cases that we've had recently. So Port Otago, East-West Link, and obviously earlier King Salmon, and the extent to which the focus has really been on policies and what they mean, and particularly avoid policies. And I'm not going to take you through the framework for a discretionary activity because you're very experienced and you know that. I do think it's worth just quickly going through the principles at 5.3. 5.3a, regard is to be had to them, not given effect to. B, each of the instruments must be read as a whole in conjunction with other instruments. The purpose of the exercise to identify the broad intent of drafters, provisions cannot be isolated and decontextualised. And I guess the point there is there was certainly some of the evidence from some of the parties suggesting that if you fail a policy, consent cannot be granted. And legally, that's just not right. It will be a factor that will need to be weighed, but breaching a policy is not a prohibited activity. And it's really just making that point. That's not the same as putting all objectives and policies in a blender or giving the overall discretion maker unfettered discretion following an overall judgment. Attention must be paid to the relevant objectives and policies. The other point, which again, for experienced commissioners, you'll understand, is that fact and context are important in resolving any tensions between objectives and policies. There may be competing directive policies. There's no presumption that one directive policy prevails over another. And the appropriate balance between competing directive policies will depend on context and facts. The specific language of directive policies is important. Avoid carries its usual meaning of not allow or prevent the occurrence of. Any gap in an avoid policy needs to be properly identified and applied. And what I mean by gap there is an exceptions pathway, really, is probably a synonym for that. There's very good reason to interpret plans and policies in a manner that contemplates some narrow exceptions to avoid policies for infrastructure given it's a public good. In my submission, that principle should also extend to activities that directly support such infrastructure, such as aggregate extraction, or in this case, which includes sand. Policies mean what they say, but they're still policies, not rules. Even the absence of a gap in the language and avoid policies, there is a residual discretion to prevent outcomes plainly inconsistent with the purpose of the RMA and sustainable management. The residual discretion is to ensure that the policy is not implemented unlawfully. And I guess that, that really was the softening of the Supreme Court's position in East-West Link compared to it. King Salmon avoid means avoid. Port Otago said, when looking at what you have to avoid material harm. So that was the Port Otago. So if you can avoid material harm, you can still pass through an avoid policy. And then East-West went slightly further and said, there may be material harm, but even that will, in some circumstances, allow you to break a bottom line if the circumstances are sufficient. And in that case, that was obviously the East-West link along the Manukau Harbour foreshore that was going through volcanic, rare volcanic rocks, through natural habitats, significant ecological areas in a coastal area, there were cultural values. And even in that case, the Supreme Court really said, look, there may be some circumstances where we have to just say, look, that it would be an absurd outcome to say, it would be inconsistent with sustainable management to take such a hard-nosed approach to it. So both Port Otago and East-West represent a softening of the avoid means avoid King Salmon into something slightly more pragmatic. Whether a proposal is an exception requires an assessment of the whole proposal, including its benefits and adverse effects and its remedial or mitigatory aspects. And then whether an avoidance policy is breached also requires consideration of whether conditions can be imposed that avoid material harm. And that's the point I made before. Offsets and compensatory measures may also be relevant to assessing the breach of an avoid policy. And again, that came out of East-West Link. That's quite an important confirmation from the Supreme Court, because some people had previously been arguing you can't use compensation to get around an avoid policy. And the Supreme Court clearly said in some circumstances you can. I mean, there's some effects you just can't avoid. And then you go, well, if you can't avoid it, and there's some circumstances you might not be able to offset because you can't do the calculation or something, and then you're left with compensate. And there were some sectors that were arguing very strongly you shouldn't be able to compensate and avoid policy, and the court said, well, we can, because not to allow that would in some circumstances be inappropriate and contrary to the purpose of the Act. So that's that. So then turning quickly to the four legal issues. The first is the MPS on highly productive land, which has received quite a bit of attention in the evidence. The MPS HPL is a matter to which regard must be had. There is no obligation on a consent authority to give effect to an MPS. The MPS HPL has a directive, objective, and many directive policies. A point about the MPS HPL, and it's really shared by the MPS Freshwater, is it was a dual purpose. It was primarily, in my submission anyway, for a planning purpose, i.e. to direct regional and district councils as to what the plans would be. But then it's also being applied in a consent framework as well, as a matter to which regard shall be had. It's important, as the Commission, as you'll know, a plan must give effect to an MPS, but in a consent context, you only have to have regard to it. And that's deliberate in the Act, and it's quite important in terms of what that means. And as you'll see, there's at least 2 Environment Court cases that have struggled to apply the MPS HPL in a consenting context, because that's not what it was primarily set up for. Although I accept that as a matter of law, you have to have regard to it. The question is to what extent, or what weight gets put on it, really. The key objective and policy 1 and 8 are set out in 6.1. And 6.2, so the objective is highly productive land is protected for use in land-based primary production, both now and future generations. In my submission, the proposal is not contrary to the objective and those policies for the following reason. The proposal involves the rehabilitation of the land back to pastoral use on a staged basis throughout the extraction operation. Once re-established, the land will be returned to its status as highly productive land. To that extent, it will be protected, if not in the short term, then certainly in the medium to long term. So again, unlike some quarries where it's hard rock quarries, it's extracted and that's it. In this case, because of the nature of the resource being extracted, it's sand, it's being removed, the soil profile is being re-established, and then it's being put back to use. In rehabilitating the land in this way at some considerable cost, the land unit has been recognised as a finite resource with long-term value for primary production policy A. The temporary use of the land to extract its aggregate resource sand, combined with the obligation to remediate the land, is not, when viewed in its totality, an inappropriate use of the land. The relevance of temporary compared to permanent loss of highly productive land is supported by the following extract from the implementation guide for the MPS HPL. I'm not brave enough to refer to these implementation guides in the Environment Court anymore, because the Environment Court doesn't like them, because it's the Environment Court's job to tell what policies mean, not implementation guides. Nonetheless, it is helpful and at least provide some guidance as to what at least the Ministry's view on it is. And there's an extract there which you can find, it's on page 31. The key test is to demonstrate the use and development has a functional operational need to be there. And then over the page under the mineral aggregate extraction exception, there must be a significant national or regional benefit that will come to. And And then it goes on to say extraction activities that result in the permanent loss of HPL are envisaged to only be appropriate where the mineral aggregate being extracted cannot be supplied domestically from another source on the non-HPL land. And this is the important bit, the degree to which land is able to be restored to support land-based primary production is a relevant consideration. And that's obviously what's being done here. Pursuant to section 104B, these provisions must be assessed together as part of an fair overall appraisal together with all other relevant objectives and policies. I set out the HPL exception there at 3.9, which you'll see. And there, the point I make it through at 6.6, it's clear from clause 3.93 and 4, the primary purpose of the clause is to direct what provisions territorial authorities should include within the district plan to give effect to the implementation section. And then I've referred to two cases. The first is the Hopkins and Waikato case, and then the second one is a Gray, that you should have got those, I think, if you want to read them, they were circulated with the submissions. The relevant extract, there wasn't a large discussion in the Hopkins case. The court in that case simply made the point MPS HPL is but one of the matters to which regard must be had. I think that was a truck yard, rural zone, highly productive land. Mr. Hunt, I think, was involved, going into a contractor's yard, I think it was. And then the Gray decision is probably more helpful. So that was a decision of the Environment Court of Judge Stevens' division. And I guess it was useful because it did confirm the problems that the Environment Courts, or the courts, are having in applying in a consenting context. And at 2.2, the court said, we intend to proceed on the basis that MPS HPL provisions are among the wide range of identified matters that we must have regard to. Turning then to the exceptions, in my submission, there's clearly a functional need for there to be a sand quarry to be located in the same place as a sand resource. I would add, and this may be an argument being made by some submitters, but just because there might be a sand resource elsewhere, that doesn't detract from the functional need for it to be in that location. And I guess that what I'd say there is the often used example is there's a functional need for a marina to be in the coastal marine area. You can't put a marina on land, whereas, you can put houses on land, you don't have to put them over on a wharf on the water. So there's a functional need in that case. But likewise, you could put a marina anywhere in the coastal marine area. It doesn't have to be in a particular place. In other words, there's a difference, the different test between functional need and alternatives assessment, and you can't conflate the two. So the functional need test isn't about whether it has to be in this location. It's just about whether, as opposed to another location, it's just whether there's a functional need to be in this location. But even if it's not a functional need, there's certainly an operational need. Those two, you'll know, are defined in the national planning standards, and they're put there for your convenience. Aggregate extraction is clearly intended to include sand, so we fall within that category, which I think the relevant planners have agreed to as well. There's a lot of debate in the economic evidence about whether the proposal will provide a significant regional public benefit. Some brief submissions on this to assist. The assessment of significance must be made in the context of the activity and resource in question. In my submission, size of the resource at Newcombe Road is regionally significant compared to other proximate and consented sand quarries. And I think, again, it depends on the assessing significance in the context of this test. Need to take a pragmatic perspective because, sand quarries and quarries generally, because the main cost of aggregate and sand is in their transportation, you're likely to have reasonably large number of smaller quarries rather than one big quarry that sends it out to all of the North Island. So inevitably, in the context of quarries, there'll be a series of smaller quarries rather than necessarily one or two very big ones. But that doesn't make them any less significant. And in my submission, there is a case that this is significant in the regional context. A regional public benefit cannot be so narrowly construed as to exclude commercial users. Commercial entities are nonetheless capable of creating a regional public benefit. And again, there's nothing in the text of the test that says that although it says regional public benefit, that is intended to exclude commercial users. Again, the flavour of that came out in some of the submissions or the evidence. In my submission, the public benefit, there is regional public benefit in there being a secure long-term and local sand supply within central Waikato. The public benefit arises from lower input costs for infrastructure, lower costs for house or commercial construction, thereby benefit future owners or businesses. The contrary evidence of Mr. Green has endeavoured to identify gaps in the analysis of Mr. McElrath. Mr. McElrath has comprehensively responded. To the extent that Mr. Green has criticised the methodologies used by the applicant's economist, Mr. Green has not undertaken his own assessment, and accordingly commissioners do not have any cogent or probative evidence to the contrary. It is inappropriate for Mr. Green to assume all existing consents to take sand at other locations will be replaced at all, let alone with the same conditions. There's the Ngāti Rangi Trust case, which Commissioner, you may be aware of. That was the hydro dam case. The High Court in that case said no, for finite resources, one can't assume in reconsenting them that they are there forever. You need to still have another look at the resource. There were some exceptions. There were some exceptions in that case for things that are so practically unlikely to change, like Benmore Dam and the Waitaki, like that's there forever, right? But other things like water flows, etc., and certainly in the context of a sand quarry, I mean, you could stop and walk, stop, clean up and walk away. I mean, that's certainly one that you can't assume would be reconsented. And the other point, which Mr. Green didn't really comment on, is because a sand quarry is a finite resource, it must eventually run out. So, to that extent, you can't just assume that because an existing quarry is consented, A, it will be consented forever, and B, it will last forever. By definition, it just won't, because it's a finite resource. Likewise, it's inappropriate for Mr. Green to assume the existing environment against which the application is to be assessed includes sand extraction for proposals for which consents may have been applied for but not granted. I think he did refer to 2 applications at least that were in for consent. Again, in my submission, quite obviously, they're not part of the existing environment lawfully. Hawthorne made that clear. The final requirement, so the paragraph E on page 16 of my submissions, the final requirement of subclause J4 is that the regional public benefit could not otherwise be achieved using resources within New Zealand. This clause, with the greatest of respect to the drafters, is truly bizarre in this context. It may have been based, I think, on the counterfactual test under the Overseas Investment Act. I crawled back, because I've had to look at this on a few occasions, I crawled back through all the consultation documents. It was not specifically explained. It wasn't consulted on. It simply arose in the recommended official's version to the minister as a test with no explanation that I could find. We've done our best to apply it, but it truly is inexplicable to me as to how you'd apply it in a natural resources sense. I could understand how you could apply it in some other factual senses, but anyway, concrete requires sand, and in that sense, it's non-substitutable with any other resource available in New Zealand. You can't use wood for sand. It's got to be sand. Artificial sand is not a complete substitute for natural sand. And just I suppose the point on that is, even to the extent someone says artificial sand should be used, you've still got to dig the rock out of the ground. You've still got to grind up the rock. You've still got to carry the sand to where the sand is needed. Like, all it's doing is adding 2 more steps to the processing at some expense. The regional public benefit of providing sand could not therefore be obtained by using material available in New Zealand other than sand. In order to provide a regional public benefit, there must be enough sand available to meet market demands, and it must be provided to the relevant market for a cost-effective price. If sand's not available or sand from further away is too expensive, there'll be no regional public benefit. So to that extent, we say, to the extent the test is understood, that we comply with it. Second issue is the control of the control of trucks on truck routes on public roads through Cambridge. Much of the concern from submitters relates to the prospect of heavy vehicles from the proposed quarry travelling through the Cambridge CBD. Firstly, this concern must be put in its proper context. There's no suggestion, for example, that the quarry trucks would travel through the Cambridge town centre, i.e. the CBD proper. So I don't know if commissioners, did you go to the Cambridge CBD? Have you? But yeah, so there's no suggestion that trucks are going to drive through the main street of Cambridge. So the route is instead the one that we discussed. So it's travelling along the old State Highway 1. And I note there, and I saw you, Commissioner, that you had looked at the nature of the land use along the old State Highway 1. Secondly, there's a legal question as to whether and what extent a consent condition can purport to control how many quarry truck operators choose to use a public road. In that regard, I make the following submissions. Truck movements directly from an activity as a quarry can be subject to a resource consent condition addressing matters such as safe access from a site to a public road, intersection upgrade, and potential amenity of effects of trucks coming into and leaving the site. And every new quarry will have consent conditions on that basis. While consent conditions have occasionally required a quarry operator use best endeavours to encourage truck drivers to use or not to use particular routes, the consent condition cannot be more onerous than that. That is because there is a statutory and common law right for people to be able to use a public road, and to the extent that controls are required on such a use, and that's a matter of full control by the road controlling authority under the relevant land transport legislation. I'm reasonably sure this is not apocryphal because I was involved in the AUP hearings, but I'm pretty sure that the AUP has an activity status of permitted for the use of public roads because, certainly it was debated. His Honour Judge Kirkpatrick, who was chairing it at the time, was at pains to point out the common law rights to pass and repass on roads, and the RMA is not going to get in the way of that. To the extent that district plans purport to control high vehicle movement activities, and that assessment criteria is generally limited to matters such as the location of the activity itself, broader connectivity of the network, and the safe and efficient function of the road hierarchy, and other road users. There's a reference there in the section 16 transportation matters, which is part of the assessment criteria applying to all discretionary activities. None of those matters in my submission extend to amenity effects for those in the Cambridge urban area of quarry trucks using a public road. Certainly nothing was pointed to. I accept it's a fully discretionary activity, although one must look at the relevant assessment criteria to be guided by that. It certainly does include things you'd normally expect, like pedestrian safety, traffic safety, etc. So I understand that. But then if one looks at the amenity criterion for noise, which is at 21.1.4, the ability to control noise and vibration effects relates to sites, land uses and activities in the vicinity. And in my submission, the centre of Cambridge, 3 kilometres away, is not in the vicinity. So if there was purported to be a condition, which I say is unlawful anyway, to control trucks because of noise and vibration through the Cambridge old Soho 1 route 3 kilometres away, I would say, where's the assessment criteria allowing that? Because it seems pretty clear that plans directed to in the vicinity of the site for the reasons we've just discussed. Finally, case law on the reasonable connection of conditions to off-site effects, even full discretionary activities are subject to reasonable constraints. The Landco case, which is long-standing, commissioners may be aware of that. That was the development of the old quarry in Mount Wellington. Concerns raised about traffic effects. Judge Thompson, I think it was in that case, said, like, this developer can be responsible for the intersections around Mount Wellington, but we're not going to make this developer responsible for the gridlock in Auckland. Like, there's just got to be some common sense limits to what a developer can sensibly do. I guess the last point.
Can I just ask on that last point there? Is that the latest relevant case on the point? And, and the reason I ask is because it's from recollection, it was focused on traffic volumes in and around that area, as opposed to what I think we're dealing with here is not so much from a volume perspective per se, but the nature of that volume, the characteristics of that traffic rather than just general traffic. It's distinguishable to some extent. And I'm just wondering, is there case law around quarries and associated traffic that might be relevant? or more relevant than I think the Landco case might be.
Yeah, I had a quick look and I'll have a look in closing, see if I can find anything else further of assistance. The answer, and it, it won't surprise you that it often comes up, especially in quarry cases, but the responses are generally the council has bylaw ability to restrict heavy vehicle movements through town if they're concerned about it. They can pass a bylaw under their land transport legislation. There's requirements for trucks to have warrant fitnesses. They can't be noisy. There's the ability of council to control noisy trucks who want to put on great big mufflers or take them off or whatever they do. So there's all that ability to control effectively noise and other activities. And every time, certainly I've been involved in the argument, the commissioners sort of fall back on, well, it's a public road, you can use it. To the extent there's other controls that are needed, then there's other statutory mechanisms. The RMA's got to be read in conjunction with all those others. But I will have a look. I had a quick look and I couldn't find anything, but I will look a bit further for you. For those reasons in my submission, the commissioners don't have scope to consider alleged amenity effects associated with the use of the Old Star Hill 1 through Cambridge by quarry trucks. I accept that you do have scope to consider the safe and efficient operation of the road hierarchy, to consider any necessary pedestrian cycling facilities, but the needs need to be undertaken on a reasonable and proportionate basis. In other words, any assessment of the use of the Old Star Hill 1 needs to consider that it's identified in the district plan as an arterial road. So at the very highest level of a district road. And we are suggesting a consent condition requiring the consent holder use best endeavours to use or not use a particular route, which in my submission, A, is volunteered as an OG condition anyway if needed, but B is within scope. And then finally, to the extent there is scope to impose traffic-related conditions on effects remote from the project, there's no requirement in my submission for there to be zero effects or even a minor effect. A discretionary activity can be granted consent irrespective of there being a significant adverse effect, although we say that's certainly not the case here. The coalition government's accelerated the funding and development of the Cambridge to Piriti section of the Waikato Expressway through the GPS 2024 as its government policy statement. The relevant environmental approvals are currently being considered by an NBA fast track. So it's there's only two that got into the NBA fast track before onto our third fast track in 4 years. I gather a decision on that is due to be released in the middle of the year. One would assume it's going to be approved, and then we understand that the works will commence promptly after that. The relevance of that project to this application, and I'm not sure, did you go down, you not sure if you travelled, did you travel to the Karapiro mobile station at all on the expressway? So if you're familiar with it, so you head south on Star Hill 1 and you come to the old mobile station, I think there was a car yard or something next to it. It's quite a big area. So the relevance of that is as part of those works, there's going to be a full diamond interchange there as part of the C2P project. That interchange would allow quarry trucks with an ultimate destination to the north to travel back on the expressway and then travel north again. And that would be an alternative travelling along the Old Star Hill 1 route through an urban environment that requires you to go down a hill and then up quite a steep hill. Exactly what route will be chosen by quarry truck operators is likely to be affected by the extent of traffic on local roads, also time of the day. It's expected that it'd be quicker to travel along C2P and it would certainly use less fuel. In my submission, the C2P project is not part of the legal existing environment because the approvals haven't been granted, but it remains open to the commissioners if they're wanting to encourage the use of C2P for northbound quarry trucks and nonetheless impose a condition on the quarry as follows. I'm confident that that's a legally valid condition because it's not reliant on it happening. It's simply saying if it does happen, then you will encourage truck drivers to use it if they're heading north. Obviously, if truck drivers are needing to go west of Cambridge, they're going to need to go along the old route and then turn left. And likewise, if they're travelling east of Cambridge. So local sources are going to need trucks. You can't get local product to local areas without going on local roads. But to the extent they're travelling north of Cambridge, that's the intention of that condition. There's a brief comment here which we can listen to the effects of the dust experts from both Mr. Curtis and Lou Wickham. So we can discuss any legal issues. To the extent there's a discussion about the appropriate activity status, and it was raised in Lou Wickham's evidence, in my submission, the proposed activity does meet the permitted activity standard, but even if it doesn't, the application is assessed overall as a discretionary activity. Any necessary consent can be lawfully granted by the commissioners. There is some case law on that, including quite recently by the Environment Court in terms of the difference between an activity and a reason for consent. In this case, the activity is a sand quarry with all the associated effects. And the judge in the Arapatu case, which I will give you in closing, drew a distinction between a reason for consent and a activity. And again, took a pragmatic view that if you're applying for an activity such as a quarry and all associated effects with that, there needs to be a degree of common sense as to jurisdictional scope. If you apply for a quarry and then you say, oh, and by the way, I want a consent for a service station as well, you go, well, that's a different activity, right? So you obviously clearly do raise jurisdiction issue. And then commissioners, you'll be aware of the section of the Act, I think it's 104, 5 or 6, that allows you to grant consent for any activity status irrespective of what was applied for as well. There's a discussion on landscape values, visual amenity, and again, that's largely been addressed here. The point I'd make, I guess, on landscape values, visual amenity, I think both the landscape experts are reasonably comfortable that other than the potential effects on 42 French Pass, there's no wider landscape effects other than more immediate neighbours. The applicant would be very interested in hear from the millers if they are going to appear as to their preference for that bunding, and there'll be evidence on that, but any preferences from their perspective would be welcome. And then the evidence record that we've been through and the submission. So happy to answer any other questions. Otherwise, Mr. Hine will be first up, and I'm not sure what time you were.
I don't think we have a scheduled morning break, do we, at this stage? No. We'll carry on through
Right.
12, I think is the plan.
Thank you, Mr. Mavis, for your opening submissions. Submitters have raised a number of issues in and around truck movements, traffic in Cambridge. You touched on the use of best endeavours to control truck routes. This may be a question for the operations manager, Mr. Hine, but what are some examples of best endeavours?
Yeah, well, I will let him talk to them. What we've had in some other, certainly in this case, there's a proposal to be a journey management plan, which would be part of the quarry management plan. Mr. Hine can speak to that. Some of the other quarries that certainly I've been involved in, Clevedon has an induction requirement. So if you're going to go there and if you're going to sign up to be able to take aggregate from there, you've got to go through an induction process that does things like identify key routes, key risks, those sort of things. So again, that's another example. But Mr. Hine can speak to those further.
Thanks. And the other question I had, just touching on 6.19 of your submission, just interesting to see what the latest views of NZTA is in regards to the suggestion that quarry trucks go to, when travelling south or even north, to utilise that Karapiro Bull Diamond interchange.
Well, I hope they've designed it for trucks. Yeah, I don't, they're not turning up, I don't think, but certainly the position, as I understand it, is they're full, and Mr. Hall will be able to address it, but my understanding is they're full-size double lane roundabouts that will be capable of accommodating large truck and trailer units. If it's a concern from the commissioner, we could get something from NZTA, but I don't think they're turning up, is my understanding.
I
Yeah,
could,
sorry, Mr. McDean can speak to that.
We met with the C2P team, Jason Harrison. I'm not sure of his title with the agency, but he's running the online section from where the Cambridge section ends to Karapiro. And we raised the issue of trucks using that diamond interchange, and they were comfortable, more comfortable than they were than us using Hydro Road or the Hydro Road turnaround. And he gave us, appreciating it's been heard by the fast track, but he gave us some timeframes around when they anticipated construction starting and when it would finish, and their issues sort of went away when that online section to Karapiro was completed.
Thank you, Mr. McDean.
So just on the functional need aspect, is the key evidence there, Mr. Hines, in terms of the access or the ability to find concrete sand as a resource within the region, understanding, I guess, a very general geomorphology of the area, but the actual location, as I understand that evidence, is in terms of trying to find that quality of sand.
Yeah.
It's led them to this site, and that they're not extensive throughout the region.
Yeah, and Mr. Hine, what was here? What's that? Yeah, Mr. Hine, do you want to, or why don't you speak to, he can speak to that, and he's next. If that's all right, we can get him to deal with that then. That's right, but just again, it's probably worth making the point too that remember, unlike some tests for this one, it's all operational. So you can get either, you don't have to meet both, it's just one or other. And we'd certainly meet the operational. But yes, you're right, it's the nature of the resource. And, and I think Mr. Hine and Mr. Foote was involved in a lot of the looking. Did go digging holes around a lot of Bay of Plenty and Waikato.
Just the other point I wanted to raise with you, and I don't really want to get into the weeds on this at this point, but you have raised the issue of the lapse date that's been proposed in the conditions, just in relation to the land use consent.
Expiry, you mean?
Expiry date, sorry.
Yeah.
There's quite I've got questions throughout the consents, because it's a query of what's been sought through the application, the usual 35-year duration for the regional type consents. I'm not sure what lapse dates are sought.
It's just standard lapse dates.
So that's the five years? Okay.
Yeah.
Then there's the Waikato Regional Earthworks consents seem to have a duration limit or expiry limit to them.
Okay.
Are they not Section 9 consents?
Yep.
They don't seem to bring in Section 13, and I can't understand the reason for applying.
That's a fair question, so we will address that. Thank you. Yeah, that's fine. Deal with it. Thank you. Is there anything else?
Oh, and we'll explore this with the witnesses as well. One thing that's come up in our recent reading of the evidence was an understanding, it came through the rebuttal evidence, I think, just an understanding that overburden is part of what's to be sold from the site, obviously to a much lesser, probably a tenth of what's proposed for the sand, but it wasn't something that was aware of at the beginning. And it's just to understand what is used for the rehabilitation if the overburden from the site, apart from what's needed for bunding and so forth, is then to be sold. I don't have an understanding of how the soil profile that you mentioned earlier, the re-establishing of the soil profile, is to be achieved without then re-importing whatever's needed to create a usable soil profile. Now, I'm sure that's beyond what you want to be talking about, but it's just flagging that as a particular issue.
Yeah, no, I understand that, and that we did discuss it with the team, so Mr. Hunt will address that, and you would have seen that the landscape rehabilitation plan has been significantly beefed up in respect to the soil rehabilitation. So if you look at the latest version of that condition, which I think is Mr. Mansug's plan, will be in and in rebuttal evidence, you'll see that. So yeah, we're aware of that issue, so we can speak to that.
Right, and just as a point, certainly we'll be exploring some of those plans, the mitigation plans and the detail of them, because I'm not sure if it's just standard approach for the area for quarries, but I'm surprised at the lack of detail in some of the mitigation plan, the land rehabilitation. That's something that we're going to be looking into, but I don't know if there's a general legal submission that you'd make at this point about how far that should go. For example, the extensive ecological replanting, I guess I'll call it, throughout that stream environment is really very conceptual. And I don't know how to hang any condition on it in terms of what it's requiring. There's no plant density, there's no time frames, there's very little. So I wanted to raise that with you early.
Yeah.
That's something that we're very interested to explore with the witnesses.
Yeah, no, that's fair. And I think certainly, I think in fairness, the management plan conditions, if one had a little more time, and we can certainly deal with it in reply. I mean, I'd normally expect those management plan conditions to have an objective and then a clear set of this is what it must include. There was a bit of time pressure involved in some of that, but I take your point, sir, and that's something we could certainly work up. I mean, ultimately, my view from a legal perspective is you need to be able to, if you're going to certify something, you need to say what's the purpose of it, and then what are the 15 things it needs to have, tick, 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 without getting into the weeds too much, but certainly in that list you would expect, I would have thought, to see some of those key factors. So that's fair comment, sir. Thank you. Right, Mr. Hine. Thank you. So Mr. Hine, and I will, if you hand me that, you've got copies. You're just going to read to it. Okay. So he's just going to read, so I've asked the experts to either bring or hand up, or we'll email them the summary document. So if he's reading it out, you will get a hard copy. So just telling you that now before you scribble 2 hours of notes.
Is it possible to get those now as we go through it?
If we can borrow a photocopy.
Oh, okay.
I was
All
just
right.
thinking the electronic versions
Oh, do you
actually,
have an
which would be
electronic one? Can you email?
much more useful.
Yeah, okay. Can we just have a 5-minute adjournment? We'll just email them. Sorry, it's just, thank you.
All right, good morning. Sorry about that mix-up. So just to introduce myself, I'm Kurt Hine, General Manager of Aggregates at Stevenson Aggregates Limited. Stevenson Aggregates became a joint venture partner with Revital and a new company, RS Sands, to consent, develop and operate the sand quarry in early 2023, Revital decided to sell their half of the JV to Stevenson Aggregates, making RS Sand a wholly owned subsidiary of Stevenson Aggregates. The applicant, RS Sand Limited, is a fully owned subsidiary of Stevenson, and I'm fully aware of the proposed use of the site and the resource consent application being heard today. Should the application be successful, the site will be operated as a Stevenson's quarry, and as such will be my responsibility. Stevenson owns and operates a portfolio of 8 quarries across the Upper North Island. Within the Waikato Bay of Plenty region, Stevenson operates the Tauhei and Wainaro rock quarries, Tuakau Sand and Cleanfloor operation, which are in Waikato, and in the Bay of Plenty, we've got Bell Road Sand Plant and Poplar Lane Rock Quarry. Stevenson employs approximately 150 people across the business. As noted in my evidence, aggregate is an essential component in a wide range of construction and building types, including roads, motorways, drains, pipes, airports, houses, hospitals, factories, and offices. Aggregates underpin virtually all of our day-to-day activities. With the growth anticipated by the future-proof growth strategy being an additional 66,000 houses over the next 30 years, this means a significant amount of infrastructure must be extended or expanded, all of which will require aggregate products as part of their construction, not to mention their housing themselves. Using the information contained within the market economics report prepared for RS Sand following a request from the Waipa District and Waikato Regional Councils, overall demand for sand is expected to increase from 793,000 tonnes to 951,000 tonnes by the year 2048 within the Waikato and Bay of Plenty of markets. It is our commercial opinion that the Waikato and Bay of Plenty regions have limited access to new aggregate resources to meet this growing demand. Sourcing aggregate outside of these regions significantly impacts the cost of aggregate for future development. This is why expanding the aggregate processing capacity through a long-term opportunity like that at Newcombe Road will provide cost savings to the Waikato and Bay of Plenty economies. The estimated market for products produced at the proposed quarry can be divided into 3 streams: concrete sand, 45%, fill sand, 40%, and turf sand and pebbles, the remaining 15%. Concrete sand will usually be transported by truck and trailer units to ready-mix concrete sites in the Waikato and Bay of Plenty that have a known location and predictable demand. Fill sand is used as a bulk fill in local subdivisions, infrastructure projects, and under new buildings. The unit type used to transport material depends on the size of the receiving site, with building and house sites likely to be truck only, and larger subdivisions and infrastructure projects, truck and trailer units. The on-site processing aggregate into concrete sand is important as a high-quality specified product that requires processing to ensure consistency, low fines of clay and silt, minimal deleterious materials such as wood, pumice, coal, non-reactive mineral makeup, and favorable grain size and shape to ensure that concrete produces of adequate strength, consistency, and is replicable. We anticipate that the sand processed in this operation will operate in a similar way to our Tuakau sand plant. Once extracted, the sand is subjected to a wet process for classifying the sand into different products. This helps to minimize any impact from dust and noise. Stevenson are happy to accommodate a site visit to our Tuakau operation upon request. We operate a robust consent monitoring and compliance process. Like our other operations, we'll have an environmental advisor supporting the quarry manager to ensure compliance with consent conditions is ongoing and any reporting is timely. That was the end of what I submitted formally. I've also take the opportunity to answer the questions around the truck management examples, and also in response to the site selection, if you'd like. So some of the examples, to build on Belle's answer around managing the truck, some of the examples I've got, Belle mentioned Clevedon, the induction process that we go for truck drivers. Part of that as well is some of the local issues around other uses of the road, such as people riding horses along the road. We also did an awareness campaign through the weighbridge that we run regularly as well, citing and road code guidance about managing speed and how to behave around horses. And we also had a speed camera set up too, so we could monitor truck speeds. And so if the speeding report goes through to the weighbridge, so we can address it with the trucks, or at times we have had to ban trucks from site as well. Another example at our Poplar Lane quarry, which comes out onto a busy road during peak times, we've got signage installed advising trucks not to turn right across the road, so they're turning left. And then if they need to go in the other direction, use the roundabout further up the road as opposed to turning across that intersection from a safety point of view. And then obviously, Stevenson's also has our own transport business. So anything that's carted on our own trucks is GP tracked and monitored. So we can direct our own trucks to follow preferred transport paths also. And then also we have a process, particularly the Cleveland example, where we've given contact details. So if there's any complaints from the community, encourage them to take the truck registration. We can take those and address those with the individuals or the companies involved. And then I'll answer part of the question around the site selection, the quality of the sand, and then Arthur, I'll ask you to expand on that because you're part of the site selection process. So three important characteristics required for site selection is obviously the quality of the sand, which is naturally deposited. So matching that up with the location of the market, so where the demand is going to be to minimise transport distances, because it's such a big part of the delivered cost of aggregate. So matching those two together, as well as accessibility in terms of being able to access the sand and the surrounding infrastructure as well. And you to build on that, Arthur?
Yes, I became aware that the Bell Road sand operation was coming to an end in Tauranga. I spent about 2 years looking around the Bay of Plenty for a suitable site, and when there was no suitable sites in the Bay of Plenty, we started to look around the Waikato, and it took another 18 months to find this site. Sort of want to highlight the difference between a site that's a full sand site, which is that pit sand, versus a concrete sand, and that's generally around the landowners' desire, what type of sand to sell, and the quality of the sand. So people might say there are 20, 30 odd sand quarries in the Waikato. There are about 4 of them that do concrete sand. That's the stuff that's going to go into the concrete for our future infrastructure. Thank you.
Thank you. Just on that point, is there a grading standard of concrete sand? And the reason I ask that, I know some concrete sand is better than other types of concrete sand. I understand Kaipara is not as good as Parkeri, for example. Is there a particular industry standard that this sand at this site is or meets?
It's regionally dependent. Like the concrete sand that comes off aggregates in the Canterbury area, generally the Canterbury spec will be around that. And the Waikato spec is generally around this type of sand. So most concrete companies in the Waikato region will use a sort of standard spec around Waikato sand. In the Bay of Plenty, that's different. That'll have to change because there's no sand left in the Bay of Plenty. So it'll have to come from the Waikato.
Thank you, Mr. Pine. I was just wondering if you had a feel for what proportion of trucks that would be leaving the site were Stevenson's trucks or trucks that would be under some sort of contract where obviously you have a bit more control in terms of expectations around routes taken, driving, driver behaviour and all that sort of thing.
You look at that modelling, don't you, Arthur?
The Stevenson's trucks would be probably 5 to 10%.
5 to 10.
And
Okay.
contracted trucks would be probably another 5 to 10% for where the sand quarry gets a contract with a concrete company that supply and deliver.
Mm.
Many of those concrete companies have their own fleets and will come and pick up.
Okay. And so the remainder of the fleet, if you like, that's going to be servicing the area, they're just private entities, or that you would have no, are they just people who stop by and say, oh yeah, I'd like a load of concrete sand, please?
Yes,
Is it as simple as that? Sorry.
it is. The sand that goes into the Cambridge fill pit sand area will be local operators, owner drivers.
Mhm.
And a lot of the concrete companies will put out a thing to say, we're going to pay X to get it from Newcombe Road to Tauranga. And people who have empty trucks going back to Tauranga will pop in and grab a load.
Okay. And can you just remind me what proportion of the sand that will be taken off site will be concrete sand versus
45%.
45% will be
Yeah,
concrete
and I
sand.
think 30 plus is going to, 35 is going to be pit sand. I think Kurt just said that earlier on.
Sorry about that.
The breakdowns.
Yeah, we had 45% fill sand. So 40% fill sand, 45% concrete sand.
Just one other question. The volume was originally assessed at 400,000 tonnes total. Does the change to the proposal, does that affect that in any market level?
No. So that's 400,000 tonnes a year.
Oh, sorry.
It'll take time to get up to that. The overall volume doesn't change either, just the staging of when the sand comes out from where in the site.
And just in terms of my earlier question around what's being sold from the site, was the overburden part of that 400,000 tonnes, or is it additional to that?
There is no overburden on the site, really. The overburden is mixed in with the sand and silt layers. And we are able, apart from a thin layer of weathered sand at the top, just under the topsoil, and we want to replicate what's there in our rehabilitation. So we'll save that in temporary bunds and then put that on the floor as we progressively move across. This overburden being sold from the site references that we won't have an overburden dump on the site. So the pit sand actually to lock up under a building site to get it rolled and to compact needs a bit of silt in it. So what happens is that silt that we talk about as being an overburden is actually interlayered within the sand. And so that will get mixed up and sold as part of the pit sand.
Okay. All right, thank you.
So just an argument, so 400,000.
Yes, yes.
Anything else?
No.
Thank you.
Next up is Mr. Mansur. Now, Commissioner Phillips, I did ask that you get an electronic copy of that. We do have hard copies, but hopefully Ms. Berry may have emailed you.
That's just come through.
Great.
Thank you.
Thank you. Commissioners, we have hard copies if you'd like hard copies, or are you happy with electronic? I'll hand it out. Okay.
Good morning, Sir, ma'am. I don't know how much of the prelim you'd like me to go through, or I intend to basically read this and propose to start the second paragraph.
Yes, I think summaries are helpful, particularly here where there's been a significant change. So I think if you can read it, please. Thank you.
I'll start at the beginning then. My name is David Graham Mansell. I'm a landscape architect and recreation planner, appearing on behalf of RF Sands and in support of the application to establish and operate a sand quarry at 77 Newcomb Road.
Sorry, you could probably start from third paragraph.
Okay.
Okay.
Appears to
Just
be.
move it a bit
I'll
closer.
just, yep. I'll just reference in the second paragraph, sir, that the assessment approach I have followed is the standard assessment approach outlined in Te Tangi Te Manu guidelines. And starting at paragraph 3, the quarry will be developed over 5 stages, extracting up to 400,000 tonnes of sand per year over 25 years. Importantly, the proposal includes the progressive rehabilitation. Each stage will be restored before the next stage commences, and the final landform will be shaped to reflect a natural river terrace, revegetated with appropriate species. If the Commission is like, I'd like to just take you through the 3D model that was produced for the application. And please, Zoe can throw that up. And if we can start with the overview, which is the little button on the far left. And perhaps, so Zoe, if you could just wiggle it around a little bit just to show, say that we can just pan around a little bit from that fixed location. Just to orient yourselves, in the middle centre is the site itself, which will become evident. If we look at the very bottom of the screen, we can see Mr. Powell's arena, which is the white building down there, and his house. If we move across to the left-hand side is the Julian property. Now, while the 3D component of the pine trees that have been removed in 3D, the aerial photo drape still shows them there, so hence that dark patch. If we'd just like to flick to stage 1. Yep. So bearing in mind the model has not been updated since the amendments, and effectively this identifies the primary cause of the concern of the landscape effects on the neighbours to the north. We could just quickly walk through the stage 2. So stage 1 was the initial cut-in. Then stage 1 gets rehabilitated. Stage 2 starts to move back. Stage 3, please. And then stage 4. So we can see a progressive rehabilitation. How that would change with the proposed amendment is the rehabilitation would still occur. So when the gully wall is removed at the end of the period rather than the beginning, it would open up views to an already rehabilitated site. Sorry, we just flicked to the last one as well. And there'd only be a small area of disturbance in the foreground. I have set up views from all the view locations in my report. This is accessible to you. I don't know how much you'd like me to go through or discuss. I'm in your hands there, sir.
I think if we just keep that image there for now.
Yep.
If you need to refer to other views, then do so, but that gives us a good appreciation. Thank you.
Thanks. So resuming on paragraph 5. From a landscape perspective, the quarry, as applied for, will result in moderate to high effects at a site level during the initial stages due to the changes in the landform and the removal of the vegetation cover. And so I think that this is significantly addressed by the amendment. However, those effects will reduce progressively over time as restoration occurs. In the wider landscape, the effects will be low due to the containment by topography and existing vegetation. There are no outstanding or sensitive landscape features that will be compromised by the proposal. In terms of natural character, the Karapiro Stream Gully adjacent to the site is already highly modified with pasture, weeds, wildling pines and bank stability issues. I assessed its current natural character as very low. The proposal includes significant ecological restoration component, including 13.7 hectares of wetland riparian planting, And in my opinion, the project will enhance the natural character of the gully over time. The visual catchment of the quarry is relatively small. From public roads such as State Highway 1 and Newcombe Road, the quarry will be either not visible or only partially visible. Where it is seen, the views will be filtered by planting and bunding. Screen bunding is required around the processing area, along the western boundary and along part of the southern boundary to screen views. I assess the visual effects from these public viewpoints as low to moderate during operations and reducing to very low post-closure. Not discounting the view from 41 Newcombe Road, the more sensitive views are from private properties on the north side of the Karapiro Gully, particularly 94, 116 and 42 French Pass Road. Following the removal of the pine shelter belt on 42 French Pass Road, views from the north into the quarry have opened up, and I assess that during stage 1, the visual effects of these properties could be moderate to high, particularly from 94 and 42 French Pass Road. However, these effects reduce in the later stages due to an increase in distance, site rehabilitation, and implementation of mitigation. To mitigate effects, RS Sands is proposing earth bunds and extensive screen plantings both on-site and where agreed off-site. For example, it's my understanding that an agreement has now been reached with the owners of 94 French Pass Road, it's the Julians, to implement and maintain for several years a band of planting along the upper edge of the gully within their property to screen views into the quarry site. I understand that because of this agreement, they've withdrawn their submission. With respect to 42 French Pass Road, the Powell property, I acknowledge that this property will experience the greatest visual effects. Initially, I was unable to visit the site, but later conducted a site visit with Mr. Oliver, the peer reviewer, and Mr. Powell. Based on the site visit, I confirmed that the effects of stage 1 would be moderate to high, especially from within the gully and along the access tracks. However, those effects reduced quickly near the house as the quarry cuts below the foreground gully crest. Basically, the gully wall in the front will hide it from view from areas around the house, or most of it. Effects in later stages reduced to moderate and then low to moderate with very low effects post-restoration. Now, I understand the applicant's reviewing the stage sequence, and this has been presented to you this morning. To try to reduce these effects further, and particularly by retaining more of the gully wall during earlier stages. Additionally, I confirmed that with the cooperation of the Powells, it would be possible to fully screen from their dwelling and horse arena while retaining views towards Mount Mangatautari by infilling gaps in the existing planting along their gully edge. However, such off-site mitigation can only occur with their agreement. In rebuttal, I addressed the comments of Mr. Morton, and I clarify that I had assessed the northern dwellings as visual receptors and had reviewed over 150 high-resolution images and used the 3D modelling to assess the effects. I also addressed Mr. Morton's alternative staging scenario, which I understand was considered by the applicant but discounted for various operational and technical reasons. I agree, however, that retaining more of the gully wall would be an effective mitigation where practical. And so, as you've seen, we've sort of come around a full loop in that. As previously noted, this has been revisited by the applicant in an attempt to find a mitigation solution that is both acceptable to the Powells and workable for the applicant. Mr. Morton provided photographs of another local quarry to illustrate likely effects, and I consider that the example is not a fair comparison. The Cambridge Quarry is not staged in the same way and accepts clean fill, giving it a very different appearance. The RS Sand Quarry will be more contained and in my view will look tidier due to its staging and the absence of the internal fill. Finally, I've recommended in my rebuttal evidence specific amendments to the proposed conditions to ensure that the rehabilitation of the site is well managed and consistent with the final landscape outcomes described in my evidence. These include detailed requirements for a final landform and rehabilitation plan and sequencing of rehabilitation before each stage progresses. To conclude, I remain of the view that the landscape natural character and visual effects of the proposal can be appropriately managed, subject to the implementation of the proposed mitigation. The effects will be acceptable and in some areas positive in the long term. I see no landscape related reason for the application to be declined. Thank you.
Thank you, Mr. Mansberg. So what you've given us is an assessment, and appreciate that this change that we've discussed has been given this morning is quite a substantial change. And I guess based on the evidence that you provided with us, I would suggest that perhaps, or conclude perhaps that it is a positive, but that's not my role. But what you've presented now to date is an assessment of the previous plan
application,
and you have not provided with us. So I'm just wondering, are you intending to provide us with an assessment of what is now proposed? Because it is quite a substantial change, particularly in the timing of when the effects will occur. So for example, I mean, you've said that you've assessed that effects will be greatest early on.
That's right.
Clearly, that's not the case. So I guess from our perspective of having sufficient information, I'm just a little concerned that you haven't actually assessed what is currently proposed.
No.
And I'm not
Sorry.
blaming, you know what I mean.
I accept that.
Yeah. So are you intending to?
I intend to address that right now. So without the gully wall being left in place, I think the effects on the Powell property get up to that moderate to high. With it in place, I think it drops right down to a low to moderate effect, and depending where you are in the property, because up in and around the arena and the house, there are snippet views out to stage 1, but you'll effectively be looking at an angle into the bund. If we have a little look at the proposal, and while it's not taken from the Powell property, there is a sight line, and apologies for the typo, that sort of shows when you look over the bund, there is an area of operation behind it which will be screened by, sorry, I'm calling the gully wall the bund for sake of convenience, that'll be screened from view, and all activity in that will just be hidden. Anything above, which includes the further back the quarry, the more of the operational face will be seen. There will still be a small component of that visible, but it's substantially reduced from the effect that would have occurred.
Just breaking in there, just to assist, I think it would be helpful for the process if Mr. Mensu provided a short supplementary statement with the chair's leave at the end of today. And I mean, it is from our perspective positive. There's no, we're trying to be helpful by putting it forward, but appreciate you need the information. So, I'm happy for Mr. Mensu to speak to it now, but equally, I think it'd be helpful if it was on the record. So, if we're able to have leave to file a short supplementary statement, I'd like him to speak to it now, but just to let you know that's coming too, if that's acceptable.
Well, let's carry on. I'll have some questions as well, just see where that gets to.
So had you finished that? Sorry.
So I was going to say, I think that from down in the gully, the change is much more dramatic because you're below now. you're going to have a low effect because you're not looking into the gully.
Yep.
At any point. And again, that's demonstrated in the sight line from the gully floor shown in the cross section.
Sure.
And to put this into sort of something slightly more visual, if you turn to the second to last page, that's Appendix 1K of my rebuttal evidence, you'll see a photo just looking in at the stage 1 face, where previously that cutting would have gone down to approximately 10 metres from the gully floor or above. Now it's only coming down 10 metres from the crest.
Yeah.
So that leaves about 21 metre off the wall, which provides, in my opinion, quite a substantial screen and mitigation for the long term.
Mm-hmm. Okay, so that's in. Hold on, let me get this right. So that's going to be in stage 1. So now that's still going to be removed by stage 4 or 5.
That'll be removed at the very end.
Near the end.
And when
yeah.
that opens up views through,
Yeah.
rather than seeing a cut, well, as it stands, you always see the cut face moving away from you
Yeah.
once you're above the crest line.
Yeah.
Under this scenario, as it drops down, it just exposes an already rehabilitated and repastured landscape beyond. So the quantum of change within the view becomes significantly less.
Thank you. That's very helpful. Excuse me. I just had a couple of other questions. It's I think one of the submitters brought up a question around why cultural landscape effects weren't assessed. Are you able to, or do you consider they were?
Cultural landscape effects are a tricky one from a landscape architectural perspective. My understanding of the trigger inside the district plan that it's a cultural landscape is it triggers to do with the awa and water management. From a landscape assessment perspective, I can only go so far in identifying whether there are any known cultural features that might trigger associative values, but I'm unable to actually speak to those values.
Okay, thank you.
Themselves. When I looked, I didn't find anything that would trigger my need to investigate further.
Okay, and is that standard for landscape architects not to be able to do a cultural landscape effects assessment?
Unless you're culturally immersed, it's very difficult actually. If you're not immersed in the culture, it's very hard. You can identify that there are values, but not how those values are affected.
Okay.
I certainly understand it. It's just that it can be difficult to report upon.
So would you expect it to be more part of a cultural impact assessment that it would be encompassed through that?
A cultural impact assessment would certainly identify up any cultural landscape values that might need to be looked at further.
Thank you. And I guess and I think perhaps the chair might have alluded to this in talking earlier on about sort of a lack of detail. And I was interested to see that you had quite detailed concept plans for a couple of locations in terms of rehabilitation, but not so for the site, and especially the staged approach. So sort of felt like, were you intending to produce more detailed rehabilitation plans, or is what we've got is what we've got?
The intention was really that the consent condition would trigger the requirement of a detailed rehabilitation plan that would then be certified through the council. So rather than putting all the sort of design work up front, it then becomes reactionary to whatever comes out of this process, and particularly as we've seen some recent changes in my access to Mr. Powell's property actually gave me the ability to look at it from a very different and make some amendments on how things could develop. So I find it's reasonably normal to say, put up the general concept for this is where the rehabilitation needs to occur, and the details of it, its implementation and maintenance and management become a part of the requirement of the mitigation management planning process is in response to a consent condition.
Okay.
And that's when all the detail is sorted out.
Okay, thank you. Sorry.
So just on that point, can you point us to the concept landscape plan for the site, please? And I presume you're meaning something other than just those staged plans showing where excavation happens and where it's rehabilitated.
Yeah, because it's an unusual one because most of it is either carried out through with the ecological restoration plan, which the ecologists are covering, or it is purely a screening and where it's the bunds. So there's not a lot of planting as such. It's really about managing the landform and the earthworks. So that comes down to a final pit design.
And just on that, I noticed there's a condition which requires rehabilitation to be completed prior to the next stage occurring. But the definition of completion of rehabilitation is that the site has been seeded. So there's no requirement for the establishment of the grass in this case, or I mean, what happens if it doesn't work? If it doesn't actually grow?
Well, I'd expect that to be covered off in the rehabilitation planning in some detail, but it would require reseeding and
yeah. So the condition says reseeding equals completion of rehabilitation, as opposed to grass actually growing, considering that most of this is going to go back to pasture.
Yeah.
So I guess the concern is around if the rehabilitation is aiming at providing stability of the landform so that you can safely move on to the next stage of excavation. And all you're relying on is the grass seed to be spread over the soil. How does that reflect, a stable environment, I guess, or stable landform?
I'm sure others will probably have commentary on the purposes of regrassing for stability reasons, but from the visual perspective, what we're trying to do is, in landscape perspective, is to finally shape something so it doesn't look like a series of cuts or too artificial. It blends into the surrounding natural landforms, and that there is the grass is re-established on it. So at the end of the day, that grassing has to serve three things: to provide a green backdrop just to help blend things in from a visual amenity perspective. It's got to provide some slope stability to stop things moving around and eroding. And it's got to be returned to a productive pastoral use at the end. And Mr. Hunt's probably better to talk about, that process of getting that final soil and pasture rehabilitation in place. But it's my understanding is when the quarry site gets handed back over to the farmer, he will want it to be a usefully regrassed and pastured. I'm not sure if that quite answers your question.
No, it does. So basically what you're saying, from what I understand what you're saying, is that that really your level of, not interest, but your area of expertise is in the visual aspect of the rehabilitation, as opposed to and it's someone else's job to make sure that rehabilitation is sufficient to enable movement to the next level of extraction.
In this case, because we're starting with a rural landscape
Mm.
and a pastoral environment, and we're going back, the actual mitigation is to help maintain existing rural character. We're going back to the same land use. And yes, while I have some expertise in that sort of restoration process in this particular application, more of that work has been done looking at it from an agrarian perspective rather than a landscape. What's important to me is that, one, we've got the screen bunding and we've got the mitigation planting on the bunding where that's needed, and also that the site is returned to pasture.
Okay, thank you.
Yeah, the ecological restoration just doubles in providing enhanced landscape
Yeah.
amenity, natural character,
Sure.
but it's there.
I guess I'm particularly interested in the stability side of
Yeah,
things, but
yeah.
yeah, no, I appreciate
no,
that. Thank you very much.
I won't attempt to answer
No,
on
that's
stability.
totally fine. That's totally fine. Thank you, Chair.
Just an initial question. You haven't been able to look at this landform from the stream environment until the other day. Can you just clarify why that is?
Just weren't provided access to.
But I'm talking about the stream environment below the main cliff line of the site, the lower parts of the site.
I've been down to the bottom of the site.
Okay.
Yeah, I've been.
Which I think you say is the key.
Yeah.
That was the key effect that you were concerned
The key
about.
effect is the effect on the power property from the other side of the river. So yes, no, I've been all over the site. I've visited the site on several occasions, up and down the bank, etc.
Okay.
But of course, you don't appreciate what you can only estimate as best you can through modelling what someone else has seen.
Okay, no, that's fine. What I've struggled with through reading all the evidence is to try and understand what the rehabilitation post extraction looks like. Is this image here, this three-dimensional image, essentially what the outcome is, which is this lowered terrace, effectively 30 metres below what it is now, with these the sides that have been, as you say, no longer cut faces, they're contoured.
They will be.
And is that
shaped.
is that what you mean by the site being successfully mitigated and rehabilitated so that it will integrate back into the landscape post-closure? Is that represents what you mean in that respect?
It's a model that sort of goes towards that. You know, a bit more rounding. What we're trying to do is emulate what nature does quite well, without too much soil erosion and loss, but to create a series of terraces. And if you look at the sort of the larger patterns through the Waikato of how streams and small gullies and rivers have developed, and you often get an oxbow that'll drop down a terrace, and then the stream will move off and cut down somewhere else. So the main driver is the Waikato awa, of course, and you see a series of terraces stepping down into that, and this is really associated with what's happening there. If we move further to the south, we'll see those terraces dropping down. So it's just trying to be consistent and not end up with a landform that looks artificial or out of place once it's put back into its final end use.
But what we see on the screen is essentially what you're saying. That's not an artificial outcome. That's completely consistent with the site and its surrounds.
Yep.
And in terms of landscaping, when you refer to that, you're referring to the ecological planting. Is that what you mean?
The ecological planting was not shown on that model.
No. But any reference in your evidence to replanting and revegetation is what is in, to the extent that it's shown, is in the ecological evidence.
Or on the buns, yes.
Or on the buns.
Or on the buns.
Okay. Right.
And everything else is back to pasture.
All right. And so just through the opening addresses, I've been trying to get to grips with what this change is. And sorry, it's probably taken me a little while. So instead of stage 1 taking out that front face, that doesn't happen now until stage 4, essentially, according to this plan.
Yep.
Yeah. And so how does...
sorry.
So in terms of what's required for the rehabilitation at, say, stage 2, what is that other than having a lowered floor? What actually happens at that point? So we haven't started stage 3. You're required to rehabilitate the land for stage 2 and post stage 1. What's actually happening there? Is it just putting topsoil down and regrassing it?
So
Is that
basically,
essentially it?
you can imagine it as you're taking the topsoil, etc., off the stage you're about to extract sand from and putting it onto the floor and re-establishing pasture on the area you've just finished extracting the resource from and having reshaped. And I think this is the key difference. That a lot of the plans are showing sort of reasonably faceted faces, but there will be a degree of rounding of lips and contours to make that final landform look slightly more natural.
And then you've done that and you've done stage 3, and then you're going to come back over all that land to part, I think, stage 4, which is shown on this plan, which previously was further up into the site.
Yes.
If I'm looking at the cross section further to the left, then you're coming back across the rehabilitated land to then take the gully wall out.
Yes, but you don't have to come across the land so much because you've more or less got that access. So it's probably easy if I point to it. Yeah. Because this bund here will be remaining, and there's the processing area. So effectively you can just take it and start working back across the top of it and back in. Mr. Klein might like to comment on the logistics.
And understand too, the other part of the stage 2 rehab is not only restoring the ground level, but also temporary grassing of that edge along there too, from a visual point of view, from the properties over. And then the extraction for it, I imagine, would come in behind it and put it in a road over the top of what has been previously rehabilitated, just like a farm. You'd have a race.
You're doing a road on a 1 to 3 slope.
Just down below it and then up.
But how do you get it?
Is as part of the stage, prior to the stage 4.
Let's go back to
This edge is over a bit, and then the final stage is taking that out. So be taking that out as you go.
Excuse me, Zoe, could we just go back one stage, or maybe to stage 2? That shows it slightly better.
The stage 2 has got the temporary grassing here, and then the stage 4, between 3 and 4. So then as part of the next stage, this comes out, so the road access would be along, because if you got about 1 in 10 up that hill, so to come up here to the plant area, the road access, minimise going across that rehabilitated land again.
Is there going to be, oh, sorry. So I was going to say, so for that final stage, when you take out the ridge line, what happens below in terms of bunding?
That final stage when that comes, because so that ridge is in here.
Yeah.
And that comes out, and then that gets rehabilitated in the same way here to back to.
No, but while you're excavating, you're going to have a bund in there to mitigate any potential, anything going down into the stream, because you're going to be, it's very high.
So do you mean
Just for erosion sediment control?
Yeah, sediment bund.
A sediment bund, yeah.
Yes. Which can be a lot smaller than the height that is here. That's set back, and if we cut in behind it, leaving the natural vegetation face as long as possible, and so that there's always that grassed area along the edge.
Because my understanding with the sediment erosion controls, or well, I'm not sure where, now I'm a little confused. So basically, you're going to have a bund behind where you're digging up on the ridge, is that right? Essentially, yes. How's that? Yeah, okay.
Land in place naturally and dig behind it and gradually remove it as we take the land down, so that the bund's effectively already naturally formed and will get lower as we dig down behind it. so
Okay.
that we're pulling material back away from the stream.
Okay, thanks.
I think the staging plans, well, obviously they need to be altered because of the change that's been proposed here. Seems that they need to be a little more definitive about, I don't know if this has been done before, I presume it has, and that there's examples somewhere, but it just seems to me that each stage there's quite a lot to be done. There's the rehabilitation and whatever landscaping is going to be done. There's provision for access to the next lot. There's the erosion sediment control measures that need to go in place for each one. It seems like there must be some sort of buffer between each stage. It can't be that the rehabilitation is just butting right up to the extraction for the next stage. So I'll leave that thought with you. Mr. Mansell, I wonder, Mr. Morton put forward some conditions which kind of aligned with what I've mentioned before in terms of what seemed to be missing in terms of a landscape plan. And I understand your preference is to develop that detail post any consent that might be granted, which isn't a usual approach in my experience. It's what's proposed so that we can consider it as to the extent that that is mitigation for whatever's proposed. However, my sense of it is that the landscaping that you're talking about is really just regrassing the exposed faces that are left.
Yeah, the landscape rehabilitation
Yes.
Is not a
and
fully developed planting plan.
Yes, and Mr. Morton picked up on the point that you made about retaining existing vegetation to the extent that you can.
Yes.
And I'm not sure if that's relative to whether they're worthy specimens or groups of trees or so forth, but he suggested a condition that requires a landscape plan to incorporate information to illustrate areas of vegetation to be restored and protected during the quarrying works. Is that something that you've given some thought to? Is that something we've got before us yet?
Yes, in my rebuttal,
You have covered that.
I concur with
Yes.
that
Okay.
recommendation.
Yeah.
And specifically, the area is around here.
Right, yes, because there's obviously, the quarry extraction goes up through part of that. There must be some need to treat that interface to some degree, I guess. Yeah.
Maintaining that lower vegetation, which will grow up and provide some partial screening from the Powell's property.
It did seem that there's an overlap here between what the ecologists are seeking to achieve through their plans, replanting areas, and what landscaping is seeking to do, particularly on the bunds and so forth. For example, the what do we call that? The gully that comes down from the sediment retention pond and the processing area, that seemed to be a key area that could be enhanced. It wasn't very clear what was going to be done with it, but equally from a landscape perspective, that may have some benefits as well. Are those areas that you've given some thought to?
Well, certainly
integrating those areas into the development.
Well, I suppose there's two approaches which I've experienced in the past. You've had separate ecological management and restoration and separate landscape restoration consent conditions and planning packages or integrated approach. And it might be that this is one of those situations where you can easily integrate the two functions. I think they're often separated out because the objective of each type of, I'll call them landscape implementation is different. And the ecologists will speak to the key objectives of the ecological management and the sort of the offset works that's involved with that. But that, apart from helping to enhance natural character, doesn't have a landscape visual amenity mitigation function as such. So the landscape mitigation function is really only tied up in a very small area, and that is the bunds and the screening. And of course, the bunds have a dual purpose for noise attenuation in some places as well.
That's all the questions. Obviously, the change in keeping that, what do you call it, the gully wall changes things from that earlier stage. You're satisfied that its removal at the end stage is acceptable. I think you're saying reduces the effects, I think it was to low moderate for the views from the power property. Once it is removed, because the land behind will have been rehabilitated.
Yes.
Is that essentially what you're saying to us?
Yes, I mean, I stand by my original assessment that the original application is workable. This is just a much better solution from the perspective of the 3 more affected properties to the north. Yeah.
Thank you.
Thank you, commissioners. I think we've got time for one. That was a 12 o'clock break or? Okay. Mr. Stewart, are you ready to go? Yep. Do you have hard copies of your speaking notes or? Okay. I might, do you have them emailed? Okay, can I just suggest we hand up one if we've got hard copies and then we'll get it emailed, Commissioner Phillips, to you over the break. Yeah, so again, just in fairness to this particular witness, he's going to speak to the change. It will have an effect from a erosion sediment control perspective, obviously, but again, like Mr. Mansberg, I think there would be some benefit in a short supplementary statement just addressing the differences if that commission is happy. Thank you. So this is mystery witness X who wasn't on my list. Apologies.
Mystery witness X has now got a statement that's had to change. So parts of this statement, I apologise now, I'll have to deviate from with respect to the proposed staging plan, and I'll just do that as I go through. If it's okay, I'll take 1.1, 1.2 and 1.3 as read. 1.4, the first couple of sentences of that are actually now the key change. The proposed amendment does obviously change the staging, and so updated erosion sediment control plans will need to be provided. The erosion sediment control methodology and the concept do not change, and that remains the same. The erosion sediment control methodology has been prepared in general accordance with the Waikato Regional Council guidelines, and in general it comprises a stabilised construction entrance, compound and load out areas, clean water diversion drains to direct off-site water away from the works area, progressive excavation and stabilisation, which has just been discussed. Sediment retention pond 1 to provide erosion control management during the establishment of the processing area, to be enlarged and converted to a water storage and reuse pond post-establishment. And that does not change with respect to the staging proposal. Dirty water bunds, I refer to them as perimeter bunds, to direct any site runoff to the retention or soakage areas. This will change slightly. Note several of the perimeter bunds will be constructed for dual purposes, screening bunds, and I had here containment bunding. Part F and G, this is where the main change occurs. Previously, under the erosion sediment control plans, we had a detailed stage 1, which benched us down, which was on that plan in front of you is the red stage benching down to create a platform by the Karapiro stream to build a soakage basin and a containment bund. This is the key change. We are now retaining
what I've picked up on has been called the gully wall. So we're retaining effectively a 20 to 30 metre containment bund along the Karapiro stream. And excavations for stages for the next lot of staging will occur on the landward side of that bund. The bund effectively is my new containment, or the new containment bund, and will provide for the soakage on the inside of that bund. So it actually takes away some of the complications of that staged approach to set up through stage one. In my opinion, it makes stage one significantly easy, more straightforward. All the proposed controls that we have in my erosion sediment control plan and my assessment did not assume any on-site soakage. However, there's been 2 lots of percolation tests done across 7 locations within the project, which confirm a very high soakage. And the high soakage is expected to accommodate rates of up to 100-year rainfall event. I just want to note that my previous calculations have worked on bunding and soakage to accommodate a 100-year event. Again, the proposed change here with the gully wall will create significantly higher volumes, and therefore our volumes to contain are now significantly higher. So I'm not anticipating any discharge from the quarry pit operations per se.
On that point, do you have a sense, I mean, this cross-section makes that point obvious.
Yeah.
Do you have a sense of the, in plan view, that gully face is retained around the full width of the site to the extent that it faces Karapiro? We've got a gully to one side, which was the overflow from the sediment retention pond. Is that retained?
I don't, sorry. No,
Okay.
sorry.
Yeah. So
Yeah, is that the intention?
And the question is,
I don't know. What's the plan?
That's right. Carry on, Mr. Stewart. We'll come back to that point if you like.
Yeah, that's a good question.
If you carry on, well, let's keep what the road, there's probably one of the things showing the extent of that.
So to sum up in terms of the regards to the soakage, what the soakage testing was showing was that in up to 100-year event, we should be getting general soakage straight to ground. So the actual runoff to controls, any controls that we did install would be minimal. That includes SRP1 up in the processing area. So the expectation that the controls and the soakage would minimise sediment yield from the proposal. The erosion sediment control methodology is bespoke because it's got such a high reliance on the soakage and the sand material that we are actually extracting. That bespoke nature would exceed the outcomes anticipated by the Waikato Regional Council guidelines that is currently best practice for earthwork sites within the Waikato region. 1.7, at paragraphs 5.7 to 5.12 in my evidence in chief, I suggest that conditions 17 and 18 of the proposed conditions, as recommended in the Waikato Regional Council section 42A report, could be deleted on the basis they do not reflect the activity, the effect and the activity as a point of principle, and do not reflect the Waikato Regional Council guidelines sediment control devices. Those were conditions relating to sediment discharge standards. And as I mentioned above, the pit itself now will be a fully contained soakage device, and I didn't think they added any value to the conditions. Paragraphs
5.13 and 5.14 of my evidence in chief, I identify inconsistencies with the conditions requiring the implementation in the proposal of erosion sediment control plans and the updating of those plans. I suppose these become more relevant now with the fact that we do need to update a set of the erosion sediment control drawings. And my comment there is that I just request that any potential or future conditions reflect the fact that it is a bespoke erosion sediment control plan, and the principles of the Waikato Regional Council guidelines will be implemented into that, but it can't be solely compliant with that. That wouldn't allow for the bespoke nature of the soakage and the methodology that we've proposed. Overall, I confirm that the proposed design is highly conservative and that the anticipated frequency of discharge, and with this potential change, I actually think the discharge from the quarry pit operations is unlikely. The erosion sediment control design seeks to avoid discharges in all but extreme events. SRP1 still might discharge when the suspended sediment load and turbidity of the Karapiro stream is expected to be of an elevated level due to the general catchment runoff. Consequently, I anticipate potential adverse effects from a sediment generation and a water quality effects on the proposed quarry operation on the Karapiro stream to be low. The question was asked before about how we would remove that gully. Just check what we're referring to as again. Gully wall at the end. In my opinion, it would be effectively what we'd proposed in stage 1 originally, where we would bench down, but in reverse, and you would be benching in from the landward side, and so there would always be a bund on the Karapiro side. So we'd excavate the gully wall from the quarry side of the gully wall and just stage that out heading towards the Karapiro stream. So you'd always effectively have a containment bund or a perimeter bund. But that's the sort of thing that would come through in updated erosion sediment control plans that would be submitted through to a council for approval. But that's how I would view that it would be.
That's happening at stage 4 though, and then you've got stage 5 to go. What happens?
That's a mistake on there. It says stage 4. Yeah. Yeah.
Thank you. Thank you, Mr. Stewart. I think you answered my question on that last response you had. So just for clarification, there won't be any dirty water bund in regards to when the excavation of that gully wall takes place. That will be the bund.
Yeah, correct. Yeah, right at the very end, there might be some, and this would be dealt with in 20 odd years with an updated set of erosion sediment control plans. But I would foresee right at the very end, we might need some controls right along the edges. That last, and we're talking a few meters now, is pulled out, and that would be a relatively quick operation. But we retain the gully walls, always retained as the bund, like you suggest. Yeah, and we'd be eating away from the inside of it. Yeah, retaining the face.
During the site visit, we looked at that area and the stream. Obviously, it's quite a low stream at the moment with Lake being in drought. Can you, I'm not sure, might be someone else, might be able to give us an appreciation of how high that stream goes during wet weather?
I can't answer that, sorry.
Mr. Powell might be a good person to ask as a landowner. Cool.
Thank you, Mr. Stewart. So just picking up on one of your points in relation to your points F and G, 1.4 F and G, relating to the area of the soakage basin and the bund, and talking about will be significantly greater volumes, which clearly means, in my opinion, significantly greater geotechnical risk. Which I'm not asking you to comment on, because you're not a geotechnical
I'm
person,
not.
but if you would like to offer.
Yeah.
But I mean, that's, just so I can get a proper picture of this. So excavation occurs, then there's some reinstatement of landform, but it's much lower than it's going to be, right? So when you've worked out your volume of your pit, have you taken into account that the landform around it, as you progress through the state, is also going to be lower, and so there's going to be presumably some retention of water over quite a large area,
So,
more than the pit, I guess is what I'm getting at,
yeah,
perhaps.
well, the original erosion sediment control plan, the drawings that we prepared were for stages 1 and 2. Because erosion sediment control, for want of a better term, is live, and we update as over the course of a project. And I suppose that's part of the reason why we seek conditions that allow for updates and reviews of the controls as we move on. So those original stage 1 and 2 allowed for the establishment of stage 1 and stage 2, and so those numbers that were calculated with respect to soakage and basins were covering off, getting us through those first 2 stages, which I can't quite recall how many years that was, but to get through to that point. Then there would have required to be an update of the erosion control plan, and where we moved the storage back to, and where we recalculated those storage areas to be. Each one of those would have moved further back from the Karapara stream. I haven't looked at this and we've thought through exactly how we would go about this, but we now have a gully wall, which is natural ground, and everything that we will be excavating is in behind it. Now, the soakage rates, and this will be discussed possibly further, are indicating that with large rain events, it just goes straight down. So there's highly likely that there's not ponding no matter how far back we go and how much deeper we go with the excavation. But that would be an ongoing monitoring requirement, and then we would be looking at that as we update erosion sediment control plans.
Okay.
Quite answer the question? I'm not sure.
Yeah, sort of. And then in terms of the location of this is just picking up from Commissioner Manukau's question around the potential for flooding. And I understand you have done it at a 100-year ARI, so I appreciate that.
Yeah.
But and that's for SRP 1, which is going to be down on the floodplain?
No.
Okay, so that's what I'm trying to get my head
so
around.
SRP 1's up in the processing area, which will be in place during the formation of that processing area, which will be a limited period of time. Yeah. The team will come in and form that area up. Yeah. So SRP 1 will be constructed straight away. They will then, and the appropriate funding to direct any potential water into SRP 1. Then it's effectively an earthworks team come in and create the processing area. And then SRP 1 gets converted and enlarged as a water reuse.
Recycling.
Yeah. What during SRP 1 has been designed in full compliance with the Waikato Regional Council guidelines. What I'm saying in my report is, with the soakage we get, it's highly unlikely that water will even flow to it. But we've designed it to be a fully compliant pond as if it's a clay site, and that you had 100% runoff during any normal rain event. But we're sitting on a sand quarry that is a small rain event, you'd just go straight to ground and we wouldn't get any runoff to the pond. Yep. That potentially though, during that process, if we had a significant event, will operate like a sediment. If water did discharge to that sediment retention pond may discharge, but the soakage rates are telling us that we're getting soakage pretty close to 100-year event type soakage. So it's unlikely. Given the fact though that when we're creating the processing yard, we are compacting and putting metal down.
I think, and this will answer Commissioner Manikar's point too. So there's a 10-metre height difference between stage 5, the lowest point of the quarry, and the stream.
Okay, because that was. I was
So
trying-
that may be, so that's a difference. So that may have been the Commissioner Manikar's question.
Yeah.
So that's the lowest point of stage 5.
Cool.
There will still be 10 metres height difference.
I was just trying to, I thought I picked up on the fact that I thought you said that there would be an SRP below stage 5. Because
No, so what
This
the
is a
original plan had
bund.
was a stage 1 to bund down to create an impoundment bund
Yeah.
and a soakage basin.
Yeah.
That, in my opinion, is now no longer needed because the gully wall creates that for you.
Okay.
That does
So
that
you're
whole
saying there's no
job.
sediment retention pond below the gully wall
No.
during stage 5?
No, well, I haven't prepared
I know,
that
and
plan
that
for you.
was my other
but,
question is that when would you expect to get, because it's very difficult for us to visualize all this
Yep.
without seeing updated drawings and
in my opinion,
anyway,
and-
so.
in my opinion, for the last stage, the stage 5, that we would be excavating that gully wall out from the quarry side out. So you'd always be retaining a bund on the edge. We would possibly have a bund on the upslope side of that gully wall. When I say the upslope slide, the quarry side, to prevent water coming into the excavated area, and would always have the bund, because we're excavating on the inside, would always have a natural face protecting the Karapiro stream. And then right near the end of those works, we would need to install some sediment control to take out that last little piece.
Yeah, that's what I'm
Yeah,
wondering, what
yeah.
that's going to look at and where it's going to be. And if it's going to be below it, is there a potential that it could actually be within the floodplain of the stream?
It would still be
and that
10 metres above
Yeah.
the stream.
Still be 10 metres above?
Yep.
Okay. Okay, that's very helpful, thank you. I just had a couple of minor questions. With this water recycling pond, now I know sand is pretty inert, but obviously the soil that's being excavated is going to contain a whole lot of things. Is there any potential for build-up of contaminants, considering that you are actually recycling?
Can I get you to talk to that?
It's the strength of processing.
Yeah.
Processing.
Yes. So through the processing, you're obviously going to have some wastewater that comes through the processing, goes into the recycling pond, gets taken back through the process. I'm just wondering if there's any potential for any contaminant buildup in the pond.
Not contaminants from a chemical point of view, but the process, having a wet process for washing sand and concrete sand is to take out any silt that's in there so that it's suitable for making concrete. And so in the ponds, there'll be silt build up over time, which then has to be dug out and removed from the pond with most likely an excavator.
And what happens with that?
That material likely be mixed in with the fill sand
Oh,
that
okay.
Arthur talked
So
about.
it'll go off-site.
So it can be adhesive, yes.
It would go off-site, okay, thanks. And one other question, Stuart, was in relation to this reliance on the soakage pit, and again, this relates somewhat to the contaminant issue. Given that both the groundwater, both perched and regional, drains to the Karapiro stream, and you're relying on soakage to the groundwater, is there any potential for contaminants or sediment or nutrients in particular? I guess are particular ones here because of the stage of it to get to the stream.
I'm not a groundwater expert. I would just say it's quarrying sand, and at that point, we're just simply removing sand, so there should be no contaminants in and around the quarry. But
I'm talking about in the pit.
Yeah, that's what I'm saying. In the pit, sorry, we're just simply excavating sand and removing.
Oh,
up
so
to
you're saying everything's taken off beforehand as you're excavating, and so you're just actually pouring the sand.
Yeah.
Okay.
Yeah.
Okay. Thank you. That's all I have. Cheers. Thanks.
It seems to me that the erosion sediment control plans that have gone through quite a process between yourself and the council, but they're effectively, this is for stages 1 and 2, no longer fit the proposal. That be correct?
They were for stages 1 and 2, correct, and now that's changed.
Yes.
Yeah. And it's
So At this stage, we don't have erosion sediment control plans that are relevant to the proposal at all. Picking up on your point that you were going to leave 3, 4 and 5 to a later time, that was going to be a question, and that at least we would have expected something conceptually, albeit that you're obviously changing that as time goes on and adapting to the conditions, but I would have anticipated something conceptual, at least at this stage, particularly with the requirement for soakage basins and so forth as you're moving back into the site. What you're telling us is that now with this revised proposal that the whole site becomes its own soakage basin effectively. So would it be possible to develop a new erosion sediment control plan for the site, for the proposal? Perhaps a stage 2 one that deals with stages 1 to 4 and one to deal with the loss of the gully face at the very end.
Yep.
And I'm wondering if we were looking at a consent in the near future, what do we have in front of us? We can't reference the current erosion sediment control plans because they're now superseded. Are the conditions that have been developed in that respect suitable to guide the development of those control plans from here? Because you did say that they're bespoke and therefore don't necessarily align with the relevant guidance documents. So we can't really rely on that in full.
No.
Or, sorry, we can't rely on those guidelines in full. It's not a case of just saying shall be developed in accordance with the technical guidance.
Correct. The erosion sediment control plan prepared is still relevant,
Right.
in the sense,
Okay.
in terms of the report, because it talks about how we will manage the site, soakage. The drawings then detailed exactly where that soakage would be for stage 1 and 2. So, and then the erosion sediment control plan report then went on to say that, you know, for stages 4, 5 and 6, would update the drawings and show where that would occur. The proposed conditions so far allow for all that. And my comment in my evidence in chief was that we just need to make sure that, particularly conditions, I think it was 3 and 4, reference the fact that it was in compliance with the Waikato guidelines and the erosion sediment control report, that it allows for that bespoke nature to be addressed through the updated plans as and when they needed to be prepared. So, and then the only other 2 conditions were with respect to sediment discharge tenant. But the conditions in itself, I still think are relevant.
Focus has to be on the conditions, doesn't it? Because, I mean, you say the plans are still relevant, but you've got soakage basins right where the cliff wall currently is. So it immediately becomes redundant.
Yeah, those drawings will need to be updated 100%.
Yeah. Okay. Yes. What you're saying is the text within the document is still applicable? Yeah. Okay, all right. With the sediment, the SRP, what do we call that? Pond, you've referred to as discharging when it needs to down an overland flow path, which I think is Gully E. What's the rain event that would cause that to need to run off? Well, the reason I ask is it's part of the ecological plan. So we would walk down there. I think it's shown as ephemeral on the plans. Yep. It's got a fair bit of seepage in there. We're obviously concerned about potential water quality effects from that. So it's just an understanding of at what point would one expect a flow through that.
So 2 things there. One is the SRP1 is operating as a sediment retention pond through the establishment of the processing area. Then it gets enlarged and is changed to a water reuse pond. So if I go back to I think the question about during the processing part where it is an SRP1, that has been sized in accordance with the guidelines for that catchment. If it was a clay site, it could operate in a relatively minor event. But the soakage testing is telling us that probably no water's going to get there. So I apologise, but I can't put a number on it.
I guess the end result of where I was heading with that is just to what extent your input would go into the ecological assessment as well, knowing that this is the runoff channel for both types of ponds in that area.
I'm expecting the processing plant to take, that earthworks need to take a couple of months, 3 months, 4 months to construct before it starts to be flipped over. And then the purpose of that pond is enlarged and changed, and it becomes a different beast.
The other aspect that I wasn't quite clear, it does come through in the conditions around the need for chemical treatment. I got the impression from your evidence you don't see a great need for chemical treatment, flocculation, whatever. I think they're both the same thing, aren't they?
Yeah.
Yes.
Yeah, it would only ever be needed if needed in sediment retention pond 1. For that, we need to have runoff to test the quality of the water. And I suppose, again, it's challenge on a normal earthwork site, you know you're going to get that, and you would be setting up to address that. But the challenge with this site is we're not actually expecting a lot of runoff, and so therefore, and then runoff from a sandy area often will drop out very quick in a pond anyway, so the water quality should be quite good and for a very short period of time. So I've said in my evidence that if we get runoff, we'll bench test for it and look at it straight away. Absolutely, but I just don't think it's going to be needed. Yeah.
Right. Thank you. I mean, the proposal's changed quite a bit. We're quite interested in how we're going to establish the soakage basins in that steep lower area of the cliff face. Didn't seem like a lot of area to work with. That's all gone, at least for those first stages. Ms. Matheson, I think asked all our questions that we had of Mr. Stewart, but I think there's what we haven't looked at, because this is so new, is how the condition structure would work to address the fact that this has changed. And my questions to him were around to what extent are the current erosion sediment control plans relevant? He's telling us that certainly the text still is, even if the plans are not. Yeah. And so we know that it was the intention to allow stages 3, 4, and 5 to be those plans to be developed at that time. Yeah. Also, I wasn't entirely on board with that, but yeah, I think we're looking at a more simplified arrangement in that respect. And part of that also is our earlier question just around understanding, perhaps there might be some 3D modelling or some plan that confirms to us how this will work as a complete basin, aside from what we just see in the cross section. So,
yeah. Yeah, no, thank you. And that's, I mean, your suggestion about the sort of 2 groups of plan. I mean, it's a given that the sediment control plans for stage 1 and 2, the plans need to be updated and they'll be provided. So that's a given. I think your suggestion of a conceptual for the latter stages is a helpful one, and with respect, and we'll certainly discuss that. And yes, understand the 3D modelling. Like I said, this was put forward in response to a genuine submitted concern that was verified by a landscape architect. It's designed to be helpful. All of the experts are comfortable with the proposal as it was originally. And so it's not being put forward, I guess, as a Hail Mary. It's being put forward as we're trying to be helpful, and constructive. So apologies that there's some material that we need to sort of do a bit of work on the fly and for putting the experts under that. But yeah, as I said, it is being put forward in an effort to try and be.
Look, I think it simplifies that side of it. Without being at all an expert in that area, but it seems conceptually to be simplified. But there's just some details that we need to understand around that. Yeah.
I saw your sandwiches arriving, so that might be.
All right. Well, in that case, we'll have to leave. So Thank you. That's a convenient point to pause anyway. So we'll take the lunch break and is 1 o'clock going to work if we just get started again at 1? Is that going to work for everyone in terms of getting some lunch? Is that okay? Yeah, okay, so we'll reconvene at 1. Thank you. just for erosion sediment control right through that stage relative to these plans. I think it's that it's cut off completely and ends up being an open face. And just whether there was any consideration of, well, I suppose the next question was, is there any consideration to leaving some of that cliff face for both erosion and sediment control and potentially a more permanent planted bund? So that's just a question for you. Now, you also asked me earlier for leave to allow Mr. Mansur to provide a supplementary statement, which is fine. We're just conscious of having that statement and others having a chance to refer to it. What was the timing that you were envisaging for that? And the reason I ask that is because we think there's a couple of other witnesses that probably would be assisted by similar statements, particularly if they haven't had a chance to consider this change. Mr. Stewart may want to provide something to address the matters raised this morning. And I think potentially, but we're not sure, geotechnical and hydrology. Possibly not. We're just not sure at this point. We think the other, and probably Mr. McDean as well from planning, if he hasn't already covered it in whatever he's going to present to us today. So I thought I'd just say we're open to receiving other statements if they haven't been able to consider the changes before presenting today. So they may find themselves in the same position as Mr. Stewart.
Yes, thank you. That's helpful. I have sent him home to start on his homework. So, but we will. I understand the issue, and probably easiest if I get back to you first thing in the morning as to timing, because we'll have a better handle on who's needed. I suspect, and we'll hear from Ms. Holbrook, I suspect there won't be a hydrogeological issue because there won't be any. It'll just be a bund, but she can confirm that. In terms of your earlier question, I've asked the ecologist specifically, and they'll speak to this, but there is going to be a 10-metre planted strip up above the stream, between the top of the stream and the edge of stage 5, so they'll speak to that. Yeah, as you say, Geotech might need some comments, so thank you. So if there's nothing else, so I've asked Mr. Hunt to present next. You should have a hard copy, and I've asked for that to be emailed through as well. So he's from Ag First, and I'll ask him to read a statement and then answer any questions. Thank you.
Yeah, good afternoon, Commissioner Blakey, Phillips and Manukau. Yeah, just reading through my summary statement. RS Sand, the applicant proposes to lease approximately 30 hectares of land at 77 Newcombe Road, Cambridge. The site is part of an operating dairy farm and is zoned rural in the Waipa District Plan. The applicant proposes to establish and operate a concrete sand mining quarry. This includes a processing area of approximately 3.9 hectares and a quarry that will be separated into 5 stages over approximately 25 years. I've reviewed the New Zealand Land Resource Inventory, the NZLRI National Database of Physical Land Resource Information for the site. The soils mapped at the property are classified under the NZLRI as LUC 2S3 and 7E30. The LUC 2 soils are on the flat pastoral land, with the LUC 7 soils to the north incorporating the gully. The LUC 2 soils qualify as highly productive land and are subject to the National Policy Statement for Highly Productive Land. The primary objective of the NPS HPL is highly productive land is protected for use in land-based primary production, both now and for future generations. The NPS HPL does recognise that there are certain situations where the development of HPL is appropriate, as outlined in clause 3.92J4. Others, through the evidence, will address the functional and operational need and the regional significance of the aggregate proposed to be extracted from this location. while my evidence will focus on the minimisation and mitigation of actual or cumulative loss of the availability of productive capacity of the HPL in the district. Clause 3.93A requires authorities to minimise or mitigate any actual or potential loss of the availability and productive capacity of the HPL in the district. This indicates that some loss of productive capacity of HPL is accepted with the focus on minimise the amount lost. The intention of 3.9, as I understand, is not an avoid if possible test. Throughout the stage process, the dairy farm will be operating across the effective area. This will include the stages that have either not been developed or those that have been quarried, completed and rehabilitated. This will minimise the temporary loss of HPL. The temporary nature of the extraction activity and the return of the land to productive use minimises any actual loss of potential cumulative loss of the availability and productive capacity of highly productive land in the district. The focus on mitigation is covered in the rehabilitation and reinstatement plan. With any soil disturbance and modification, there is a risk of negatively impacting the soil profile when stripping, stockpiling and restabilising landforms. Therefore, it is important to undertake some baseline soil monitoring and benchmarking. This will ensure that the restoration is completed to a standard where there will be no detrimental impact on the soil quality for land-based primary production, particularly the areas of HPL. A baseline assessment will ensure that the land is being reinstated to a similar standard as prior to the quarry operation and following best management practices. I'm confident and have seen through my experience that reinstatement to a similar standard can be achieved, and consider that this baseline assessment can be undertaken prior to commencing earthworks and that it should be required as a condition of the consent. And I think it's been included as a draft in the site rehabilitation and landscaping conditions. The key elements of the management plan include minimised soil compaction and damage, effective soil stripping, best practice topsoil storage, and reinstatement of soil profiles through the replacement of the subsoil and topsoil layers post-quarry completion. In addition, I've responded to evidence of Mr. Chisnell, specifically paragraphs 27 and 29. Paragraph 27 focuses on whether the soil reinstatement and rehabilitation can replicate the original natural state. And I guess the focus of my assessment has been to minimise and mitigate as the requirements of clause 3.9. Whilst I do not dispute that the soils will be altered and not authentically restored, I do disagree that the level of degradation will be more than minor if managed appropriately. It is common practice to reinstate land and soils following extensive earthworks and return these disturbed soils back to a productive state. The soil identified on the site is defined as having a mosaic of well-drained and imperfectly drained elephanic soils. While all efforts will be made to separate the topsoil layers from the subsoils, the unavoidable mixing that does occur during their removal and subsequent replace will, in my opinion, have minimal effect on their productive capacity. Within paragraph 29, Mr. Chisnell talks about the uniqueness of these soils within the Waipa district. Whilst these soils are HPL and considered high-class soils, they are not unique to the site and are very widespread throughout the Waipa district. The Waipa district contains 10,540.5 hectares of LUC2S3 soils. The proposed quarry will impact 0.21% of these soils within the district.
Can you remind me, I know I did see those formula stuff and, establishing doing the baseline conditions somewhere.
So that's that
I can assist. It's probably so, on the 28th of March, there was separately sent around, so it won't be on evidence, it'll be in a separate document. 28 March was the YPAR condition sent around with the evidence, with the changes proposed by the applicant. And yeah, so that's dated 28 March, and then the condition I think you're after is probably 19 from memory. 17, 18, 19, somewhere around there. Thanks.
It's just that I was looking. I was also looking at the regional council consents and proposed consents, and they have a rehabilitation position as well. So I was just trying to marry up the two of them, basically.
Yeah, well, they'll need to be consistent, so it probably makes sense having them on one or the other, I suspect.
Yes, yes, thank you.
Thank you, Mr. Hunt. So I was just wanting to know if you could, I'm not sure if you're the right appropriate person, but if you can give us some rehabilitation reinstatement examples of the same scale and scope of the proposal before us. If there's any others out there?
Yeah, well, it hasn't been completed, but I was involved in one, the Cockapoo Road in Waikato district. And that was for a clean fill, where the material was being taken from the site, filled with the clean fill, and the subsoil and topsoil layers were then proposed to be reconstructed back onto the top at the end of the game with some roughage and stuff to then form the similar contour patterns and return it back to the similar level of production. That was through the MPS HPL as well, through a 3.9 clause. So that is one that's currently accepted by Waikato District Council. In terms of operationally, we've been involved where there's been layover sites with NZTA. Those have been returned back to production land. Once they've been returned, ultimately NZTA takes a corridor. Then for quite some time, they lease them back to the surrounding farm. And once all of the area has been completed, that some of that land then gets on-sold back to the farms that they often took it from. And there's been a lot of rehabilitation of some of those layover sites where we've provided expert sort of scope to providing baseline or what is the surrounding topsoil layers and how that should be reinstated. And those are now part of the functioning dairy farms. We've got a client at the moment, Waihi Oceana Gold. That's a huge mine where the tailings site is stage contouring, and that is all being leased to neighbouring farms once it gets to the completion of each stage. And so we're managing the production and the capacity on what's happening on that and making sure it's and we're benchmarking against regional growth patterns to ensure that it is performing to how they'd, what they've signed up for in their consent.
Thanks for the answer to that question, because that was a particular question I had, and it was something that I think Mr. Whitaker raised in his 42A report about some evidence of those types of outcomes. And I guess what would be useful to us is to understand those where it's been done at a similar scale involving quite steep quarry faces as we have here. The NZTA laydown areas, I don't know how large they are. Is it perhaps the clean fill that is the closest?
Yeah, the clean fill would be a similar size and scope. Yeah.
Yes.
Again, for that one, we worked with, and I had to provide an assessment based on the final rehabilitation plan that even the slopes and stuff were not going to be any changing impacts. So the average slopes across the site. With this one here, I guess we've got a flat landform dropping down to another flat landform. Whilst there is going to be some benching, There is currently LUC 7 that's on the site that is currently benched. So essentially that is going to be migrated inland or away from the Karapari Gully. From what I believe from speaking with the geotech, that is going to be a 3-to-1 slope batter, which in its current state, I guess that gully face is a LUC 7. It's very limited in its capacity to be used for any productive use. When I visited the site there are some young stock that do graze it, but you can see that there's some erosion scarring, and it's not designed for heavy class. With that 3-to-1 slope batter, that, in my view, returns it back to a similar class slope as a LUC 4, which is still suitable for partial grazing.
Are you saying where the better slopes or the final better slopes will be, that is not LUC 2 land at the moment?
The current slope where the gully is?
No, I'm thinking, going back to the plan that we had earlier.
No, where it's going to be intended to be.
Sorry, isn't the point being that, yes, we're using it for this quarry area, but that land will be reinstated to productive land at the end?
Yes.
So that would include the quarry faces, the 3-to-1 or 1-to-3.
I think that will be able to be used in a low productive sense, but what I'm trying to draw comparison to is the current slope face is actually LUC 7. So what the concept will essentially do is move that LUC band from its current location, and that'll be moved to sort of, it probably won't be an LUC 7 slope, but it'll be a 4 or a 6 slope. Sorry, it's hard to explain.
Well, do you mean that the intent or the end result would be to expand the LUC 7, or maybe it drops or increases to 4, but bring that into the site where you currently have LUC 2?
Yes,
and I'm referring to this plan here, which is figure 5 of the AEE, I think.
So I guess
where I'm getting to is, are you replacing like for like is essentially the question.
That's right.
Yes.
Yes.
Okay.
So just to clarify, within the footprint of the activity site, there is both LUC 7 and both LUC 2. At the end of the rehabilitated stage, there will be a mix of LUC 2 and something that is lower productive potential. That'll be because of that slope batter, which has now been removed from the other side of the site.
In terms of, sort of been a bit of evolution and understanding the overall approach, and I initially thought there was sort of an attempt to reinstate landforms and so forth within the site. I think we have a better understanding of it now, that it's essentially this flat quarry floor, 3-to-1 slopes on either side, and that is the productive land that will eventually be created. Just to imagine that we start off with, if we were doing it all in one go, we have a quarry floor, then the 3-to-1 slopes. How do you recreate that into productive land? Is there something in your assessment that talks about how that's done in terms of re-establishing that soil profile? Is it just a matter of bringing in the topsoil that you stockpiled somewhere and just spreading it over that quarry floor? Is that how it works?
Yeah, so I'll just so in my initial assessment, I'm not sure if you've got it in front of you. There's section 6.3. And that goes into detail. And this is similar mitigations and processes that we've used for other sites for reinstatement back into a productive sort of land use. And by no means is this the end site rehabilitation plan, I guess I was asked to provide commentary on how we can do this and what we need to consider when getting to the end game of returning it back to productive capacity.
Right, and you would have heard the questions earlier arising from the change to the proposal so that cliff face, I've got the right term again, gully wall, sorry, the gully wall being retained right up until the end. Is that something that your plan or your text as to how it will be done accommodates that arrangement? So in other words, there's the creation of rehabilitated land through the project, and at the end, there's a need to bring that that area gets quarried right at the end. Is that something that you've given any thought to, or had a chance to give any thought to?
Yeah, I had a look at it, and I spoke to Christian, and just to get my head around, whether that bund was going to be removed or is it going to be more of a permanent feature, and the answer was that it was intended to be removed. So therefore, I'm talking about the end game here. So in that sense, that there will be essentially no change. There may be a loss, a temporary reduction in it, in the speed that some of those stages get returned back, but not over the course of the project.
It would seem you've got in your at your 6.3 the requirement for travel lanes be established in areas being rehabilitated to reduce the potential for soil compaction. So that must become a key factor there when you're coming back to then remove part of the site.
Yeah, I guess that kind of comes back to this is the intention of the rehabilitation plan is essentially to migrate from one cell to the next. And I guess once these are returned back to pasture, I assume that they're going to be closed off from construction. So, they're going to be, reinstated back, fenced back. There's certainly going to be tractors and stuff driving on them from, for farm machinery and whatnot. So the odd vehicle movement, I can't see, but yeah, we're just trying to remove and focus on sort of key areas rather than having big travel lanes on what's already been rehabilitated.
I think your evidence is just today talked about that the extraction area is temporary in some areas because you're still intending to allow farming over the stages that haven't been worked on or undertaken. Have we got that right? So that the quarrying is underway on a certain stage, but there's still farm activity going on the rest of the land.
Yeah.
Is that the intent?
That is my intent. It's a 30 hectare stage. So, if the initial quarry is going to be focused on sort of even removing that bund area, so it's going to probably be the first stage, it's going to be stepped out. There's no need in my mind to completely close off the whole site. They will be able to be isolated until we get to that point.
Sorry, I'm just going to have to clarify this again. You made a comment about that the bund will be removed. Which bund are we talking about here? I am getting quite confused now because I've written down here, Mr. Stewart.
Yeah,
Mr. Stewart said there will always be a bund on Karapiro Stream. So I'm a little confused about what's staying, what's going at this. Sorry, apologies, but
No,
it's pretty confusing.
Yeah. No, that's fine. So what? So I think, and Mr. Hunt can confirm, but we're talking about the gully wall. Is the galley? I think when you said the bund, did you mean?
Yeah, I meant
that's what I was understanding as well.
Yeah.
And I understood that part of that, the way that I think Mr. Stewart described it was that part of that would be retained to maybe 10 metres, I think he said, and it would be cut into. So there would always be, and that would form the bund.
Yeah.
So there'd always be a bund.
Yeah. So just sorry to be clear. So what so 10 metres off the top at the start. So there's a very large 30-metre odd now, 10 metres off the top as part of stage 1. That bund stays at about 20 metres, plus I guess about 10 metres to the stream. Stage 1 and 2 get done, 3 and 4 at 5, come back to that bund from the landward side to the gully wall, start removing the gully wall from the landward side so that all the sediment stays inside. And then my understanding of what Mr. Stewart said was at the very end, there might need to be some temporary diversion bunds or something when it's getting very nearly flat, right at the very end of removing that gully wall to stop any overland flow going into the stream at that stage. And then commissioners, you asked the question, well, is it possible to keep a small bund at the end, which is something that we can talk about? Is that so? The original end intention was flat right to the edge to reflect the current landform that you'll see goes flat to the edge of the cliff and then drops down. So the intention was to restore it to that.
Okay, but the cliff would only be 20 metres high? No.
10
10
metres.
metres
It'll still be
high.
10 metres above the stream.
Stream, yeah.
Yeah.
It'll still be, okay,
Yeah.
thank you.
Yeah.
Appreciate that.
No, it's fine.
Anything else, Mr.
One, it's really just the wording that you used in your evidence, but again at 1.7, you say the intention of 3.9 is not, as I understand it, an avoid if possible test. Can you just remind me where that wording comes from, the avoid if possible? Is that you referencing the clause itself, or is that you paraphrasing what you think it means, or might have been intended to mean?
Yeah, I guess there's more of a paraphrase. There's, and like we've spoken about, the guidance isn't, what we all refer to, but, the MPS HPL being a relatively new policy, there is the guidance document there, and within the guidance, it does talk about that through some of these 3.9 pathways that there will be acknowledgement that there will be a loss of HPL land. So I guess that's where I kind of get to that. It's not going to be a complete avoid.
You're saying that in the context of the exception rule that is being pursued here. So if you read 3.9, then generally it does very much feel like an avoid if possible requirement, and then it has these particular carve-outs, which we're discussing today.
There's some areas of 3.9 where it says, no loss of HPL, but through mineral extraction and aggregate extraction, the policy talks that, that it recognises the fact that there will be a requirement that by disturbing the soil that there may be some change and there may be some loss of HPL, and I guess it's acknowledging that. And that's what I'm trying to bring to the table.
Thank you. That was everything.
Thank you very much, Mr. Hunt. You're excused. He promises me he's not off to see the cricket, so that's okay. Right. Now, I thought we'd get both the ecologists, because if I get Dr. Baber or Mr. Kessels, they'll just blame the other one. So if it's okay, I'll just get them both up at once, and then you can ask them both questions. Thank you.
Ecology. How many paper copies do you have? I think the issue is just a matter of circulation to everybody that's here, that's all. So, okay, yeah. Is the electronic copy on its way, is it? Yep, great, okay. Sure.
So if it's okay with you, Mr. Chair, I'll suggest maybe they both, do you want them both to read out their summaries and then ask questions, or on the way, or up to you?
I think if they can take us through that, and it would make, in my mind, it would make sense if Dr. Baber goes first, just from the general, and then we'll go to the specific about the bats.
Great. Okay. Well, Dr. Baber, you're up first. If you could start, and then we'll get the electronic ones to imminently.
Right, so just reading out my summary statement of evidence. And I've also got two figures that seem to be very relevant from previous discussions, so they're available to pop up on the screen. So my evidence relates to terrestrial, wetland and aquatic ecological values, effects and approach to effects management in relation to the sand quarry. The subject site is 134 hectares, primarily consisting of grazed pasture. Gullies slope down toward the lower reaches of the Karapiro stream, which runs along the northern boundary. These gully systems feature exotic dominated vegetation and seepage wetlands, with gully basin wetlands located in the floodplain. And there are two significant natural areas, or SNAs, that are situated nearby. So based on desktop investigations and ecological surveys, the site includes or potentially includes habitat for several species classified as nationally threatened or at risk under the NZ threat classification system. And most notably, this includes the long-tailed bat, or pika. The Karapiro stream also supports a diverse range of fish species, 5 of which are at risk declining. So I use the ecological impact assessment guidelines to describe and assess the effects of the proposal. The habitat types with the highest ecological values are located outside the project footprint. Nevertheless, terrestrial and wetland habitat loss associated with project construction and operations has the potential to adversely affect ecological values, most importantly for long-tailed bats, copper skink and gully seepage wetlands. Potential effects include habitat loss, degradation, disturbance, and harm to fauna. So in essence, the proposal is expected to result in the permanent loss of 7.89 hectares of terrestrial and wetland habitat. And this loss comprises 4.09 hectares of pasture, it will be lost permanently, 2.22 hectares of exotic dominated scrub, 1.04 hectares of pine plantation forest, 0.37 hectares of mature exotic dominated forest, and 0.174 hectares of native dominated gully seepage wetland, of which 0.1 hectare was not detected, but is conservatively estimated to be present in an inaccessible gully, which was Gully A, in which there was exotic pine plantation. There will also be temporary loss of 19.6 hectares of pasture habitat arising from staged vegetation clearance and earthworks over 25 years. So, in essence, potential effects associated with the loss of vegetation and habitat types and associated species will be further avoided, minimised, or remedied through the development and implementation of the ecological management plan. That said, levels of effects after measures to avoid, minimise or remedy for the loss of each habitat type and assessed against the ecological impact assessment guideline criteria include high level of effects for pika or long-tailed bats, moderate level of effects for gully seepage wetland habitat, and moderate level of effects for copper skink if detected. So effects on all other ecological values were assessed as either low or very low. So these residual adverse effects are proposed to be addressed through habitat restoration and enhancement measures So having avoided, minimised or remedied effects to the greatest extent practicable, alternative effects management measures were developed to provide for enhancement of ecological values for the species and habitats affected by the proposal. So offset options were first considered but deemed not possible due to difficulties in quantifying impacts and benefits with sufficient precision, monitoring long-tailed bats and recreating like-for-like wetland habitat inclusive. Compensation requirements were then established in accordance with the NPS-IB and the NPS-FM to ensure the proposed habitat restoration and enhancement was as close to an offset as feasibly possible. A BCM was applied as a decision support tool, or I'm sorry, a biodiversity compensation model was applied as a decision support tool. The compensation proposes to address in the round these residual effects through approximately 14.38 hectares of habitat restoration and enhancement within terrestrial floodplain and gully habitat, all along the northern boundary of the site. So the proposed vegetation will firstly create additional habitat and ecological connectivity for bats and other forest fauna along approximately 2 kilometres of riparian margin, linking up 2 existing significant natural areas. Secondly, it will provide buffering and ecological connectivity for approximately 3.69 hectares of either gully basin, floodplain or seepage wetlands through the native revegetation of wetlands in their margins. And thirdly, it'll improve the extent of native dominated wetland through weed control and wetland revegetation and enrichment planting with species specific to the various wetland types. The restoration and enhancement also includes stock exclusion fencing, a 20-year weed control program and 25 years of main and pest control, and covenanting of all restoration and habitat enhancement areas, and the provision of bat roost boxes upon commencement of restoration and enhancement actions. So while the proposal acknowledges the loss of extent of natural inland wetlands, I consider the proposed restoration of wetlands nearby will yield more effective ecological outcomes than attempting to recreate gully seepage wetlands to achieve no net loss in their extent. Collectively, these proposed measures are expected to achieve net positive outcomes on biodiversity values in Indigenous wetlands within 10 years of their commencement and within 15 years for long-tailed bats. These biodiversity compensation actions are proposed to be managed, monitored and evaluated via the draft ecological management plan, which is to be certified by Waikato Regional Council and Waipara District Council. The EMP includes the implementation and maintenance approach, methodology and timing, and monitoring and reporting requirements. The evidence of Mr. McDean describes how the compensation program and therefore proposal will align with the relevant provisions of the NPS-IB and NPS-FM. And in conclusion, I consider the proposal will appropriately address potential adverse effects on ecological values to achieve net positive outcomes. Thank you.
Thank you, Dr. Weber. Just a question. We understand the Department of Conservation now has a level of comfort with the proposal. Could you take us through some of the key aspects of the proposal and the plan that satisfied the department's concerns?
The department was satisfied that the type and the quantum of ecological restoration proposed was likely to generate or expected to generate net positive outcomes because there's a lot proposed relative to the impacts on site, which ultimately sit within a an exotic dominated context, notwithstanding the fact that there are certain species there, particularly bats. So there were deemed to be effects on those bats, but that they would also benefit from a riparian corridors extending 2 kilometres between 2 existing significant natural areas. And also the plantings would also in the long term provide great foraging habitat for those bats, and in the longer term, potential roosting opportunities. So that was one in summary for bats, and broadly they were comfortable with that type and level of restoration, and that it was fit for purpose. And in terms of the other main concern initially was the loss of the seepage wetlands, because they're a threatened ecosystem type, but they felt that in exchange for the loss of 0.174 hectares of those wetlands, which were exotic dominated, so there was little to no native biodiversity in them, the benefits to 3.69 hectares of wetlands, including 0.3 hectares of wetland seepage wetlands, was likely to generate very good outcomes.
On the connectivity to the SNAs, just so I get my head around this, got one SNA to the north, woods, and then one sort of on the opposite side of the highway, to the south.
No, these SNAs are to the northwest and the northeast of the property, extending 2 kilometres.
I can find a map, so I can find one that I think it's in maybe in Kessel's doctor report.
Right.
Showing the SNA to the northwest.
Right.
But not, and even in the, I think in the text talks about one to the south, and I can find that one to the south. But it's on the other side of the motorway. I mean, it's even said which of your number it is.
Okay, well, we'll clarify that.
I haven't turned on my thing, sorry about that. Because my question was around, because one of the outcomes of this, the proposed compensation is greater riparian connectivity, and I couldn't see how you could do a riparian connection to something which was across the motorway to the south.
Right. No,
So
it's,
perhaps that would be a good point to clarify.
yes, we'll clarify
That would
that
be
and
great, yeah.
provide maps that illustrate that.
Yeah, okay. I spent a lot of time trying to get my head around the timing of the ecological outcomes. And I've read through the BCM report, so I'm reasonably comfortable with understanding how that works and this sort of thing. But is the timing based on the consent being granted? You know, when's the start point? Because I think the confusion was that there was reference to trees being 20, 25 years old or plantings.
Yes.
Whereas and therefore the outcome would be achieved in 10 or 15 years. And it's like that implies that the trees are planted 5 years before.
Yes, okay.
The outcomes could start to happen.
Yeah.
You know, the benefits could, so could you do
Yes,
that in a nice simple way?
It is tricky due to the staging.
Yeah.
So that some vegetation lost is lost early and other vegetation is lost 20 years down the track.
Yes.
So in summary, all our planting will be done in the first available planting season, following or assuming the proposed consent is granted, and then continue thereafter for the next 5 years.
Yeah.
So all the planting will be done within 5 years of, or in the 5 planting seasons
Okay,
following
so just to
consent.
clarify, is that the mitigation planting or the compensation planting? So
All
that's
planting.
everything.
Yes, but on your point, we would focus the mitigation planting first.
Okay.
And then we would work out from there, because that mitigation planting we want that to function as soon as possible.
Yes.
Whereas some of the more peripheral planting a long way from the project footprint, that's probably a lower on the priority list in terms of the timing. So in essence, all the planting is up front. So some of the planting conceptually will be 20 years old before some of the vegetation for which
See that now,
yeah. So it was but it is, the staging makes it quite tricky to
Yes, and I
get
guess
around.
that was a question too, because like I couldn't find a map anywhere which showed which vegetation was going to be lost.
Yes.
Because the only sort of map, you know, in the vegetation or various maps, it shows the staging, which of course now has changed. And so it was difficult to know what was going to be lost when, and
Right.
therefore when it's just that detail. And
detail,
just that
okay.
detail about when rehabilitation, I mean, I know you've got, this is your from the EMP, it's got the timing, so I understood all that.
Yes.
But over the course of the 25 years, when were things happening? And therefore, when would the outcomes actually start to occur, which is, came down to
Sure.
this. So it'd be quite useful to have a map of, because presumably you have mapped the vegetation and marked those areas that are going to be
Yes.
lost.
I'll go back and check what I should have in there. What I thought I had in there was a map showing the stages and the different, and you can see visually with the stage delineations, you can see where the habitat types are, and therefore can see what's getting taken out in each stage.
That'd be
But
quite
I'll
useful
just check.
to point us to that
Yes.
if it's there, that'd be
Absolutely.
fantastic. Yeah. And I guess, did you want to ask a question?
You mentioned at the outset there were some maps that you were going to refer to. You said that they were of particular relevance now.
Yes,
Are they the ones that are attached to the?
Yes, so they are the Appendix A in my evidence in chief, and probably the best one to go to is Figure A2, which I think that's it. Is that A2? That's A2. Yep, that one there.
I guess this is what I was actually referring to the students. I guess what that doesn't show is, it doesn't really tell me the detail about. Oh, and again, aren't I? What, how much vegetation is going to be lost at different stages, and therefore, how does that then relate to the restoration, mitigation planting, and the restoration planting?
Yes.
Whereas you're saying it's all going to be done in the first 5 years. So it's all going to be cleared in the first 5 years.
No,
No, and that's the point.
Yeah, so it'll be done up front.
Yeah.
There'll be some impacts early,
Yeah.
some impacts midpoint, some impacts later.
Yes.
Most of the impacts are in the mid-later stage from the vegetation point of view. So what I did to simplify it was just sort of take the midpoint that on average we're planting in the first 5 years, and on average some of the veg will be taken out in year 1 and some of it will be taken out in year 20, and working on the assumption that on average it's taken out at year 10, then the plantings done up front will be on average about 10 years old when the average impact occurs. So there'll be a bit of an advance.
What's an average impact? I mean,
average in terms of the amount.
I'm not, but the vegetation is only one aspect.
Yeah,
and
so-
you've got the relationship to the ecology. So in terms of working out when you're going to actually start to see outcomes, yes, for those areas that you clear early, it could be 20, 10, 15 years. But for those areas that occur late, especially if they're quite a substantial area of vegetation, and this is the thing, we don't have that information to know what is being cleared when in terms of areas, and therefore we can't work out. It could be that quite a lot of the outcomes won't happen until 20, 40 years, because as you've said, some of the vegetation may not be cleared until 20 years down the track. So,
we
I
have
guess in terms of ecological outcomes and
Yeah.
what this compensation package is proposing to achieve, working on averages is not really very helpful in terms of ecological outcomes.
It's built into the modelling because there's essentially the longer it takes to get the gains that you're aiming to achieve, the more the model pings you, the more work you have
Which
to
is my
do.
point.
Yes.
Because if you're working on averages,
Yes.
and in fact you've got some scenarios where it may not happen for 20 years down the track, or that the impacts won't stop until 20 years down the track because you're not taking out the vegetation until then.
Yeah, I'm just trying to clarify. Ultimately, the fact that the vegetation is impacted later in the piece is a benefit. So we plant early. And so by the time 10, 15 years down the track, we impact an area of vegetation, the offset compensation plantings are a lot older and the ecological outcomes closer to what we want than if the vegetation was all scorched earth at the very start and the plantings were only little. So I've worked that into the average and the time lag. And when we do that with the model and we explain how we've done that, I'm comfortable that given the quantum of what we're affecting, the type and the quality of what we're affecting, and the fact that our plantings are in advance of, and considerably so, a lot of what we're impacting, those three levers, we're in a really good space.
Okay, I just got to get my head around. I have
Yeah.
thank
So
you.
I think that
It's because I'm interested in the outcomes
absolutely.
and when those outcomes will occur.
Yeah.
relative
So the
to-
outcomes when we plant, if a lot of the impact's not till long down the line, then we're in a much better position. That's the key point than if we scorched earth early in the piece. Yep. So it's a good thing.
Okay, thank you. Did you want to ask a question?
I think the outcome and the procedure is quite clear in your mind. What I'm not clear about is how that then comes into the conditions and the timing, which at the moment, for example, in the WDC set of conditions, we don't know the timing until the ecological management and monitoring plan tells us the indicative timeframes and the identification of areas to be planted. All this detail is being left to these particular plans. Got this ecological monitoring, management and monitoring plan in the district council conditions. We've got an ecological management plan in the regional council conditions. One's required, this isn't your fault, I don't think you wrote these, but just part of the issue that we have in trying to work out what's required when. These plans don't need to be finalised for 40 days for the district council and 20 days for the regional council. There's a lot of inconsistency between the two sets of conditions. I don't know if you've turned your mind to them as to how you think they will assist you or in advising the consent holder how it's all to be implemented. And so there's that. There's also the starting point, which is the plan that we've put up there, A2, which is by any measure an extensive area of mitigation and enhancement. And we looked at the area yesterday, and I think it's an enormous task that you have set in terms of that rehabilitation of that area. But having said that, it's entirely unclear what is to be done. There's no species density list. There's no fencing plan. There's quite a lot of all that is there is that plan. Is that something that you would normally rely on at this stage?
Yes, it is, and I can speak to that and explain that. So so I'll start top down. So what we know is that we've got an area of impact, which is relatively small and exotic dominated, notwithstanding some values. We've got proportionally a massive area that we're proposing, 14.34 hectares, that we're proposing to turn from pasture or exotic dominated into native. And that will benefit the riparian area, benefit the wetlands, benefit the terrestrial. So that when we look at the highest level, the multiplier or the balance between impact and what we're proposing in terms of scale and type is we're in a good space. When we drop down from that, we've broken up what we're doing into 6 different areas, 4 different wetland types, and essentially terrestrial floodplain habitat and sloped terrestrial habitat. All of those 6 different areas have their own planting specifications to them. So we've identified what plants we're proposing to plant in those areas, and they're fit for purpose, and they're also done in accordance with the Waikato Regional Council various planting plans, and that's stated. So that has a lot of detail. So we're consistent with those. Then we also have two stages of planting. We have enrichment planting. Those are the things that you plant and they're pretty tolerant, and they're bulletproof, and they can handle sun. And we're proposing some more sensitive species to plant in a second phase, which is 5 years down the track when there's more protection around those species because they need it. And we're also illustrating conceptually or how much of what each species we want to plant, whether it is most common, few or least. Now, the reason we do that is often, and the reason we only usually go down to that level, is that often when we write these management plans, sometimes it's 5 years before they get certified if we're going through a hearing process, an environment court process. What's really important, and it gives a false sense of security, if we provide detailed planting specifications at this stage of the process, and then we go closer to the time, whether it's 5 years down the track or 2 years down the track, and we call up the nurseries and say, right, we need all these species and they need to be eco-sourced. Then the nursery comes back to us and goes, well, we can't get this because there's no seeds this year. We can't get that. Then all our plant specifications go out the window. That affects the number of plants we propose to plant, which usually goes in the plant specification list. It affects what we're planting, and it affects the meters and the spacing between plantings, because that can be influenced by what and where you do stuff. So we usually wait till when we get to that submitting a plan for certification, and we call up the nurseries so we know that when we put a plant in a planting plan that it can actually get planted. Otherwise, yeah, if that doesn't work, then everything changes, because you've got the numbers of plants of each species has to accommodate for the fact that you might not be able to source stuff. So this is a pretty consistent level of detail, and I do acknowledge, though, and it is valid, that the more detail we have is important for your assurance, but at the same time, there's a tension between providing a level of detail that we can't commit to.
I understand all that.
Okay.
There's no performance standard within these conditions. We've got your report, I think, that you used in consultation with Doc, talks about species, and also talks about pest control and so forth, which is another factor to be included. But there's nothing in there and nothing in the condition that tells us what is the outcome that we're striving for.
Okay.
That's the gap that we perceive.
Mm.
And then tying that to stages, as you say, there's a number of stages, and you're intending to do a lot of it now. It's not clear to us that was the case, that all the mitigation planting would be done in 5 years. So it's that sort of detail in the conditions.
Yeah.
Then, of course, we have two quite different conditions, which I don't think makes your job any easier in terms of meeting the regional council and district council requirements. And then we also have these further subset management plans. I've made a list of all the management plans that are referenced in the conditions or the evidence, not always both. And then you've got these vegetation management plans, avifauna management plans, lizard management plans, habitat restoration enhancement plan, animal pest control plans. None of that information is before us. It seems to be just put there as a placeholder at this point. I think that there may be a bat management plan that we'll hear about, but the rest of that information is just listed as a future management plan.
The detail, so there's, I think I've got 53 pages plus your bat management plan and the ecological management plan. So the detail is in that. Granted, there could be more detail that we'd add and update when we submit for certification. But it's more than what's in the consent conditions, certainly.
Yeah. Okay. All right. Well, look, the conditions as we see them are just, there's not certainty in there.
Okay.
Have a look at them. I think the key thing from your perspective is, as I said at the outset, you've got a clear idea of what's to be achieved and when.
Yeah.
And I think
Needs to come across.
we've heard that from you, but it's not clear that it's come across in the conditions.
No, valid. Thank you.
Mm. Yes, sorry. Yeah, Karen. Karen.
And just picking up on the monitoring plans, I acknowledge that there is some detail in the EMP around those different plans, but I guess what we're getting at is more detail would be appreciated. But also in the glossary of the EMP, I notice that there's reference to a biodiversity outcome monitoring plan, but there is no, it's not mentioned anywhere else in the document, and it's not in the conditions anywhere. And I'll let you think about that for a sec, because that leads on to my next question, which is about monitoring and performance.
Yes.
And I understand that the EMP, the implementation of that is to monitor performance of restoration measures on predicted ecological outcomes. I understand that is the purpose of the EMP. Would that be correct?
Yeah, the focus we have here is compliance monitoring to make sure what we say we're going to do.
That's my point.
Yeah.
But can you answer my question, which is not about compliance, it's about
outcome monitoring?
What is my understanding is that the purpose of the EMP is to monitor performance of restoration measures on predicted ecological outcomes, which I think may be up front in the EMP. And picking up on your point, the only thing that's in there is compliance monitoring, which is actually more about, have they planted all the plants they were going to plant that year? Have they done that bit of weed control they're going to do? So how do you know you're going to achieve you have achieved your outcomes if you're not monitoring for your ecological outcomes?
I can't speak to bats, but
aside from bats, because bats is actually being monitored.
Yeah.
It's a different story.
Yeah, I mean, when we're talking about, we don't have predicted gains for things like lizards and invertebrates and birds, because there's plenty of evidence to suggest that when you switch from an improved pasture setting to a native dominated tall forest, that those things will come back. So in terms of outcome monitoring, there's enough evidential base in the literature to illustrate that essentially if you build, they will come. That's not necessarily true when we're dealing with some other fauna that aren't necessarily at the site, where there's less certainty because the literature base is weak. And in those instances, that's where we might apply a certain type of outcome monitoring, because we need to verify that our stated outcomes are achieved, because there's not that much certainty around it. Or sorry, there's not as much certainty around it from the literature and other sources. So in this case, it's pretty straightforward, given how much we're doing and the type of what we're doing, that when you recreate a forest, that forest biodiversity will come back.
But a lot of the outcomes won't appear until after, well, certainly beyond consent. If this consent is granted for 35 years or even 25 years, the outcomes are not going to be achieved until beyond that point, based on what you were saying earlier around, it could be 20 years, 15 years. So I guess what I'm saying is that why wouldn't, I guess I'm struggling to just simply accept that build it and they will come is sufficient evidence of outcome being achieved. Whereas it's not uncommon to have a 5-yearly monitoring condition.
As long as the monitoring is done so that you can actually, the information is adequate and can be interpreted to the point that you can demonstrate that an outcome's been achieved. So in a site like this, for example, if we wanted to do bird monitoring, we need at least 200 metres apart between bird stations, but we're taking about 7 hectares of habitat, so we can only fit about 2 monitoring stations in the impact site. So then we can monitor from those 2 stations what our outcome is. We've got 2 kilometres of planting, so we can probably do 10 monitoring stations along the forest area that we're planting. And again, having bird counts at 2 stations at our impact site to monitor loss, and then the gain over time in our 10 bird monitoring stations in the 2 kilometres area. It's just, it doesn't provide any statistical validity or rigour. But what we do know is that when you plant, especially in early stages, things like Aprosma and Five Finger and a bunch of it, and flags, that tui and Kereru use them, and we can go to the literature for that. So monitoring is great when it's needed and there's a lack of evidential base, and when you can achieve the replication and the quality and the standard of statistical rigor that you need, and when that information is easy to link, it's a cause and effect. You can link those changes to what you're actually doing. Things like birds and stuff, they work at massive levels. So if the birds don't come back in the area that we're planting, we don't know if that's because in the surrounding landscape a whole bunch of forest has been shut down, or because our planting's not working. So we can't tie it to anything tangible.
I think it still comes back to what you're proposing as your outcomes.
Yeah.
Something to think about anyway.
Okay.
So just a question about your the post-translocation lizard monitoring trigger. Obviously, if that's even they occur, I just wanted clarity around that. It says it's based on translocating 50 or more individuals. I wasn't sure if that related to at one time over the course of the restoration. What was the time frame for that?
Over the course of the salvaging. So this will be.
But that's going to be ongoing, though, isn't it?
It will be ongoing, yes.
Yeah. So. Okay. Perhaps that just needs a little clarity in there.
Right. Yeah.
Then. So, and just to clarify, you're not proposing to do any wetland monitoring you're just proposing to
compliance
plant
monitoring.
them. Yeah, just compliance monitoring for everything.
So that we know that if plants die, we've got an infill planting program to make sure that we can achieve our performance standards.
Just a comment on the EMP, there seem to be, there's a few places where it refers to the site manager having responsibility. There's one place where it says environmental manager. Sometimes it refers to a herpetologist and an avifauna person, but not a project of. I think you're going to have a project. It's just a,
good
tidying
pickups,
up there about making sure consistency. There's an example of where, for one, I can't remember which one it is, specialist ecologist requiring certification for vegetation management, but not for avifauna management. Simple things like that, which are actually quite important, I think.
Okay,
if
thank you.
If this is going to be this comes back to the conditions really about.
Yes.
Yeah. Okay. Should be. Yeah, I mean, I think we heard earlier on today about this afternoon about that there's going to be I think you were actually saying there's 10-metre buffer, planted buffer, so up the slope. So I guess when we were on site, it's like, wow, that's pretty steep. I mean, what sort of things would you plant? Yeah, how effective is that going to be?
Good. So it'll be the same as it'll essentially be we've got in the restoration planting plan. We've got slope vegetation, which will be podocarp broadleaf forest, and we'll go for the more resilient of those species that would ultimately sit in a mature system. So those things that's really important, is those things that are likely to survive, because the environment's pretty harsh out there, especially with changes. But
there was talk about a 20-year weed control program, but I couldn't see that in the conditions or in the EMP.
Was it in condition 55 of the?
Is it? Okay, well, it may be in a version of conditions.
It's in one of the conditions.
Received relatively recently. Condition 55 of the regional council ones, I assume. 55. It was the 20 years that I thought was quite critical.
Yes, no, that's important. That's the intent. So we'll have to.
No, I knew that.
Good pickup. Yes.
No, that's cool. And in terms of the EMP, at section 2.13, it talks about this, what to do if you discover an at-risk or threatened flora or fauna species. So I was just wondering, this quite possibly could be one of the people on site, a staff member on site, not trained ecologists. So what training is being proposed to enable that identification?
Yeah, training's important to make sure that if there's anything.
I couldn't see that in the EMP anywhere, and I
Yeah.
couldn't see it in the operations plan.
Yep, that's a
plan
good
either.
pickup. Thank
So,
you. We'll
yeah,
add that
okay.
in.
Just one very minor thing. Under the felled log deployment in the AEE, it talks about 20 metres per hectare, but in the EMP it's got 10 metres per hectare, which obviously has functionally is quite different. I'm just wondering why there was a change. Is it just a typo?
It's an error and it should be 20.
20, okay. Thank you very much. That's me, thank you.
Yeah, I've just been sort of understood what you're saying now about the 2023 EMP, which is the draft document which sets out those sub-plans that you referred to me to earlier. So the 2025 document is more of addressing the doc requests for further information, and that's where you bring in the animal, the pest, animal, so forth. That's not in the draft EMP at this point, but that needs to come in by its own specific condition, and that's the part that I couldn't find in the condition structure at the moment.
Yes, so from here, we've got the draft EMP that was written a couple of years ago. There's been updates to that via that memo, and there'll be further updates before we submit for certification around calling the nurseries up and getting some clarity. So sort of like got a few steps to go before we submit for certification.
I suppose what appears to me, looking at it from anew and trying to understand what the outcome will be, which area-wise is extensive, and as I said before, that's acknowledged. It's whether that plan would say, and picking up on the point that you raised, the uncertainties as to what's available at a certain time, that plan might say for this particular category of replanting, seepage wetland or gully, stream side riparian, whatever it might be, that it might include an indication of what the options might be in broad terms. That would have given me a better sense of what you had in mind as to what's been achieved. You've got the species listed in the EMP, but I just don't know at what density.
Yeah, densities are, because I was looking through, density is a key one that we didn't have in the answer. We just, in the plans that we're working in accordance with, it's 1.5 metres per spacings with the plants in terrestrial, and it's 0.25 to 0.5 in wetlands. That you need to plant them in the wetlands a lot denser. So that's a key, that's a really good point. And that's a key piece of detail that isn't in here that we can put in.
Is it a challenging, I mean, all these projects are challenging. Is this a particularly challenging stream side type environment to rehabilitate in the way that you're proposing? I mean, we saw a lot of existing quite intact weeds through there. It's obviously a lot of work just to get to the point where you could actually undertake planting. It's not unusual in your experience.
I'll leave Jerry to add to my comments, but they're all quite hard because you never know what you're going to get in terms of environmental conditions, droughts or extreme flooding. What was interesting is when you saw on site, you might have seen some areas that were fenced off, like really close to the stream on the other side, and you did get a really dense Carex geminata, or the sort of the rushes there. So I suspect that when we take the stock out, those will come back close to the stream bank, and they're very flood tolerant because they anchor really well. And then slightly further back from that, we'll do the typical plantings, but it's most of the planting along that floodplain are non-hydric soils, which tells us how often there's flooding. If they're flooding all the time and there's just standing water sitting there most of the time, the non-hydric will turn to hydric soils. There's some instances along that floodplain where that occurs, where the wetlands are, and certainly in that gully basin wetland, it's clear that there's overtopping and periodic connectivity of that big gully basin wetland with the stream because of the fish that you're getting in there that they've, you know, a lot of exotic fish that have come from the stream, and then in the overtopping, they stay in that area. And that was one thing we were really interested in, because there was a question around whether mudfish were in that habitat, but mudfish don't like, you'll know, too much connectivity with streams, because the fish predators can take them out. So, yeah.
I'm surprised we haven't asked this question yet, was in relation to the changes that we were introduced to this morning in terms of the staging. Does that affect your assessment in any way?
No, the only thing is we'll need to make sure when we do our mitigation plantings that that the plantings sit back from the drip line, so that when at the very end of the project, we need to scrape that last bun back, we're not taking out root structure. So that's the only thing. Is there anything you wanted to add on that?
No, I think in terms of the difficulty of planting here, I've got a fair bit of experience in planting in the Waikato, and we would be looking for fairly tolerant species to get on top of the weeds pretty quickly. So I'd be looking at a strong component of flax, harakeke and cabbage tree. And then up on those dry slopes, totara and kānuka would be dominant for me. And keeping it reasonably simple in terms of the planting plan, at a high density planting. And then I'm confident I'll get on top of it.
Good, thank you. That looks like a moment to hand over to you, Mr. Kessels.
Kia ora, thank you, Commissioners. I hope you've got my summary evidence in front of you now. For those of you who don't know, my name is Jerry Kessels, and I've got 30 years experience as an ecologist. In the last 15 years or so, I've become more interested in bats, so that's my specialty these days. For some projects, I'm also working with Stevenson. It's not written here, but I thought it might be useful on 3 of their current quarries for bat monitoring, on 3 current Stevenson's quarries. And I've been involved in a number of roading and mining projects around the country at a review level, right down to the implementation of the conditions over those 30 years. So this summary is a summary of my primary evidence, which addresses bat ecological values, effects and approaches to effects management as it relates to the proposed sand quarry. It also provides supporting evidence for Dr. Baber's statement. Based on my desktop investigations and ecological surveys, the site includes or potentially includes habitat for peka peka, and I undertook 2 surveys. And in the 2019-2020 survey, we had a total of 159 bat passes over 21 monitoring nights, with an average of 0.9 bat passes per functional ABM, and an ABM is a bat detector per night. In the May-June 2020 survey, we had, and this is outside the deemed to be appropriate time of surveying, but we had an incredible total of 4,709 bat passes over 41 nights, and that averaged 14.4 bat passes per functional bat detector per night. And for the context, the Newcombe Road site represents a mid to lower end of the typical bat pass detection rates, which I would expect to see in other similar sites in the Waipa district. Just if I can just pause there and just say that throughout the Waipa district, long-tailed bats are widely distributed, and they prefer a wide variety of exotic and indigenous habitats, and they use gullies and rivers and streams and wetlands for foraging and habitat, and they can use shelter belts and exotic trees for roosting and commuting, or queues for commuting around the landscape. The proposal is expected to result in the permanent loss of about 7.9 hectares of terrestrial and wetland vegetation communities, which provides commuting, foraging and potential roosting habitat for long-tailed bats. There will also be a temporary loss of 19.63 hectares of pasture from the stages, clearance and earthworks over the 25 years. And potential effects associated with the loss of these bat habitat types will be avoided, minimised or remedied through implementation of a range of measures, including application of Department of Conservation best practice, pre-felling protocols to any potential bat roost trees proposed to be removed, development of measures to reduce effects of artificial lighting, dust control measures, installation of artificial bat roost boxes and implementation of pre-felling roost checks, which I've repeated. Temporary loss of habitat for bats will be addressed through some 40 hectares of habitat restoration and enhancement measures within the terrestrial floodplain and gully habitat. And this proposed restoration will create additional habitat and ecological connectivity for bats and other native fauna along approximately 2 kilometres of riparian margin and provide high quality foraging and roosting habitat for bats through enhancement and recreation of gully basin, floodplain and seepage wetlands, including targeted native revegetation of wetlands in their margins with buffers along the quarry edge next to the high valley habitat and cavity bearing native trees which will provide roosting habitat. In addition, a 25-year targeted animal pest control program over the site and immediately around it will reduce predation of bats which may be roosting in the locality. Collectively, these proposed measures are expected to achieve a net positive outcome on bats within 15 years of their commencement for long-tailed bats. These biodiversity compensation actions will be managed, monitored and evaluated through the EMP and BMP, the Bat Management Plan. The Bat Management Plan includes the details of how measures such as artificial lighting standards, native revegetation, animal pest control and the installation of bat roost boxes will be implemented, maintained and monitored over the life of the mining operation. The evidence of Mr McDean describes how the compensation program and therefore proposal align with the relevant provisions of the National Policy Statement, Indigenous Biodiversity and the NPS Freshwater Management. I conclude that the proposal will adequately address potential adverse effects on bats and the utilisation of available habitat within and adjacent to the quarry site to achieve net positive outcomes. And I just attached on the back of my little bit of evidence the sites where we surveyed for bats and our initial mapping of bat habitat, potential important bat habitat within the quarry and its site and the infrastructure area. And I just also quickly, which I will do a cut out and email through Mr McDean, I just put up the SNA layer I have for Waipa District Council. So I can send that through to you if you like. And it shows that there's SNAs on the Karapiro stream above and below the quarry site. So this restoration won't link those two SNAs directly, but it'll add to the overall linkage values and create stepping stone habitat as well.
So it is that one on the southern side of
yes,
the
and then
that I thought, because I thought it was actually in your report that I saw that.
Yeah, that's right. But I think in my map I didn't show all of the wider SNAs in that. So there's a SNA on the Karapiro stream above and below the site, which is, I think I might have mentioned in my report, we were saying where the linkages could occur.
Yeah. Okay.
Thank you, Ms. Kessels. Under the latest proposal, the gully wall adjacent to Karapiro Stream is going to remain in place until stage 5. Just wondering, in your opinion, what effects, if any, positive, negative, would that have on the bat population, considering that's going to remain in place while quarrying is taking place?
Yes, I did ponder that one yesterday, and I think it's potentially got advantages to be there because it will create some shielding between the mining activities and that what I'm assuming to be a major commuting route through the Karapiro stream for the bats, so they'll be flying through there, but because that abundance so high, it'll be hopefully shielding. Not that I think activities will be occurring at night in the quarry anyway, but it will be providing a navigation cue for those animals. And also, if, as Dr. Baber said, if we can get that planting in there early, within 5 years, that'll further consolidate that corridor through there. So I think, if anything, it's probably beneficial.
Because it's currently there already.
Yes.
So I'm assuming it is playing a navigational aid to the bats.
Yes, that's right. Because it's as you've been on site, sir, you would have seen the gully is quite steep and that really steep bank. So I'm sure the bats are using that as a navigational cue, and then they'll be slipping into those side gullies to look for insects, foraging for insects at night. So they'll be using that bank through their acoustic detection to navigate through that landscape in the dark.
Okay, first question, is it 20 or 25 years of weed restoration, whatever you call it, weed management? Because I think you said, you said 2025 or animal pest program, so that's separate.
That's right.
So it's 25 years for animals and 20 for weed. Is
Yes,
that right?
that's correct.
As opposed
That's
to just
correct.
a 25-year pest program.
Yes, so that was negotiated with the Department of Conservation
Okay,
staff
that's
that we
cool.
undertake
Alright, cool.
animal pest control for the life of the quarry, more or less.
Okay, thank you. Just this, and this may be a question for either of you actually. When we were on site yesterday, we went down into Gully E a little bit, and we could clearly see some seepages. Ironically, it was actually fenced off, but then clearly cattle get in there. And I was just wondering, just thinking about that, is there any restoration? I mean, it's not marked on the map, but is there any plans for anything to be done to that particular gully in terms of restoration, enhancement, or just because of its connection down to?
No, it would.
No.
Yes, it is. It does have a regular flow, that gully, and it is currently being accessed by stock, but it isn't part of the restoration plan.
Well, it's actually here it's indicated as being an ephemeral stream.
Yeah. Did it have flow when you were there?
Well, there was not in the stream as such, but we didn't go down very far. But there was definitely seepage coming out of the hill. So, so it just sort of struck us that could be quite a reasonable area for a bit of restoration. But I don't know. Yeah. Oh, that's right. And that was the other reason, is because it's actually in the bat surveys it came out as being high value.
That's right.
So that's why. And it's already fenced off. That's why we're sort of interested to know if there was anything. And the other thing too is that on the current restoration and habitat enhancement, there is actually a proposal for mitigation planting along it, although it looks like part of phase was stage 5, might cut into it. So it's sort of, it's just that detail, I guess, is ambiguous if you're going to have mitigation planting, but you're actually going to be cutting into it as well. So some.
Yes, well, that planting on the top of that gully you're referring to.
Yeah.
Yeah, that was. Correct me if I'm wrong, Dr. Baber, but that was a bit more shielding that the Department of Conservation were keen to be planted. So we put that planting on top of that steep gully there. Yes, and it's envisaged it will be out of the quarry footprint. It will be on the edge, but we'll have it set back so the drip line of the canopy is not hitting the quarry edge.
So I guess, again, I'm not sure when that was planning to go in, because of course that was meant, I'm looking at one of the maps you had up. Oh, I think Dr. Baby had up of that was meant to go all the way around I interpret as being around the outside of stage 1. So I guess that's something that you will need to think about in terms of the staging of the revegetation, the mitigation planting in particular, because this is specifically about the mitigation planting.
Yes.
As I interpret that map. And
yes.
What it's going to.
And Yeah, I mean, that is an ephemeral strain that in that gully E. It doesn't
Okay.
make its way
Getting
to,
contrasting.
yeah. In terms of that area being an opportunity, because there are seepage wetlands in there for restoration, we looked at it and we decided that there would be better, would optimize ecological benefits if we went across the Karapiro stream, because you get a whole sequence and diversity of different wetland types, plus the big stream, which is more important, plus that's better for connectivity for bats because that's the main highway. So on balance, it seemed to better to focus along the stream and again to connect those two SNAs on the other side of the Karapiro, on the northern side of the Karapiro stream.
Thank you. So just back to Mr. or Dr.
You can call me Mr. Kessels.
Jerry. The bat roost boxes that you're proposing as mitigation.
Yes.
What would be the trigger for installing them, and how long would they be in place for?
Well, on granting of consent, we would look at starting to install them around those gullies.
Okay.
And the idea of them is it's going to take 25 years for exotic trees to even start having cavity bearing properties. Oh, sorry, native trees.
Yeah.
So those bat roost boxes, which we know work from our work in Hamilton, will just bridge the gap in terms of that time lag. Yeah. And then, as the department staff pointed out, we'll put some aluminium bands around the top and bottom of them to stop the possums and cats getting into them.
Yeah. Okay. Yeah. And then in your report, you talk about you actually have a lighting plan,
Yes.
which clearly needs to be integrated into the operations of, and so it's not at the moment. And I'm just wondering if you felt that it should be there as a condition in terms of that lighting plan that you propose, rather than being lost in a bat management plan, which is lost in an EMP, which perhaps it should actually be taken out of the EMP and put as a separate bat management plan.
Yes, I think there needs to be a good link between those requirements, a number of those requirements, the BMP and the operation plan.
Yeah, just because it is an
And
operation plan. Yeah.
I mean, if I can say, my experience is that with Stevenson's and Fulton Hogan is that they take those plans quite seriously and they will push them into the operation plans, and the quarry manager will ensure through their regulatory team will ensure they're implemented. And I also like to just mention that the training of staff. So when I was recently at the Clevedon Quarry doing some pre-felling bat roost checks there up at Papakura, and there was a whole section in our health and safety induction on what types of animals, native fauna were there and what to do should you find them. So I think that's a really good point, and I think there needs to be a strong linkage between the operational plan and these fauna protection plans to ensure that these measures to address minimising harm on fauna and reducing adverse effects are integrated into the day-to-day operations on the ground.
Yeah, okay. Yeah, I mean, especially given that the EMP actually identifies the site manager as having overall responsibility for the implementation of the EMP.
Yes.
So there really does need to be an implementation in the operations. Okay, last question, very, very minor. I assume in your section 8 of paragraph 4 of your bat management plan, you mentioned reporting to Waipa District Council, but not to Waikato Regional Council, but I assume that's just an oversight.
Yeah, well, that's a planning matter. I'm not quite
Is it?
sure.
Oh, okay.
Which council will be dealing with the bats and which
okay, well, maybe the planners can answer that.
Yeah.
I guess I'd kind of assumed that it would go to both, but
yeah.
It's in both their conditions. Okay. All right. Okay. Thank you.
Thank you.
Anything else for? One question, Skissels, you've got in the table in your evidence in chief, avoidance of vegetation clearance during bat breeding season. I don't know what is that season, and are you concerned enough about that it should be a specific condition? Because it's not at present.
I guess I could have worded that more carefully. So I was saying as a first step, you would avoid clearance, but we will be clearing, or the applicant will be clearing potential bat risk trees on site, and that can be done, only be done under the DOC protocols between October and April in any given year. And so that, I guess that's what I was trying to say, is that we need to manage felling those trees that time of year. And the reason is that bats go into semi-hibernation in the winter. So you've got more risk of catching a bat in an occupied tree in the winter because they'll sleep over for many nights. So, yeah.
So can I just be clear, is that any vegetation or is it any trees that?
It's any potential roost tree.
Right, well, that's quite narrow, that's a bit narrower than
Yes,
vegetation.
yeah.
It's saying as a first step you avoid it, but in the absence of that, what's the next step?
You invoke the bat pre-felling protocol checks on potential roost trees.
And that will be part of the bat management plan. I think we've got a draft attached to the EMP.
That's right, and it's actually tagged as a specific item in the condition set as they now, from memory.
Thank you.
Thank you, Commissioner.
Sorry, can I just ask one more question? I think in your bat management plan, you talk about translocating trees.
Yeah, that is another option.
How successful is it? Has been based on your experience.
We haven't done it often,
Mm.
but I can't give you categorically any known cases where it has been tried.
Yeah.
But it actually should be just as or even more successful than artificial bat roosts. It's just an option there that you can translocate a tree, and with those cavity features already intact, you don't have to wait for it for 25 years to grow.
Yeah, sure. Thank you. That was just a curious question.
Yes, yes, that's
Sounds expensive.
yes.
Okay, if the ecologists are free to go, we'll go to geotech next, and then thinking hydrogeology would probably make sense if that's suitable.
You're going to go into the same.
Mic is on.
Mr. Matheson, I see we've got Mr. Hegley there, and
Sorry, what's that?
We've got Mr. Hegley sitting there. I'm not sure we have many questions for him. We'd be happy if you want to bring him up first, and it might allow him to
Yep, no,
escape
he'll be
quickly.
pleased to escape.
Yeah.
Thank you, Mr. Hickley. Are you there? Thank you very much, sir.
Can I just check that you guys have got all the summary statements sent through to you now? You should have had a bulk email from Tracy.
Were the Ms. Holbrook's evidence, Andrew Curtis and Michael Hall, and yours. I think that would be the end of it.
Yeah, okay. You should have Mr. Higley's already, I think.
Yeah, I think we've got him.
Right. Welcome, Mr. Higley. Have you got a summary statement as well? Oh, okay, sorry, missed that. No, I'll find it. Yeah, okay. Just you hand me the physical copy if you can. Yeah. Oh, yeah, sorry, found it. Yeah. Mr. Higley? Is that based on a particular decibel descriptor, if I've used the right terminology? Is that over 15 minutes or 16? Just the only other question I had was the bunds. Obviously, we've got the one along that western perimeter that you've talked about here. That's the only one that's there for noise screening, I believe. The rest are landscaping and other perimeter bund functions. Yes. Yes. And the 2.5 meters that it's specified to, that's the height that it needs to be to achieve the minimum height that it needs to achieve what you've assessed. Yep. Okay.
I don't think your mic is on.
Apologies.
Sorry, yeah, I have one. So sort of following on from that, I was also going to ask you a question about the noise bund. I think it was in your evidence, or perhaps your rebuttal. Anyway, you talked about the fact that the bund doesn't need to be there all of the time, and doesn't have to be, but that it, yeah. So I guess the question is, when is the latest it could be put in? You know, like what's the shortest amount of time that it would need to be there to comply with the the noise limits? And apologies if you have actually found
It's-
evidence somewhere, because
It's in figure 2 of my evidence, and I'm not sure of the time, but it's whenever the plant's operating within 100 metres of the notional boundary of that house to the west, or 41 Newcomb Road.
yeah, I've got that. So yeah, I guess I was interested in, what sort of time frame that would be, which is obviously, that's related to a stage, right?
Yes,
Yeah, so at what stage would that be occurring now, given the changes?
I'm not sure
Not sure.
how long it would take to do that. That would probably be more an operational question.
Yeah. So I guess, because my question is, because that is one of the concerns, and I think the Section 42 officer picked up on that, although that does address the concerns around noise, potentially as an amenity effect. We were at the site, you can see the house very clearly, to have this 2.5 metre high bund going for what sort of distance? Quite some distance.
It's almost the full length of that western boundary.
So to have that for 25 years if that can be reduced, that would obviously be of benefit to the submitter, potentially. So,
Yeah, I think, Commissioner, that's a fair question. I mean, again, it would be helpful to see what, and I think Mr. Whitaker suggested that the millers turn up. I mean, we're happy to, see what their preference is in terms of, do they want it there for shorter or longer? RSN's very, very keen to hear what they have to say. I mean, unless it's also, I mean, there's a bun plan, which I think Mr. McDean put in his evidence, sort of clarify this, but if it was just there for noise, and if the miller's strong preference was that they don't want it there until it's absolutely needed, then that's something we could look at. If they want it there the full time, then that's something we could look at. So we just really want to hear from them and see what their preference is.
or the other option you forgot about is they don't want it there at all.
Well, if they don't want it there at all, then, that's, I mean, from a noise perspective, the bun's entirely on our property.
Sure.
It's there for a purpose. 2.5 metre high bund is, if it's planted, some people might see it as quite an amenity.
I guess I'm just picking up on Section 42A officer's report, which pointed out that could potentially be an adverse effect. And I guess I was interested in just exploring whether the applicant was interested in being proactive in that regard.
Yeah, well, like I say, I mean, the evidence is helpful because, I mean, you could have a condition that said once the equipment gets within 100 metres, then you put the bund in. It may be that Miller's preference is actually they want it there sooner for other benefits. I don't know.
Sure. Fair enough. Okay, thank you.
Sorry, Mr. Higley, just a further question on the point I asked you before was we had a plan handed up to us yesterday with Mr. McDean's rebuttal evidence, this bund sequencing plan. It's got the bund around the processing area described as a noise and planted landscape mitigation bund. Is that at your direction or your recommendation, the processing bund?
No, I mean, it will have a benefit for noise, obviously, but it's not there solely for noise.
All right. But you're happy with the description that it's been given then? It will have that some effect.
It will have a
yes.
benefit.
Okay,
Yes.
right. Good. Thank you. All right, that was all our questions. Thank you very much.
Thank you.
Thank you. Okay, we'll now go geotech if that's okay. Thanks, Rose.
We'll just take a quick adjournment, 5-minute adjournment, although we're coming up to the 3 o'clock break. We might just take 15 minutes now and get started again at 3:05. Thank you.
Thank you.
Just a bit of housekeeping. Just welcoming Mr. and Mrs. Powell up to the front, and I'm sorry for not inviting you earlier, but these chairs are more comfortable, so I hope you enjoy those. I was just discussing with council staff the availability of this venue just past 5 o'clock if we need to. I would like to finish, and I'm sure the applicant would like to finish today if possible. I think we're making okay time. Sometimes it's always longer than the applicant expects, but it's the nature of it. So we're happy to go till 6. I hope that suits everybody. The venue is available. So if we get close to finishing at that time, we'll keep pushing on, but I hope that won't be needed. But I think it'll just be tidier tomorrow rather than trying to push submitters out who are probably expecting to start at 9 or their allotted time. So I don't want to spend any more time on that, but that's our intent for today. Thank you.
Excellent, thank you. Okay, we'll get over to Mr. Holland. Thank you.
Good afternoon. For those who don't know me, I'm Andrew Holland. I'm a chartered professional engineer and technical director at HDGO. So RS Sand hired us to do a preliminary assessment of their site at 77 Newcombe Road, Cambridge. They plan to turn the current dairy farm into a sand quarry. We submitted our report to the Waipa District Council and Waikato Regional Council to support the resource consent application. Our work included a desktop study, site walkover, and site investigation, including CPTs, soakage testing, and groundwater monitoring. We looked at the geotechnical effects of building the quarry, including slope stability and settlement that could be caused by groundwater drawdown. Our key findings were that the ground conditions matched the mapped and expected geology, with interbedded silt and sand soils extending to 15 to 17 metres below ground level, overlying dense sand soils to the bottom of the investigations. Groundwater was found at between 2 and 10 metres below below ground level, and this is perched within the near surface silt and silty sand soil layer that exists across the site. The regional groundwater is near the gully level at about 40 metres below current ground level. The next 2 bullet points in my summary are probably the key ones. Our slope stability assessment shows that the proposed final slopes will be stable with safety factors above the minimum required. And our settlement assessment indicates that there could be up to 10 millimetres of settlement below the Waikato Expressway adjacent to the site, that's at the on-ramp, decreasing to less than 1 millimetre below the expressway and the bridge, based on the drawdown assessment by WGA, who will be presenting shortly. We concluded that there were no significant geotechnical hazards that cannot be managed or mitigated through further detailed assessment and design or during the quarry's normal operation. To satisfy the concerns of NZTA as a key stakeholder, we prepared a trigger action response plan with predetermined actions if effects are greater than expected. So that's in relation to the groundwater drawdown potentially triggering settlement, and particularly in relation to the expressway.
Thank you, Mr. Holland. Just following on from my previous questions and other experts, under the new proposal, we've got the gully wall. It's going to remain into the final stages. Do you think there'll be a reduction in settlement of your forecasted settlements on the on-ramp because of that?
No, I think there'll be no effect. So the retention of the gully wall is at the opposite side of the site from the expressway, and the drawdown effects from that perched water table will occur as the excavation extends back towards the expressway. So there shouldn't be any effect from that change.
Thank you, Mr. Holland. I have a few questions. Just going through, in terms of, in the report for the application, you talked about monitoring and maintenance of the recycling pond.
Mm-hmm.
Where would you expect to see that detailed? Because I couldn't see it in the quarry management plan, and it's not in the conditions that I could see. Because you also recommended that the pond be lined with impermeable membrane, which again is not captured anywhere. So
sure.
I sort of thought that they're quite fairly important. What's your thoughts?
Yes, so there are elements of detail that are needed beyond the resource consent process, which is focused on the effects, whether they can be appropriately managed. The pond, the detailed design of the pond will be around its operational requirements, and because as the sediment control expert was saying, the site is very free draining, and so if we're expecting to reuse the water that goes into this pond, it's likely that we'll have to line it in some way to keep the water in the pond.
So likely, but not. So therefore, we're making it a requirement that the recycling pond has to be lined with an impermeable membrane, as you're saying, that's not appropriate?
I don't think that it needs to be a requirement. I can't think of an effect that would be trying to manage or mitigate.
So explain why you think it needs to have a lining then.
As an operational matter.
Operational, sorry, just expand on that a wee bit.
So in the operation of the quarry, they're going to have to use the pond to temporarily store water and hold it and then reuse it in the operation of the plant. So I don't think it's if the pond was lined or unlined, I don't think it would change whether there was an effect of that activity on the surrounding properties or the gully nearby.
Okay. So going back to the monitoring and maintenance side of it, I haven't seen that included anywhere. Is that something you'd expect to see in a quarry management plan?
Yes, I would expect that in a quarry management plan.
Thank you. In your evidence at 4D, you recommend long-term groundwater monitoring. Now, I appreciate there have been some groundwater conditions that have been proffered quite recently. Have you had a look at those? I think it was Mr. McDean's rebuttal. Was it in your rebuttal evidence?
Is that included
in my original evidence in chief for the
groundwater?
41 Newcomb, 943 Terra?
I just don't think I could see a thing which actually says undertake groundwater monitoring. There's some groundwater take, there's stuff related to the groundwater take, but not to level monitoring, which is what I understood Mr. Holland was proposing.
Yes, so the hydrology expert will be talking to the groundwater in particular.
Yes.
But yes, I've got to.
I think I picked on it because it was in your evidence as well. That's why.
Yeah, sure, and that's because the groundwater affects whether there will be settlement, which is in my evidence.
Yes, and I know the TARP relates to that. We'll
yes, yeah,
get
that's
to
right.
that in a minute.
They go together.
And just on there, I noticed that there's this condition around the TARP, but just a minor thing, and this is probably just a consent writing thing. There doesn't seem to be a condition which says you actually have to prepare a TARP or implement it. There's one which talks about how you have to get it checked off by New Zealand NZTA, but I couldn't find anything which actually said prepare a TARP. But before that, I noticed that in your section 92 response, you talk about long-term groundwater monitoring, which we just talked about, and providing a settling monitoring specification, which is your Appendix B, and a plan of monitoring locations, which is Appendix C, which are obviously really integral before you can actually implement the TARP. And I can't see any reference made to those documents anywhere, which I would have thought collectively would have formed part of the monitoring around that's related to the settlement. Would that be correct?
Yes, that will be, and that would be something that would be prepared and agreed with NZTA if consent was to be granted.
Yes.
That one of the conditions will say that the TARP which includes the settlement monitoring specification.
Oh, okay. So at the moment in your section 92 response, there are three separate things, and you actually refer to them as a groundwater monitoring program, a settlement monitoring specification, and then the TARP as a separate entity. So if the TARP incorporates all of those things, I think that needs to be made clear. And again, maybe that's just a consent writing thing rather than you. It just seems like you've gone to this effort to produce this this, all of these documents which are relevant to how you actually implement the TARP. So,
Yes, yes, and they're all in, I guess they're in a detailed draft forms
Yes,
so that they can then be
yes.
carried forward and
yeah,
agreed with,
yeah, it's
with
just,
NZTA.
just making sure that they're captured in the conditions, I guess is really.
Yeah, sure.
Yeah, yeah.
That makes
Did you have a
sense.
question around the TARP? Oh, yes. You just talked about how the final batters, that the factors of safety on the final batters are acceptable. And I was just wondering, so there are interim batters, aren't there?
Yes, there are.
So what about those? The FOS values for those? Have you actually assessed the factor of safeties for those?
Yes, so they are they don't have to meet the same factors of safety as the final, and that would be something that's in the operational plan for the because if you go too steep, obviously there's health and safety issues.
Yes.
Our focus of this assessment was on effects on the neighbours rather than on the internal operation of the quarry.
Yes.
But yes, the temporary batters would be part of the operations plan of the quarry.
So that would all come out in the final design process?
Yes,
part
that's
of
correct.
the
Yep.
design process. Okay. And you also talked about having a building restriction zone of 10 metres, which I couldn't see in the conditions anywhere, or in the quarry management plan. Where would you expect to see that?
That would be in the final consented layout of the quarry footprint, because that 10 metres should be within the property that's being affected. So just to make sure that there's no impact on the neighbouring properties.
Okay. So does that need to be specified in some way, or is that just going to be something that we integrated into the plans themselves?
I think that was a recommendation from our assessment, which I
Yes.
believe is carried into the design of the quarry pit.
Okay. All right. Okay. No, I'm not. Yeah, I'm not sure that it has. That's why I guess I'm asking the question.
So that there needs to be 10 metres between the boundary and the crest of the final slope for any neighbouring properties.
So would that be better included as a specific condition of consent that the design includes?
Yes, it could be included as an offset as it is in my evidence, or it could be included as the design of the quarry shall be as presented in the plans, which include that.
Okay.
So that can be
I
captured
guess
a number of different ways.
That's we're not sure about, because we're not design experts, not knowing necessarily that there's a 10 metre.
Mhm.
And I guess that's a question actually it's a question I have for council, but just this question of, I couldn't see anywhere where the design specifications, there's specific things like the bund has to be approved by a geotechnical engineer, but I'm not sure that the plans, the design of the quarry as such, and maybe I've missed it, but I couldn't see that the design itself has to be signed off anywhere. And whether that's something that needs to be considered. And I do appreciate that's not a question for yourself. So
Sure.
thank you. That's all I have.
Just on that last point, Mr. Holland, the 10 metre distance, would that remain the same with a bund on the surface within that 10 metres? That doesn't create a loading down that you then need to provide a further setback for?
No, that was accounted
That's 10
for
metres,
in our,
okay.
yeah, we included the bunds in our assessment.
Right.
And that's part of the reason that, the offset there includes the bunds.
Right. Just trying to find it again. The TARP condition that's been handed up with Mr. McDean's rebuttal evidence, you've had a look at, you're familiar with that, you helped with it.
Yes.
Is it intended that the green, orange, red, or was it, sorry, amber, orange and red alert levels, that they're yet to be defined, and they would be defined by some millimetre measurement?
Yes.
Assigned to them? Is that
there's
how I
an
read it?
example in there, and that needs to, the detail of that needs to be agreed with NZTA, whose infrastructure it is that could potentially be affected, to make sure that they're happy with the approach.
That's set out within the condition, and so I'm just going to need to.
I believe the condition has both the Regional Council and NZTA approving that plan.
Right.
but-
Okay.
So I see it now does actually have something saying that.
Mm.
they prepare it. My apologies.
Yes. Okay. There it is. Okay, just my only other question was just really understanding the groundwater levels that you draw attention to in your summary statement today, which to some extent aren't that far below the surface, and we're going down about 30 metres as part of the quarry activity. Does that change the permeability of the underlying soils? We've heard the way the sediment control probably won't rely on the bunds to any great extent because rainwater will soak away. For the larger events, is there a limit to that given that we're kind of already into the groundwater level, the perched groundwater level as part of the quarry activity? Does that affect that drainage capability of the land, of the quarry floor?
I think the hydrologist would be best placed to answer that. The short answer will be yes. It varies slightly as you go through the different layers.
No, thank you. I will put that to somebody else. Thank you. All right, nothing else. Thank you very much for your evidence. Yeah.
Thank you, Mr. Holland. Good segue into Ms. Holbrook. Thank you.
Before you start, do you want to just pick up that last question I put to Mr. Holland, just while it's fresh and online?
Is it working now? So there's a perch layer. So there is a layer at about 5 to 7 meters down below the ground surface, and that has a perched aquifer sitting above it, so water there, and then it becomes dry again once we get to the other side. So I think even though you're thinking about the groundwater levels in the first perched aquifer, it's then dry again. And then we're not seeing the groundwater level until we're getting down to the unconfined aquifer, which is closer down towards the river, the level of the Karapiro River. I've got a cross-section schematic in my evidence in chief and the reports. I think all the reports have it, showing that perched layer and then the deeper unconfined aquifer, and then below that is a confined. So.
Can I just ask, sorry, I know you haven't even started, but so what's the lateral extent of the perched aquifer?
Yeah, it was relatively consistent that we could see. And that was shown both through the evidence of the drilling that was done on site, but also we could see in aerial photographs during dry periods, seepage along the edge of the terrace, as you might have seen yourselves when you're out there, at about that consistent level. So it was relatively consistent. In the Waikato, they're not always, those perch layers sometimes can be quite inconsistent, but those levels of evidence made us consider it relatively consistent in that area. Shall I go on?
Now you can start.
Yeah, I can start. I think I'm just about to repeat the same thing, but that's okay. So I'm Claire Holbrook. I'm a hydrogeologist. I've been working in hydrogeology for about 25 years. So there's 3 underlying aquifers below the proposed RS Sand Quarry: the perched aquifer, which is approximately 5 to 7 metres below ground level, an unconfined aquifer approximately 39 to 43 metres below ground level, and then the confined aquifer approximately 53 to 82 metres below ground level. The quarry is proposed to be excavated to a final floor level of 40 metres RL, which will remove the perched aquifer, but the quarry base level is approximately 7 metres above the unconfined aquifer. That's at an RL of 33 metres RL. There are several local incised gullies that will limit the drawdown effect of the proposed quarry on the perched aquifer. Modelling of the drawdown effect on this perched aquifer in the direction of State Highway 1 resulted in a projected drawdown of 1.2 metres under the on-ramp and 0.2 metres underneath the expressway. There are a number of registered bores and a consented take from a spring that I consider will not be affected by the proposed quarry excavation. In addition, there is a nearby spring to the northwest of the site that is used for an unregistered water supply by the neighbour at 41 Newcombe Road. I consider that this unregistered spring could be significantly affected by the proposed quarry excavation. One of the submissions provided information on a spring at 143 Tiro Road, which is used for water supply. I consider that the recharge source to the spring will be relatively local and generally be sourced from water seeping down through the submitter's property. The westward movement of shallow groundwater towards the spring is considered to be limited, but cannot be ruled out as a minor component of the spring flow. The proposed quarry at its full extent may cut off that shallow groundwater flow from the eastern direction. Therefore, there is still potential for a very minor effect on the spring flow during periods of low rainfall. RS Sand is seeking to abstract groundwater from a bore for dust suppression and sand processing from the confined aquifer. Volumes of 1,100 cubic metres per day and 290,000 cubic metres annually are required, with RS Sand intending to reuse 75% of that processing water. There is allocation available from the underlying aquifer management zone for the proposed groundwater take, and the projected effects from the proposed groundwater take are less than minor on nearby bores and surface water bodies. The results of on-site soakage testing indicated that the floor of the pit should provide sufficient soakage capacity to enable the management of incipient rainfall without direct overflow to the stream. However, some ponding on the quarry floor is likely to occur while infiltration catches up with the runoff of the inflows from the pit into the pit. The conclusion of the soakage investigation was that the quarry design could include a designated soakage area or basin in an area of the pit floor that characterised by higher permeability material. And just to, I'll finish off, and some additional drilling and groundwater level monitoring is recommended to ensure that the groundwater levels respond as expected. And then I was just going to add about the new design. I don't think that that's going to significantly impact the groundwater drawdown effects that we've modelled around the site. It will in that, what do they call it, incised gully? Is it not a bund? I don't want to use the word bund. The gully wall, sorry. So with that gully wall, the perched aquifer in there will be cut off on either side, so effectively draining out anyway in that period of time. So it effectively, as if it wasn't there anyway from the effect of my assessment. And when I was talking before about, putting in a bund, and obviously that's been superseded by the gully wall. Thank you.
Oh, okay. I'm not talking about that one anyways. At 3.22 of your evidence, you refer to an adaptive water management plan to address potential issues related to truck movements and reduce permeability of the quarry walls. So I guess that's when the trucks are actually moving around in the quarry. I can't find any reference to a water management plan anywhere, and I was just wondering what that might entail. And
I think that, so we didn't realise, it'll be the erosion sediment control plan, I presume. That would be about where that, the control of that water and runoff and putting it into. So we did find there was some variability within the soakage when we did the soakage testing on site. And so our recommendation was to find a higher permeability zone as the stages progress, and that might be variable.
Okay, all right. Okay, so
just to be clear on that, that wasn't my impression of the purpose that you were referring to that plan in your evidence.
Okay.
I do think the erosion sediment control's probably dealing with something different to what you're talking about at 322. you're concerned there about potential compaction of the groundwater beneath the works.
It's not the groundwater, it's more around the, it's management of the soakage. So, that if truck movements are everywhere across the surface and we're trying to have the surface being used for infiltration. So it is related through to the infiltration, and it's just making sure that the entire surface doesn't become highly compacted, so that and if there are designed areas for infiltration, then that would help with that, and whether that's through the erosion sediment control plan could be an option, but I'll leave that to Mr. McDean to decide.
So would you see those areas for higher level of permeability sort of partitioned off in some way, or in some way separated off so that trucks don't end up going in there?
Yes, and through
I know that's operational,
formation
but-
of a basin and designated as an infiltration type zone, and so that the infiltration rates maintain at the level, so that especially they're not so that their level of infiltration can keep up with the rainfall that's coming through. It's generally very high permeability, but occasionally there's some areas of low permeability. It just needs to be managed as they're developing the quarry.
And the only other question I had was, again, I couldn't find a groundwater monitoring plan specifically referred to as being required, unless I've missed it in the various versions of conditions that have come through.
No, I've suggested some groundwater monitoring in the in my evidence.
Yeah, I agree, and because there was also that proposal for some additional piezometers, so I don't see any of that having been captured in the conditions. Do you think it should be?
I think it should be groundwater monitoring plan should be considered in the conditions. Yes. And my figure attached to my evidence shows where in purple the two current locations for piezometers. I've indicated that there could be another one with the star that would be both deep and shallow, but also noting that from the geotech point of view, they're also looking for that. So I've added on there the SP location. So that's where the geotechnical engineers were looking for some monitoring. And I'm happy to be doubling up with some of that. But obviously I need it from more of a longer term point of view than necessarily the responses of a TARP that you might have from a geotech point of view, longer term type responses.
And I think the geotechs actually recommended groundwater monitoring as well, and actually had some detail around that, I think. So it sounds like between your evidence and that document, you might be able to put one together quite readily.
Yes.
Yeah.
Yep.
Thank you.
Very clear.
Just while we're on the conditions, you recommended at 6.2 to 6.4 of your evidence, I noted 4 different matters that you were seeking or recommending. I couldn't see those carried through into the conditions before us. Have you had a chance to look at the condition sets as to whether they cover the points that you're seeking be addressed there?
I have had a look at some of the conditions, but do you have them in front of me? We had a discussion about some of the monitoring that might be occurring for looking at the effects and neighbouring properties.
That covers the 4 points that you've addressed in your evidence?
That covers the...
It's 41 and 143. Those are
Yeah.
Just that they were quite specific, talking about things like pressure transducers and so forth, and they're certainly not captured in the condition set that's in front of us. I don't know if you're feeding anything back to the set that's coming at the end of this hearing.
I will be, yeah. So the pressure transducer is just an automatic recording, so that's just in terms of my recommendations of continuous automated monitoring.
So that would all form part of the groundwater management plan. That we
Correct.
Yeah.
Yeah, and I think if there was a condition for a groundwater monitoring plan, this is what would feed into it. So I took it to this point at this stage.
got some conditions in front of us to address that issue that you raise about the spring, the neighbour's spring. And I mean, you've acknowledged in your evidence that that's a matter that is outstanding as far as I could tell. From you say that there will be an effect on that spring that they're relying on?
The one on.
This is the site to the west. Yes, 41.
41 Newcombe.
Yeah.
Yes, I do consider that spring will be affected.
So there's some conditions amendments to it that Mr. McDean put to us. Oh, sorry, that was to 143 Tirail Road. Is there a condition for 41? I think there was.
16, I think condition 16.
16?
Yeah.
There it is. Thank you. And I just wondered how readily you'd be able to tell from an assessment post the quarry being undertaken that as to whether it was the quarry that was having an effect on their water supply, which I think is what this condition is seeking to address.
I think the site visit is initially to just like if it's a pump failure or something quite obvious, not
That's right.
something else on site. Occasionally those things might occur where there's something quite obvious that wouldn't be attributed to the quarry.
I mean, I get the impression this condition sort of the best you can do without any further information or the ability to visit the site, the neighbour. But as it stands for the panel, for us at the moment, you've told us that there's an impact or likely to be, and this condition is the way that you would seek to address it. But it, again, relies on access to the site in order to achieve any measurable analysis of the way in which they draw the water? Yes. Okay. All
So
right.
it's unclear whether they're drawing from the perched aquifer or the regional unconfined aquifer. I've assumed that it's the perched aquifer. If it was the regional, that might be, it might not be quite so affected, but I've made an assumption without visiting the site that at what level they're taking the water from.
Okay. And so for the other one at 143 Tirail Road, which was probably the condition I had in mind before, was at 19, or the new number 19, it says, should the quarry activity be determined to be the cause of the loss of groundwater? Is that something that you're confident you'll be able to determine?
So usually you would have groundwater monitoring, towards a site, but then access to have that monitoring to determine it. You could get an exclusion that you think that it's not because of the quarry, if it's a failed pump or something that was operational. As I stated before, that site is quite different to 41. 41's quite close and direct. The effect on 143 is much less likely.
Okay, so I just want to pause on that condition 14, make sure I've covered everything there. It was, I think, no, that's right. I understand your answer. And I think the lack of any the difficulty of having no baseline data must make your role further along, much more difficult. Yeah.
And, or you could set up a monitoring site but you'd still need access to someone's property to then go in and put a bore in close by to have some detailed information on it. So it does make it difficult.
Yes. Just one minor detailed question. I'm not sure it has any real effect, but at 313, you talk in your evidence about a maximum of 500 cubic metres for dust suppression. Mr. Curtis refers to 455, which isn't hugely different, and then the regional council's report refers to 600 cubic metres. not so worried about the differences. It's just that it's all in the context of what I understand to be the sort of maximum take for these types of purposes of 1,100 cubic meters. So I think it would be good to have certainty around those numbers so that 1,100 is known to be the definitive max number, because obviously if you draw, well, not obviously, but in my assumption, if you draw more than that, then you potentially have an effect that you haven't considered in terms of where that water's been taken from. Is that correct?
So yes, the maximum is 1,100, and that's what we've considered in our assessment, 1,100 cubic meters per day, which would be their consented limit. And those numbers were derived through looking at, we did some analysis of the number of days that might require dust suppression, looking at the application rates of that in our initial report. We did do some work on that to look at that dust suppression number. And then the processing, I think I've got that when I went through, and there might have been just a little bit of a buffer around it. And maybe that's why they're rounding up to 1,100. But in my evidence at 3.15, we talk there about the reuse and therefore the additional water that would be needed based on the number of tonnes that they're looking to process, which has come to the 582 cubic metres per day. And then there's probably a bit of buffering in there that's put it back up to the 1,100.
And I had a note, it's just out of interest really, is what are the challenges on reusing 75% of the processing water? Is that's achieved elsewhere? That's not unusual or difficult?
I don't know. That would be more of an operational question that I'd have to put to back to R.S. Stevenson's.
Okay. Mr. Hine, is that a
yeah, sort of recycling the water's not a problem as long as you sort of skim the top of it. It's fairly clean and you don't suck up too much of the sediment. Most of the water is lost with the product that goes off the end of the belt, really. So takes the 25% of water away. Thank you.
Okay, nothing else? All right, thank you very much for your evidence.
So we might, slight change of scene, go to economics. And then after that, I think we're just left with Mr. Curtis and Mr. Hall. So I think there should be 3 to go. If I've count. Oh, yes, and the planner, yes. So Mr. McElrath, thank you. Yeah. Sorry, we don't have this is the one we don't have an electronic copy for, but we can get it to you tonight. So, but there's a paper copy in the meantime. Thank you.
Very good. Thank you very much. I'm Lawrence McElrath from Market Economics. I've prepared a summary statement. I'll just read through that. We've got hard copies. I'll send a soft copy through. I'll just start at 1.4. But my evidence covers the sand market in the Waikato Bay of Plenty and the outlook. In the summary, I'll highlight the key points relating to the demand and supply patterns, the sufficiency position, the cost and benefits of enabling the Newcombe Road operation, and then also comment on submissions that have an economic element. In terms of demand and supply patterns, sand is an essential input into concrete as well as the construction sector. Construction is a central part of economic growth and development, And infrastructure investment includes spending on new infrastructure, maintenance, and spending to address backlogs. Sand is a high volume, low value commodity, and its cost is sensitive to transport distance. Therefore, the spatial relationship between where sand is sourced and where it is used is very important. The delivered price of sand is directly correlated to transport distance. Transporting sand from its source to its destination significantly increases the cost of end products. Beyond the direct financial cost, environmental externalities, so that is emissions and accidents, also arise from transporting sand. Enabling local sources of sustainably quarried sand ensures that the sand market can operate in a cost-effective manner. Now, there is no official information about the volume of sand that is extracted. However, demand for sand is derived, so that is, demand for sand arises through demand for other goods, such as concrete. Using published information about concrete, we can estimate the demand for sand. The weight of sand used to produce 1 cubic meter of concrete, sorry, not sand, is known, as is the volume of concrete that is poured. So just on that aside note, you use between 400 and 450 kilograms of sand for a cubic meter of concrete. So using those ratios, and we can link that to population, so demand for sand can be expressed relative to the size of the population. I estimate the demand for washed sand in the Waikato Bay of Plenty market, and this is between 655,000 tonnes to 708,000 tonnes, and that's broken down as follows. Ready-mix concrete sand, that's between 291,000 tonnes and 314,000 tonnes, and other applications between 363,980,000 tonnes and approaching 400,000 tonnes. In these estimates are in line with demand levels we saw around 2016-17, where the economy was growing, but before the rapid growth seen immediately before and after the COVID disruptions. So these estimates reflect the current slow economy and is likely to underestimate the likely baseline demands. In terms of the outlook, I use a scenario approach that is based on population growth to estimate future demand for sand. The anticipated shift is substantial. The overall demand, so that's the total quantum, demand is expected to increase to just over 790,000 tonnes. I'll just round those numbers. Between that and 950,000 tonnes by 2048. In terms of the additional sand, so that's the shift that's needed, the additional washed sand, so that's for concrete, there will be demand per year is estimated at around 76,000 tonnes up to 135,000 tonnes per year. Based on the growth scenarios and sand use patterns, the production levels will need to increase by between 21 and 34% to ensure that there is sufficient capacity to support regional growth. Now, changes in the Auckland sand market is adding uncertainty and could add to demand for Wellington Waikato sand. These changes relate to the consent renewals that have been cancelled, specifically the Parkry sand consents, as well as existing consents that will come up for renewal, specifically the consents in the Kaipara. Those ones expire in 2027. Adding a portion of Auckland's long-term sand to demand estimates, add between 206,000 tonnes to 241,000 tonnes per year. This suggests that the long-term, that's by 2048, demand for Waikato and Bay of Plenty sand is estimated at between 1 million tonnes per year up to 1.2 million tonnes per year. So in terms of the supply patterns, sand is one of the world's most consumed raw materials. Sand is not a homogeneous good. For example, wind-eroded sand has a round profile and is not suitable for concrete applications. River sands north of Taupo have high levels of alkali reactive materials and pumice, meaning that it must be washed before it can be used for high-strength applications. So as mentioned, there is limited useful data about sand production volumes. Therefore, I use industry sources and publicly available information to form a view about the supply situation. The key points regarding the supply is consented volume, so that's the theoretical maximum of sand is estimated around 1.2 million tonnes across the Waikato Bay of Plenty, and important, that's the capacity. Consented volumes for washed sand is estimated at approximately 530,000 tonnes per year. The sand supply market is relatively concentrated with a large share of consented volumes associated with a small number of operators or consents. This concentration means that if these consents expire and are not renewed, then a large portion of the supply is lost or is at risk. Some sources already service the Auckland market, meaning that the sand is unlikely to be available to the Waikato market. Spatially, the consented volumes are spread across the Waikato and have good accessibility to State Highway 1, so that's a transportation requirement. A significant share of the existing consented volumes will expire over the next 5 to 7 years, so that's around 47% of consents likely to expire the next big while. In terms of sufficiency over time, that's paragraph 3.1. I estimate sufficiency by subtracting demand from supply. I use a scenario approach to illustrate the sufficiency position. So figure 1 in my main evidence shows that sufficiency position, and the main points are there is sufficient capacity to meet demand over the short term. A deficit is expected over the medium term, and that's around 2030-31 as existing consents expire. Dynamics in the Auckland market, sand market, can be expected to add complexity and additional pressure to the local sand market. So what are the potential options to address the shortfall? As these consents expire, we've got options in terms of importing sand from other regions. We can lift production at existing operations or renew consents or enable new quarrying. So obviously the consent at Newcombe Road is the third option. Manufactured sand is also often put forward. I'll comment on that a bit later. So enabling the Newcombe Road operation will help avoid future shortfalls. So in terms of the cost and benefits, supporting regional economic activity is critical, and sand is an essential input. Without sufficient sand, adverse economic effects arise, including a drag on economic activity. Examples of the potential adverse effects include price increases, rationing, and shifting demand patterns, and those lead to the use of uneconomically or economically inefficient options. So that's really about long distances. Enabling the Newcombe Road resource offers the ability to supply sand to the regional market in the way that not only satisfies demand, but also avoids transport, environmental, and social costs. These avoided costs are seen as benefits. The costs are all related to the transport function, and they include the direct cost, the emission cost, and the social cost. The sand supply market operates as a network of extracted sites and demand locations. The scenario approach is used to illustrate the likely scale of benefits, and so that's the avoided cost of using different sources and as the market responds over time. So just to skip forward, so 4.5, the benefits associated with enabling Newcombe Road to supply sand into the Waikato Bay of Plenty network will accrue into the future, and the present value of those effects are summarised there. And just looking at the main, so that point D, that's the total. So it's approaching $180 million over the life of their consent. So that's the current value of the future benefits. So based on the transport, environmental and social costs that would be avoided, enabling Newcombe Road sand extraction would deliver benefits between $179.5 million and $181.2 million. This represents the economic benefits in the form of avoided costs that accrue to the region's economy and ultimately households. So I'll also respond to some of the submissions. At the initial submissions can be grouped into 3 parts, but I comment on Mr. Grimm's submission separately. So the submission points can be grouped into 3 categories. As I said, the first one is the effect on the tourism sector. So tourism accounts for between 2.6% of the Waipa economy and 4.3% of the Waikato's economy. In my view, developing the Newcombe Road Quarry is unlikely to undermine the tourism sector's growth opportunities in either the district or the region. Supporting infrastructure investment and development is crucial for the well-being of residents and the functioning of the region. Opportunity costs associated with foregoing agricultural land. Developing the quarrying will mean that the option to use land for alternative land uses is foregone. Crucially, the site must be rehabilitated to pasture upon conclusion of quarrying. In my view, the opportunity costs are outweighed by the positive economic effects. Increasing vehicle movements. Submitters point to the increase in vehicle movements associated with the Newcombe Road Quarry and highlight the adverse effects. Such adverse effects must be viewed against the counterfactual, that is, the traffic movements if the sand is sourced from elsewhere. Mr. Green's submission on behalf of Mr. Pell covers several matters that are addressed in my rebuttal statement. Mr. Green provides additional information about 2 granted consents that I have considered. However, even after considering this additional information, I remain of the view that enabling Newcombe Road Quarry is essential and that without additional volume, a deficit can be expected over the medium term. Mr. Green makes several points in his submission, and I would like to highlight the following elements. Mr. Green questions my sufficiency analysis and provides additional information about granted consents, as well as consents that are still being assessed. In my assessment, I state the deficit position and I highlight the uncertainties. It is inappropriate to base the future analysis on the intentions and development ambitions of competing operations. So that's current and future. I also understand from counsel from RSANT that as a matter of law, when assessing the environment, it is unlawful to assume that any existing consent, resource consent with a finite life will be renewed, or to assume that any existing consent conditions will be applied to any replacement consent. The key point I make is that there is limited certainty about the medium terms regarding supply. In my opinion, granting consent for the Newcombe Road Quarry will reduce uncertainty for at least the duration of the proposed Newcombe Road consent. Mr. Green points to manufactured sand as an option to provide additional sand supply, and he references 2 examples, one in Auckland, the Brookbeck Quarry, and one in the Waikato, so for Kaya Sands. Although I'm not a concrete specialist, I understand that manufactured sand is blended with natural sand to improve workability. This understanding is based on information on the Aggregate and Quarry Association of New Zealand's website, as well as evidence of Mr. Officer presented in support of McCullum Brothers Limited to the Environment Court. Mr. Green asserts that in his view, such blending is irrelevant to this assessment. I'm unclear what the basis is for this position. Using a blended approach implies that natural sand is still required. Manufacturing sand does not replace it on a one-to-one basis. Unfortunately, Mr. Green's description of the manufactured sand situation does not extend to the wider implications and other considerations of this emerging technology. Mr. Green's assessment does not capture other crucial points. Manufactured sand needs aggregate feedstock and must then be transported from the point of production to where it is used. Manufactured sand requires a significant financial investment and could add between 20 to 30% to the cost of sand on top of additional transport costs. Mr. Green dismisses the additional scenario I used to illustrate the wider considerations, such as the dynamics in the Auckland market. I explain the factors influencing the Auckland market. Mr. Green lists 3 examples in support of his position. I note 2 examples are listed under the Fast Track Approvals Act and are not considered. These consents are not guaranteed. The Kaipara consents expire in 2027 and renewal is not guaranteed. With reference to my assessment of the transport associated costs, Mr. Green queries the destination markets that I use as well as the alternative I used to set the counterfactual. He assumes that 90% of Newcombe Road sand could be used for concrete sand. This is a key ratio that drives his spatial analysis. I'm unsure what his source is. Concrete sand is only between 35 and 44% of the anticipated use. Mr. Green's high ratio changes the spatial patterns with his analysis and excludes important submarkets and misses important distributional considerations. In terms of the transport cost methodology that I use, Mr. Green states that the only way in which transport savings could be achieved is if RS Sand could achieve those transport savings and the savings have no impact on price. My assessment considers the direct transport cost difference using the scenarios. This is the cost difference regardless of the quarry gate price. Sand is low value, high volume good, and its delivered price is highly sensitive to transport distance. In terms of emissions, Mr. Green asserts that the emissions trading scheme, or the ETS, already covers emissions, and therefore the emissions cost should be excluded from the assessment. I disagree, because the ETS cost covers the cost of emitting and does not reflect the externalities of those emissions, so that's really health costs. Further, my analysis is based on the parameters and approaches used by the New Zealand Transport Agency, Whakakotahi, and data published by the Ministry of Transport and the New Zealand Treasury. If Mr. Green's approach to excluding emissions is appropriate, then it is unclear why central government considers emissions as part of its project assessments. Road safety simplification. In the section dealing with social costs in Mr. Green's evidence, He questions my sources and approach. I have relied on New Zealand Transport Agency Waka Kotahi guidance, parameters and data sets to estimate the social costs. In conclusion, I remain of the view that establishing the Newcombe Road quarry will support regionally significant and essential sand industry to fulfill local demand while also supporting other regions. And without new resources being developed or the existing consents renewed or extended, the region will not have sufficient capacity to support infrastructure investment and meet the needs of other sand users. The economic costs associated with such a deficit are significant.
Thank you. I just have one question. This might be being a bit pedantic, but I want to test it anyway. So in your rebuttal evidence at 2.4, you state, in my assessment, granting consent for the Newcombe Road quarry will reduce uncertainty for at least the duration of the proposed Newcombe Road consent. And then in your evidence in chief, you state, and in your report, you state that it would provide supply chain resilience. And to me, resilience and reducing uncertainty are not the same thing, but I just wanted your view on whether this was just playing around with words or you have actually changed your stance somewhat.
No, I think we're talking two separate things.
Yes.
Supply chain resilience is, can the supply chain function and operate?
Yes.
And certainty, is there certainty in the market? Do people know where they can actually get the product from? So we are talking about two different things.
Well, I guess these are both your conclusions. You talk about it will reduce uncertainty for at least the duration of the consent, if it was granted.
Yep.
Versus providing supply chain resilience.
I think it's an and. I don't think it's trying to be clever with words or anything.
Okay, all right. Okay, thank you. That's all.
The table that you've reproduced here at 4.5 in your summary, I was quite struck by the narrow range of your estimates. Normally, in an economic analysis, you'd see quite a much broader range than what you've got there. Are there particular factors to this type of assessment that lead to that kind of outcome?
So I think a key driver of the sort of demand levels is really population growth in Waikato. And if you look across the low and medium and the high projections from stats, the variation between them is actually quite narrow. So that's sort of one of the key drivers. And as part of the assessment, we actually looked at some of those ranges and thought, okay, well, if we look at this assessment, what are the other core drivers of the potential outcomes? We said it's really about the transport distance. So we actually had a separate little analysis covering the sensitivities where we said, well, what happens if we change the transportation distance by 10%, 15% or 20%, and under the 10% setting, the costs change by around 7%. So.
In the next page, I think it was, or thereabouts, you talked about the opportunity costs of foregoing agricultural use of the site, and I certainly assume that this would be at the margin, but why was that opportunity cost not built into the what you call the present value of the benefits, i.e. avoided costs at your 4.5? Is it something just completely different to what you're assessing here?
Yeah, it's entirely different, and it's the foregone stuff. But in the response, I provide the share of how big it is. So we actually went back and had a look at how big the dairy farms are and tried to get a sense of, is it the economic units? But it's really a can of worms that you try to end up there. Because a farmer could potentially lease some of the site and trying to then just untangle the production on the farm versus that potential lot. So it becomes virtually, super difficult. But I can add to that if we look at the area relative to the size of farms, relative to the size of total the dairy, the effective hectares, we're talking less than 1%. It's very small.
And can you just give us a sense of if this sand, say, from this quarry was used, say, to supply this southern part of Auckland, which I presume would be the furthest you'd want to be transporting sand. I mean, is transporting it so cost prohibitive that that would not be a likely scenario? You've talked about Auckland's own problems.
Yeah.
Somewhere, if that supply was to stop completely, then Waikato would start to have to transport further, correct? But is there a limit to how that could happen?
The change was always at the edge, at the margin, right? So if we look at, say, if Auckland really ran out of sand, it's not going to immediately start importing sand from Cambridge, but it's going to come from Mercer, one of those locations. So, and that changes the dynamics. So it's not necessarily a case of the sand will come from here, but it changes where the supply and distribution patterns in the Waikato, then that moves around, because it's the cost associated with the next best option that sets the price.
All right, well, we'll be hearing from Mr. Green tomorrow as to which parts of his arguments he accepts or not. And yeah, I'm thinking ahead is how to consider both sets of evidence, because they're dealing with quite high, for us, quite difficult subjects to, there's a lot of assumptions built into them. And for us to unpick that is quite difficult. I think one of the key ones that I picked up from his evidence was this issue of transport and the extent to which other quarries are going to come on stream. And that's, as you say, we can't really consider those ones that haven't been consented, as likely as that might be or not.
Yeah.
That Gordonton was one of those, wasn't it? That was 1 million tonnes, and that's one that he says that was a fast track application. Is that correct?
That I understand, so yes.
Yes. Okay. All right.
I think
Thank
I
you
can
for the
just add to that. I
summary.
think it's important to, and I don't know the ins and outs of all the quarries, but we have to differentiate. And remember, sand is not just sand. You know, when we start looking at concrete sand, we have to reflect those attributes, because, you know, we do have different types of sand, and the quality of sand is important.
Thank you. Thank you, Mr. Mekarath. So I think let's do traffic then. Mr. Hall, if you're free. You should have a hard copy of the, sorry, an electronic copy of this as well, so, but.
You can proceed, Mr. Hall, if you like. Thank you.
Cool. Thank you very much. So I have prepared a brief summary statement, which I've circulated electronically and provided hard copies as well. So I'll run through that quickly, starting from section 2, which is to do with traffic volumes. Based on an extraction rate of 400,000 tonnes per year, I've calculated that the quarry may generate an average of 78 trucks or 156 movements per day, which equates to 7 to 8 trucks or about 14 to 16 movements per hour. Of those trucks generated, approximately 44% may pass through Cambridge on the former State Highway 1 route, sort of heading towards north of that urban area, which is the equivalent of 3 to 4 trucks or 6 to 8 movements on that particular route. It's my opinion that an increase of that magnitude is unlikely to have a material effect on the receiving traffic environment. The distribution of traffic in my calculations has not allowed for products serving the Cambridge to Pireri C2P project. Obviously, that project still hasn't yet been given consent. It's likely that that project would proceed, and therefore I would expect that demands through the Cambridge area would reduce accordingly. I've undertaken sensitivity testing with higher truck movements at the Newcombe Road and Tiro Road intersection and identified that the road network has sufficient capacity to accommodate at least 200 trucks or 400 movements per day. To provide further comfort to concerns in relation to pedestrians and cyclists, monitoring conditions have been proposed as conditions 32 to 35 in the draft conditions. Those conditions require a review of the road safety record during the operation of the quarry, and that once the C2P project is complete, that trucks heading north would be encouraged to use the future Karapiro interchange to reduce movements through the urban area. Based on the expected distribution of trucks from the quarry, I've also calculated that the heavy vehicle impact fee would be 4 cents per tonne, which is included as condition 21. Conditions 22 to 28 include upgrades to Newcombe Road and Tiro Road. This includes upgrading the surfacing on Newcombe Road, monitoring of the pavement structure, ensuring that appropriate visibility is provided, and a raised island is included on Tiro Road between Newcombe Road and Lockley Road. These conditions have been derived based on my consultation with both NZTA and Waipaha District Council. I note that all submission points from NZTA have been resolved within the conditions proposed. The submission from Mr. Ray Talbot includes matters that have also been resolved within the conditions, such as his concerns in relation to visibility at the Newcombe Road, Tiro Road intersection. There are some differences of opinion on other matters. However, it's my opinion that the concerns raised are not exacerbated by the quarry or would present a greater road safety risk compared to what is proposed. So as a very brief conclusion, it's my assessment and an opinion that the quarry is unlikely to create a significant adverse effect on the transportation road network.
Any other questions?
Yesterday we went on site visit and we turned in from Tito Road into Newcombe Road and also exited out of Newcombe Road onto Tito Road, and obviously we're on a small vehicle. So the sight lines were quite restricted at this stage. To understand that there's going to be some planting, reduction in planting, but also some slight earthworks in the area.
I don't believe that earthworks are necessary at this stage, and that's largely based on historical street view imagery of that site. When it was first built, I think it was 2017, that embankment that you're referring to, the planting was still new at that stage, and it's just overgrown over time. So I would expect that once that vegetation is removed, that we can then achieve appropriate visibility, because as you've pointed out, that it is restrictive at the moment, and hence the conditions being included. So my current understanding is that earthworks are not required. However, if it is found that some earthworking is required, then there would need to be consultation with Waipaha District and potentially NZTA to ensure that any geotechnical matters or slope stability matters are appropriately addressed. I would note that, being not a old piece of road or an old slope, that I would expect that when it was constructed to appropriate standards at the time, and it would have been safety audited by the agency at time of construction.
Thank you. Just picking up on your this sensitivity testing that you did, and coming to the conclusion you come up with accommodate up to 200 trucks per day. And then I notice, and there is actually a condition which sets a maximum of 200 that it shouldn't exceed 200. And I'm just wondering why it needs to be that high, given clearly there was quite a lot of confusion from your initial report around this that came out very strongly in the submissions. And so, and I did read all of your report and evidence, so I can see that occasionally it could get higher than the average. That's why it's an average. But I just wonder why it needs to be 200, given that I understand that from what you're saying that it was a sensitivity test rather than a necessarily reflecting any kind of particular scenario.
You're correct. I guess there's probably a couple of things. One is there is allowance for daily variation. So some days might be busier than others.
Yeah.
And it's also just a reasonably nice number to sort of set as a threshold. In my evidence in chief, I think I ran through sort of various sensitivity scenarios that identified that, if you were to take just a purely capacity perspective, you could get something like 190 movements in an hour. And obviously if you take that over a day, that would be a very high volume. So in terms of the science of where the 200 was landed on, there's, from a traffic perspective, no exact reason why it's 200 and not 190 or 233 or whatever it might be. It's just a number, and I've assessed at that level.
But why couldn't it be 100?
Good question. It could be 100, but my assessment at 200 shows that 200 also functions adequately.
Yeah, I guess I'm just sort of thinking from the perspective of the submitter's concerns around the possibility, because at the moment, the way the condition reads, there could be up to 200 vehicles or 400 movements per day, every day of the year that they're open. Correct?
That's the current wording, yes.
Yeah.
I'm aware for some other sites that there could be maybe a weekly or monthly thresholds. But yeah, the daily one seems like an appropriate one just from a traffic perspective based on my analysis.
Yeah, sure. Yeah, no, I understand. You're only coming from a traffic perspective. So, okay, thank you.
Just wanted to, just to be quite clear, NZTA doesn't have any problems with quarry trucks using, let's just say the C2P project goes ahead. NZTA doesn't have any problems with quarry trucks using Newcombe Road to travel down to the Karapiro interchange, because initially I thought there were some concerns they raised.
Yeah, so the current thinking is that the trucks coming out of the quarry would still use the existing section of Newcombe Road heading towards the Tiro Road intersection, and then travel to wherever the construction site may be. Part of the discussion was to try with NZTA was to reduce trucks using the extension of Newcombe Road in the future, so that they don't have to design it to a higher specification. So it's part of the conditions, and I forget which number it is, I think is to encourage or design the vehicle access such that it does encourage right turns out of the quarry site to reduce usage of the future Newcombe Road extension.
Yes, see that in 35.
35, yeah, thank you.
Thanks.
In your evidence in chief, you referenced agreed matters with NZTA. It included a consent holder make all heavy vehicle drivers aware through a travel management plan of the need to avoid utilising the Hydro Road turnaround facility. Now, is this? I haven't seen a travel management plan condition per se, but we have handed up a journey management plan in yesterday's evidence, I think it was. That seems to deal with a different matter, which is making drivers aware of not going through the Cambridge CBD. Seems to me there's a place to have a more combined management plan that tries to pick up some of these travel measures as I think they're cast in encouraging terms rather than sort of rules, because they can't be enforced. Although we did hear today that there's ways to monitor drivers and so forth, which is welcome news. Is that something that you've
Yes, so
can have a thought to?
yes, so as part of my consultation with the NZTA, they did raise concerns around Hydro Road being used particularly during public holidays and times when it's busy on State Highway 1.
Yes.
So typically Monday to Thursday on your typical week, there's no real issue with use of that turnaround facilities. And in fact, it's probably a faster route to sort of head north on State Highway 1 than going through the Cambridge urban area, just due to sort of local congestion and other sort of matters like that. And so because it's available sometimes and not as efficient other times, it didn't sort of make sense to stipulate that thou shalt go this route or thou shalt go that route. It'll largely be dependent on the truck operators to select the most efficient route for them. So that's why it wasn't, or we moved away from a condition that said it must be used or it must not be used.
Not accommodate double axle, what do we call these? Truck and trailer unit?
Yes. So that's what it has been designed for. And I think on the NZT website, they even have some videos of it in use to demonstrate it. Yeah.
Just coming to, this is a new condition 32 in the set that we got with the evidence that I think you've referenced in your summary today, just around the Cambridge through traffic issue. It requires that the first part is that the consent holder commission a suitably qualified expert, it's probably yourself, to document the reported crashes over the previous 5-year period for Victoria Road, etc. Is that not data that's already in hand? Is there not a baseline? You would have assessed that for your transport assessment?
Correct, but it's also more about going forward.
Yes.
So to make sure that once the quarry is operational, that it's not creating an adverse effect in terms of safety within the urban area.
Sorry, so that it's to deal with the future.
Once the quarry is operational and trucks are moving, there will be sort of those 3 to 4 trucks going through the Cambridge urban area, and the condition is there so that we can assess and identify whether those additional trucks are actually creating a safety effect on the road network.
So the condition I was reading from is the first one where you're establishing that baseline before the quarry commences.
Baseline, sorry.
Yes.
Yes, I have done a baseline test and identified, sorry, just testing the memory. I think there might have been one crash. Say again? So yes, there was one crash which did appear as involving a truck, but on further reading of the description, it was actually a ute vehicle as opposed to a truck and trailer type vehicle. Yes.
Okay. No, it seemed to me that analysis that you've already done, I guess that would set a baseline as of today, but this is designed for prior to the quarry commencing, which could be, say 2 or 3 years, so it might build up a picture. But it seems useful to at least incorporate the data that you've already got. I guess that's always researchable in any event, isn't it, from the CAS database?
Correct.
Yeah, okay. And then... Oh no, the second part of that, 34, I'll pick up with Mr. McDean. Yeah, okay. Did you have another question? Yeah.
Just one more question. Caterpillar Dam closures have been occurring for some time now. The upgrade of the hydro station there. With that ceasing or coming to a close and the Caterpillar Dam being probably opened up more permanently, how much traffic generation would that increase the use of Hydro Road, considering it's been closed nearly for some time?
In terms of distribution of trucks from the quarry?
Just in terms of vehicles coming and utilising the Hydro Road turnaround or coming out of Hydro Road, and quarry trucks any trucks wanting to use that.
Yep. So in terms of trucks using, I guess the Hydro Road aside from turnaround, I'm not foreseeing many doing that at all. There's sort of more efficient routes to travel in that particular direction. My assessment of traffic volumes was based on volumes before the dam was closed. So in terms of effects, I don't think it would have changed any conclusions in my reporting, and don't foresee that as having a significant bearing on whether trucks can or cannot use that turnaround facility.
Lastly, I just wondered if you could advise of any particular science behind the number that you've come up with for the heavy vehicle fee at 4 cents a tonne. The council's put forward 7 cents. Feels like something of a development contributions debate, but I don't know, have you had further discussions with the council about your figure?
We had several discussions throughout the process, and I was given a number by Mr. Hudson, who's the transportation manager at council, in terms of a cost per kilometre basis. In my evidence in chief is my table identifying where trucks are going to be travelling, and what the percentage changes in terms of the quarry trucks. And then it's just a sort of a calculation of if you increase trucks by this much percent, it's therefore going to an effect of this many dollars. And then when you divide it by all the tonnage from the site, that's how I got to 4 cents per tonne. I haven't seen any calculations to give 7 cents per tonne. I know there were in the draft conditions that I saw sort of flagged as a to be confirmed number.
What you're telling me is there's maths behind it that are not a matter of.
Correct.
You can't vary them. They are what they are.
Correct.
And okay. Oh, sorry. Yes, the Appendix A. You
yes,
included that. Okay. All right. There it is. Yes. Thank you. Okay. It was all the questions we had. Clearly, the traffic effects through the town centre have been a particular issue. I think you've addressed that clearly in your evidence, and I think the route that you've identified as the key one, or this would form part of the journey plan condition, which is to keep going up the old State Highway Road network before turning right onto the, I forget the name of the main road, but it essentially goes around town as much as it can. And in your evidence, it would not be, it would take longer for a driver to go through the middle of town, the more, the centre.
Yes, and probably on your sort of Monday to Thursday type days, and that would likely be the longer route, just for the congestion that does exist in town, compared to the alternative of using the turnaround facility on the state highway.
Are there any road improvement measures that you're aware of for that route in the council's plans or anything like that?
Nothing that would affect sort of truck movements. It is an arterial road. It does provide connection between the existing industrial area, sort of just to the sort of east of that urban area. In terms of those industrial areas want to get north, that's the route that they will take. So in my view, I'm not aware of any projects or schemes that would prevent trucks from using that in the future.
That's right. Okay. And on that point, I think it's your evidence also, and that of NZTA's statement that no northern on-ramps are envisaged.
Correct.
At all or in the future.
Correct.
Yeah. Okay. All right. Thank you very much.
Thank you.
Thank you, Mr. Hall. Mr. Curtis. Just before we get on to Mr. Curtis, it's probably worthwhile just bearing in mind that for the traffic movements, there's also a cap of 400,000 per year. So it's not, while some submitters might say it's 200 trucks every day, all day for the whole year, that gets to about 1.2 million tonnes. So you need to look at both. And we always have this issue with, with quarries, and, you get a big job, you get a quite busy period and then a quiet period, and trying to get averages and rolling averages, it is a nightmare. The 200, 400 movements is arbitrary, but it's certain and it's easy to measure. It just gets really complicated trying to run rolling averages and how long you averaged over, and becomes quite problematic. Right, Mr. Curtis, thank you for being patient.
I do have some copies of my summary statement, which Mr. McDean has, and he's just vanished on. So I think it's been sent electronically through to you.
Just
Yeah, so I'll just, if you've got it electronically, I'll just start and we'll. So, excuse me. So my name is Andrew Ferguson Curtis, and I'm a technical director at Paddle Dallimore Partners. Been involved in air quality related work for almost 30 years, and done a number of sand quarries over that time, primarily in the Waikato, but in other places as well. So just starting at 1.2, in terms of background information, I consider that the mine is well situated with few close sets within 200-metre neighbours. This is important as general nuisance dust effects really occur more than 200 metres from their source. The wind monitoring that has been undertaken on site indicates that winds are channelled by the local terrain, which means there are relatively small percentages of wind from the north and south compared to the more dominant east, southeasterly winds and the west and winds from the western quadrant. I've also had particulate monitors installed on site which have measured the existing PM10 concentrations. While these are not reference level monitors, they indicate generally low levels of particulate that even if they were doubled would still provide an indication of low levels of particulate and will provide a baseline against which changes from the site once it is active can be compared against. Despite the fact that the sand resource at Newcombe Road has an in-situ moisture content of about 30%, there is the potential for site activities to generate dust, with, in my opinion, the greatest potential being associated with the removal of overburden and rehabilitation. There will be no crushing activities on site, with wet processes being used to separate out different size fractions in the resource. These processes are all standard ones and occur on all sand mines in the Waikato. This means that the mitigation measures, including the use of water and maintaining small active areas, are well proven and have been shown to be effective. I undertook a qualitative assessment of dust effects using the methodology recommended by the Ministry for the Environment and the Waikato Regional Council. This demonstrated that even at the closest residence at 41 Newcombe Road, there was a low potential for dust nuisance effects to occur. A portion of the dust that is generated will fall into the PM10 size fraction, which can give rise to house effects. My assessment is that the dust control measures that will be in place to control nuisance dust will also ensure that PM10 is well controlled. This is supported by a monitoring study undertaken downwind of approximately 230 hectares, or something in the order of 10 times the size of RS Sands, of gravel quarries in Yaldhurst in Canterbury, which demonstrated that PM10 concentrations were in the order of 50% of the National Environmental Standard for PM10, and that was actually measured both downwind of the site and also upwind of the site. So essentially, the site contribution to PM10 was actually very small. There is also some respirable crystalline silica in the resource. Crystalline silica, often called quartz, is a common mineral most commonly seen in New Zealand on white sand beaches. The respirable size fraction, that is particles less than 4 microns in size, have been identified as having the potential to cause a range of health effects. I assessed this using a US EPA assessment methodology and determined that there was a low risk based on the measured RCS concentrations in the resource. I note that Mr. Chisnell and Max Wickham have incorrectly compared the total silicon content Mr. Chisnell determined of 69% against the RCS content of 16% that I used in my evidence, and on that basis stated that I had underestimated the potential effects of RCS. Max Wickham has also identified other assessment methodologies, including a Californian guideline of 3 micrograms per cubic metre as an annual average. While it is not possible to monitor RCS emissions from the sand mine yet. The study I mentioned earlier did and found no RCS, generally found no RCS. And when it was detected at the concentrate, it was at concentrations well below the Californian guideline McSwickham mentions. And so consequently, I think there's a very low potential risk associated with RCS emissions from the site. There were a number of matters raised in submissions, most of which I've already talked about. Those that have not have primarily related to vehicle emissions. Given the current volumes of vehicles using State Highway 1 per day, in the order of 21,000 vehicles based on latest data, the potential emissions from the additional vehicles accessing or operating the site are negligible. The same is true for heavy vehicles driving through Cambridge with only a small increase in ambient concentrations, with there likely to be only a small increase in ambient concentrations generated over that from existing heavy traffic volumes. I do not consider that there is any potential that dust from site activities will have impacts on roof collected drinking water given the distances between the site activities and residences. And finally, based on my experience with other sand mines in the Waikato, I do not consider that there needs to be a significant buffer distance such as those suggested by McSwickham. Those Victorian guidelines she mentions were primarily developed to control effects from large hard rock quarries in the arid Australian conditions. They are not appropriate, in my opinion, for a sand mine in the Waikato where the resource has a 30% moisture content.
Thank you, Mr. Curtis. Sorry, just going back to my question. Just had, first of all, could you just clarify what you mean by, let's get up to it, by that the monitors were not reference level monitors? What the implications of that are for in terms of how we interpret the information?
So the reason I made that comment was it was in relation to McSwickham's evidence and her suggestion that monitoring should be undertaken using reference level equipment. So the National Environmental Standard for Air Quality sets out ambient air quality requirements that regional councils are required to ensure that concentrations are kept within. And that standard includes a specific reference level piece of equipment that can be used to measure it. So that's what reference level equipment. Reference level equipment is generally quite expensive, so on most sites, people don't use reference level equipment. They use more affordable equipment, and so that's what we have had in place at Newcombe Road is two pieces of equipment which are not reference level. They're a different type of monitor, or they use a different technique for detecting particulate. So there's a lot of these types of monitors around, so there's a good understanding of how they relate to reference level concentrations, and part of McSwickham's evidence talks about having a K factor that can be used to adjust the concentrations so that they read closer to those reference level numbers. So the types of monitors that we have used, the K factor is probably going to be somewhere between 1.5 or 1.5 or 1.8 or something like that. So you could effectively double the numbers would be one way of looking at it without doing that specific K factor calibration work that she mentioned. It's hard to say exactly where it is, but regardless, as I say, the numbers that were measured were so low that even doubled, they're still very comparable or exactly the same as I've seen measured with more reference level values in this type of environment.
So I think you'd agreed to do that calibration?
Yes, and we've agreed that with a condition that there would be some K factor development, yes.
Okay, that's fine. And just in terms of the respiratory crystalline silica content, how variable is it likely to be around the site?
I think from memory there was something like 4 or 5 sites or boreholes that were done, and the numbers in them ranged from, I think, from memory, from about 12% to 18% or something like that. So, I mean, it's not a huge variation.
Were those samples, because I don't think that detail was actually in your report about the depth at which those samples were taken.
Yeah, I think that, well, no, that's correct. It wasn't in my evidence because it's not really my expertise. I just take the data that's there. But the 16% one in particular was actually a composite sample. So I think the boreholes went down through the resource, is my recollection, and analysis was done at various heights within them. But the 16% one I did was a composite sample across the entire depth of
yeah, because I guess that was going to be, that was my sort of follow-on question is it necessary to, especially as you go down deeper, is it going to be necessary to resample to confirm that those levels are as low as has been assessed?
I don't believe so. As I say, the borehole logs or the borehole records that went with the analysis I saw essentially sampled through the resource column. So, there were some that were taken from lower down, some that were taken from the top layers, and 2 or 3 that were just composites, and they're all in that same sort of order of the concentrations.
And would it be normal to use, to me, that's quite a small number of samples for quite a large area. Would that be standard practice to use that small number of samples to provide a representation of the variability? I mean, I appreciate you're not a geologist, but you are someone who is using those samples to make a determination on the content of.
Well, look, again, I'm not a geologist, and this is definitely not my area of expertise, but I was actually impressed that there were that many samples. So, and they were across the resource. So I think that it's a reasonable number, and given that that they didn't have any really significant variation in the numbers, I doubt that doing more samples would make any difference. It might refine them a little bit, but you're not going to suddenly find that there's a spot where there's more RCS, because the RCS it's just, it seems to be randomly distributed throughout the resource.
Okay. All right. Thank you.
Mr. Curtis, I understand the dominant wind direction for the site is east to southeast. And
yes.
The gully wall is northeast to east facing. Just interested what your opinion in terms of what effect or having that gully wall for the early stages of the quarrying will have on dust movement on the site.
So dust leaving site, sorry, did you say? Well, I think that not having, retaining that as a wall will actually have some physical containment. Certainly not in the initial stages, which is true of anything, but as it's deeper down there, that's a physical barrier to dust actually travelling through. And in terms of the wind data, there's, and it's I'm just trying to find the my wind rows up that I put in. I've got the wrong evidence, sorry, so I can't find it. So in figure 2 in my evidence in chief, so that's the windrows that was measured in essentially the middle of the quarry. And you can see there's actually a relatively small percentage of those southerly winds, which would be the ones that would carry across towards French Pass Road. So to be honest, whether that bund was retained or not, the potential for wind generated dust to go north is relatively small. Having the bund in place will reduce that small potential for for the dust that might be generated primarily by those rehabilitation activities and the overburden removal, and also potentially a little bit by the some of the traffic movements as well.
I think you made mention about the funneling effect of the wind.
Also, generally across the entire site.
Yep.
Yes. Yeah. So that's constrained by I guess the valley within which the mine and Waikato River lie. It sort of flows generally in that southeast northwest direction, and so that's why the winds there are different from those measured at Hamilton Airport, which is in the middle of a big flat pit.
Just to clarify that the FIDOL assessment that you did, just can you clarify for me the way in which offensiveness is categorized? And the reason I ask that, it's probably obvious, but just to be clear, the reason I ask that is because if I was a neighbour and I knew that the resource that was being quarried contained RCS to whatever, 16%, I think you've assessed it as, for the lay person, that would be the potential for offensiveness, if not actual. Is the tool that you're using there purely about earth materials being quarried, or does it allow for consideration of particular components of the quarried material?
Right. Yep. I guess there are two things. First, I'd just correct that. We haven't said there's 16% RCS. There's 16% crystalline silica in the resource, which is quite different. That covers all size fractions. So RCS is only the percentage of that resource that is less than 4 microns in size. So that's pretty small. So to come back to the bulk of your question, the FIDOL tool is intended to be an amenity tool. So it's something that you use to assess primarily odour effects and dust nuisance effects. So I did not assess the RCS using the FIDOL tool. I used a separate analysis looking at the risk associated with materials. That's set out separately in my assessment and in my evidence. So if you
say at 2.19 that it's based on the FIDOL tool.
So that's the assessment of the nuisance effects is, so dust amenity effects. So that's 219 is talking about dust amenity effects. So my assessment of respirable silica is set out at 2.26.
Oh, sure. No, what I meant was, and then at 2.21, while we're still dealing with the FIDOL tool, is the RCS component nevertheless a potentially offensive component from an amenity perspective? If I live next door to it and I knew that RCS was a component of whatever was being quarried, I might find that offensive.
That's not how the tool would normally be used because RCS has a health component to it. It's not, it's not seen that way. So it's assessed using a different technique, which is more appropriate. The FIDOL tool is to, my house is covered in dust. That's really annoying. My washing's covered in dust. That's really annoying. What's the risk of that? Or it might go in my water tank, whatever, or something smells and I can't have a barbecue outside. The tool is just intended for those amenity purposes. It's not intended to assess health risk or associated with some specific component that might be in a discharge.
Is this situation one of those cases where provision could be built into the conditions for those things that you just mentioned, the house washing, where over a period of much less time than at present, the house might become, it might be a low amount of dust, but over days may add up?
Yeah, I mean, it's not unusual to have dust management plans that have a condition that says, do all the things that you can to control your dust, in the event that you cause an effect that for some reason you could not control, have some contingency measures to resolve those. So that's not an unusual measure to have in there. And I just can't off the top of my head remember that we have that in the draft document that we had. I've actually just, hang on a second, let me have a look at yeah.
It's okay. I think it's something that could be picked up in reply. It's just that house is right next door. I appreciate what you're saying, that the off-site generation is low, but it's hard to imagine a closer proximity for a residence. Where is it? The monitoring, talk at 3.7 about, you say, based on the analysis of silica content, concentrations of dust air, and based on similar operations, that it's expected that there will be no significant additional risk for people. And I wondered, is there monitoring data that's in a relatively easily digestible form that you would be able to provide to this panel to illustrate those types of monitoring results?
Yes, and that's, I guess, the comment I made in relation to the Yaldhurst study. So the Yaldhurst study does exactly that. That was a comprehensive study that was done, funded by Environment Canterbury due to concerns raised by neighbours who live downwind of the group of Yaldhurst quarries. There's something like five quarries in that 230 hectare area. So it was a comprehensive assessment of the additional risk. So we can certainly provide you with a copy of that if you would like that.
Thank you. Lou Wickham was actually a peer reviewer on that, and that is mentioned in the report. We have a copy, so we can easily provide that. That was a very in-depth study.
Yes.
I don't know if you see it when you fly into Christchurch Airport. It's a very, very large area of quarrying. So anyway, we'll get you a copy of that report because that was specifically looked at.
And the I guess the interesting thing about that report is that, you know, they're gravel quarries, but they do size reduction because of, and so they're the sort of sites that if RCS was going to be generated, you'd expect it to generate, and it wasn't measured in appreciable quantities.
You're saying that the monitoring data is based on similar operations. Is this one in Christchurch rather than anything more local?
I'm not aware that there are any sites in the North Island or at sand quarries that have done RCS monitoring downwind of them.
Right. So when you make that comment at 3.7, you're only talking about the study in Christchurch. Is that right?
Yes, because I'm not aware that there are any other sites.
Well, you've said on similar operations. I'm just trying to understand, what are you using as your comparator?
So at 3.7, I'm talking about general dust concerns. If you're looking at my primary statement.
Thank you. I think I've written the paragraph number down wrong. Or not. Yes. Okay. So what you're saying is that's solely related to dust and not RCS.
Yes.
So okay. All right. So the only monitoring data we have is in relation to the Christchurch quarry that's been monitored for downwind RCS.
Yes. Yeah. Okay. A lot of, I mean, there are hard rock quarries that do occupational RCS monitoring. But that's a different thing because that's people who are directly exposed to the activity. But in terms of downwind stuff, the only site I'm aware at the is that one in Yaldhurst.
All right, and just to clarify the point that you made earlier, so we have, I think, has it been agreed that the measurement of, I think it was around 70% of silica that was raised by Lou Wickham's evidence, that's not the respiratory or crystalline. Then we have the 16% figure that you've got for RCS, but of that, there's a further fraction as to what is actually
So the 16% is crystalline silica.
Yes.
So it's the quartz.
Yes.
And there's a smaller fraction of that.
Yes.
That is in the respirable
Yes.
fraction.
Yes. And to be respirable, it needs to be at the PM4
And less.
and less. So not PM10, PM4.
Yeah.
Yeah. Okay. All right. Good. Okay. Got it. Thank you. All right. Thank you very much for your evidence.
Mr. Curtis, Mr. McDean. Lucky last. Thank you.
We might just take a 5-minute break. I think everyone might appreciate that before we go through. Thank you. Okay, we'll get back on the way.
Right,
Thanks.
thank you. Mr. McDean.
Oh,
Oh.
yeah, thank you. No, you can start, Mr. McDean.
I'll start at section 2, if that's okay. So the project, as originally submitted and clearly changed, you've heard today, is described in full in both the application and the respective 42A reports. As you're now aware, RSN have proposed an amendment to the quarry staging that results in the north wall being left in place until the quarry is nearing completion. I would like to deviate a little bit and acknowledge the Commissioner's comments today on the conditions, the condition sets. Clearly, there's a bit of work to be done there, and trying to get, I guess, build the relationship between WRC and Waipā conditions to get them working a little bit better. So we'll be endeavouring to work on those, ideally, well, with the council's involvement as well, over the next few days. Paragraph 3, the submissions. So submissions made generally followed a lot of specific themes: traffic, air quality, ecology, water take, amenity, biodiversity, and cultural effects. Those submissions have been very well addressed within the 42A reporting of both councils, and the theming of those submissions, as well as by RSN evidence, specialist evidence and rebuttal evidence to submit expert evidence. A number of submitters were directly engaged both before and after receipt of submissions, and this resulted in a number of submissions with submitters withdrawing their right to be heard, tabling evidence confirming concerns had been appropriately mitigated, or withdrawing their submissions in their entirety. And that these are the New Zealand Transport Agency, the Department of Conservation, Fish and Game, and Mr. Ivan Julian of 94 French Pass Road. A number of parties related to the property at 41 Newcomb Road made submissions on the application, and this included groundwater effects, which have been assessed by Mrs. Holbrook, taking a conservative approach due to lack of site access. On the basis of a probable effect, RSN offered WRC draft conditions that required RSN to provide an alternative water supply to address this potential adverse effect. These types of conditions have been offered to and accepted by WRC in the past, namely for the construction of the Cambridge section of the Waikato Expressway, which is where we got that condition from. A similar set of conditions have been volunteered by RSN for 143 Te Rau Road, again taking a conservative approach on the lack of site access, and building in a level of assessment and potential certification by WRC to ensure we are in fact, RSN is in fact causing a failing water supply. I think it's been noted that it is the best we can do without that site access. The 42A planners reports, Waikato Regional Council, Mr. Penfold's report. Mr. Penfold noted two outstanding issues within his report. Sorry, I am in general agreement with Mr. Penfold's 42A report. Mr. Penfold noted two outstanding issues within his report. The first related to a protection and perpetuity mechanism for the restoration area. RSN provided proposed conditions to deal with this. That was supplied within my evidence in chief. The second outstanding issue was in relation to conditions agreed with the NZTA, specifically the Trigger Action Response Plan. An original set of TARP conditions were provided by RSN and agreed to by the NZTA. However, the WRC have since provided a set of updated conditions providing WRC with certification of the TARP. The proposed conditions were subsequently agreed by all parties and have been circulated within my rebuttal evidence. Waipā District Council 42A. I noted within my evidence in chief that I had only minor but largely immaterial disagreements with Mr. Whitaker's 42A report. However, this was prior to the Waipa District Council draft conditions being made available and the introduction of an expiry date to the land use consent sought. The LUC expiry, proposed condition 3 of the Waipa District Council consent conditions, proposed a term of 25 years, but only actually provided 24 years due to the expiry in July 2049. The RSand application at no time sought a term or expiry for that land use consent, and it was expected that this would be an enduring land use consent. The 25-year life is an estimate based on the expected availability of the resource and an average extraction rate of that resource over that period. The extraction footprint has been clearly identified with no ability to go outside of that area without a resource consent or a 127 change of conditions being approved by both the Waipa District Council and Waikato Regional Councils. The operation should cease in that location when the resource operating within the parameters set by the consent conditions is exhausted rather than at a specified date. As such, we seek to have that proposed condition removed. Truck movements through Cambridge. Mr. Whitaker made an excellent point within his report that there seemed to be a misunderstanding with regard to the assessed vehicle movements through the Cambridge town compared to the number of truck movements being 400 frequently mentioned within the submissions. I believe that based on the number of submissions that raised concerns with regard to the incorrect figure of 400 truck movements through Cambridge, this was an important point to make, and this has also been clarified by Mr. Hall. The National Policy Statement, Highly Productive Land. Mr. Whitaker highlights concerns with the NPS HPL, specifically the significant national or regional public benefit that could not be otherwise achieved using resources from within New Zealand. I've provided my own opinion within the original application documentation and within my evidence in chief on how the NPS HPL should be read. I've also relied on the assessment of Mr. McElrath and his evidence in chief. I maintain my opinion that the NPS HPL must have been prepared on the basis that resource consents for aggregate extraction are able to be issued consent. Otherwise, why was it specifically provided for within clause 3.92 and separated from mineral extraction in 3.92J3? Both the legal submissions of Mr. Matheson and the evidence, including rebuttal of Mr. McElrath, have provided further opinions on these matters, which may hopefully influence Mr. Whitaker to provide his own opinion to assist the commissioners in making their decision. I do concur with Mr. Whitaker's statement, reiterated and expanded on by Mr. Matheson, that an NPS is but one of the relevant planning instruments to have regard to within section 104B. Outstanding matters. Mr. Whitaker noted a number of specific queries in relation to transport, vibration, pastoral re-establishment and bunding, all of which have been responded to within the specific specialist evidence, or within my own evidence in chief or rebuttal evidence. And we've heard from a lot of those specialists today covering those topics. I reiterate the statement I made in the rebuttal evidence that RSand would like to hear from the owners and occupiers of 41 Newcomb Road in relation to the establishment of a noise bund identified on the bund sequencing plan submitted with my planning and engagement rebuttal evidence. As discussed earlier today, it could go in at different times. It could go in at the start, it could go in when during stage 3 or 4 when heavy vehicles or when earth machinery is getting close or getting close to their notional boundary. Specialist evidence. Mr. Adrian Morton. Mr. Morton made reference to a site visit he undertook to ground truth his understanding of the site. No RSand associated person, including Mr. Manser, was able to undertake a site visit to 42 French Pass Road until the afternoon of the 31st of March, 2025. Initial contact was made with Mr. and Mrs. Powell in late September 2021 by letter from Kinetic Environmental. This began a relatively short phone and email correspondence period between Mr. Powell and myself. Consultation ended with Mr. Powell on the 24th of November 2021 following the request of an access fee. The access fee arrangement or negotiation of a fee was not something RSand were willing to enter into. However, With access being granted on the 31st of March by Mr. Powell, I view this as a positive outcome that has allowed Mr. Manser to be able to ground truth this assessment, which has resulted in a proposed amendment to the quarry staging to better manage the offsite effects. Blue Wickham, in their evidence, it is stated they do not believe the proposal can meet the permitted activity standard because there is a discharge of hazardous substance, or RCS in this case. The application documents undertook an assessment of the permitted activity conditions within the mineral extraction rule within the regional plan, which was informed by the air quality assessment completed by Mr. Curtis. It was concluded that the permitted activity standards could be met and that there was a negligible risk of RCS at the site boundary. I maintain the opinion that this is a permitted activity. I have significant experience in preparing and managing resource consent applications on behalf of aggregate extraction operators across the Waikato. I'm not aware of any aggregate extraction application I've made in the last 15 years having resulted in the issue of a discretionary activity air discharge consent. While I appreciate each site must be assessed on its own merits, these applications have included hard rock quarries where significant volumes of aggregate is crushed, unlike in this situation where water is used to wash and separate aggregate material by size. Notwithstanding my comments, if the commissioners did decide a consent were required, a specialist assessment would need no additional work. The specialist assessment would need no additional work by Mr. Curtis. In my opinion, a discretionary activity could, if necessary, be granted by the commissioners. Mr. Mark Crisp. It does not appear that anyone other than the Road Controlling Authority or the New Zealand Transport Agency would disagree with Mr. Crisp that north-facing ramps would be beneficial to the proposal and possibly even the Cambridge community. However, the NZTA have made their position clear within Mr. Braithwaite's evidence that these ramps have not been considered for construction at any point in the recent past or are going to be in the near future. Any further consideration of these ramps as part of the application is beyond scope of what has been sought by RS Sand. For the reasons outlined within the application documentation, my evidence in chief and rebuttal evidence, I maintain that the project can be granted with appropriate conditions.
Questions?
Yep. All right. Thank you, Mr. McDean. I was just wondering, there was mention of an MOU with iwi, and I noticed, I was interested that there wasn't any cultural evidence presented today. So I'm just wondering what the status of that is, this MOU, and also what the purpose would be.
I'd have to leave that to Stevenson or RS Sand.
Sorry, what was the question again?
I understand that there was mention of a memorandum of understanding with local iwi. And I'm just wondering what the status of that was and also what the purpose of it is.
The MOU with the iwi is that we'll work together with them. Sorry, the purpose of the MOU is that we'll work together with them. We'll give them preferential treatment for work on the site around pest control and planting, and we will induct our people. We'll get them to induct our people into the cultural sort of significance of the area. So those are the main things, the main purposes for it.
And so what's the current status of that MOU? Has it been signed?
Yes, it's
It has
active.
been signed.
It starts when we get a consent.
Okay. Right, thank you. I think, and in your, I think it was, yeah, in your rebuttal evidence, back to Mr. McDean, you present this fund sequencing plan. And I was somewhat surprised not to see any time frame on it, given that it's what I would have expected. A sequencing plan, to a sequence sort of implies some sort of temporal component to it. So I was wondering if you could take us through this sequencing plan, which I'm just getting up now.
I can.
And I guess the question is it still relevant as of today?
Yes,
Okay,
yes, it is.
with the change, I mean, yeah.
Yeah. What we did with the bund sequencing plan was I mean, largely in relation to the millers and understanding, seeking to understand their view. And also just to confirm to ourselves at what point the different bunds were required. So in the application document, I'll start with the it's noise and planted landscape mitigation bund around the plant area. The application does say that when the stripping of that processing area occurs, the stripping material will be used for that bund.
Great.
So that will happen day one when they start stripping that processing area. The green or the blue one is a bund that just got shown on a plan and kind of got carried through. It serves no purpose, no mitigation purpose. It would effectively be used for additional stockpile area for topsoil if it was necessary. There's a significant amount of landscaping along the front of that property already. It wasn't required for landscaping. It wasn't required for noise. It was just shown on a plan
Yeah,
as
so it's not really a bund, it's just more.
it's a stockpile
Pile
area.
of, yeah, stockpile,
yeah.
yeah. Okay,
The green bund it's a visual bund from the highway. So that does need to be constructed using, well, that probably does change actually, now that I can read it because I've got my glasses on. That will be constructed using strippings from whatever stage one is going to look like now.
okay.
And that is to avoid, when you came down I'm not sure if you came down, you would have seen it as you came down the expressway. You can look basically right across the property, and that visual bund is for that purpose. That'd be constructed immediately using stripping material.
Okay, and that's going to be planted, you're saying?
That is going to be planted, and that is in for the life of the quarry.
Okay.
The orange bund is the noise attenuation bund for the Miller dwellings. That can be constructed, I guess as we've discussed, when the Millers would like. It is for their purpose. It is for us to be below 50 dBA, being the district plan standard. I did talk to Mr. Hegley earlier, and he said that if the bund weren't in place, the noise level would rise to 54. So it doesn't need to be in place until heavy machinery is within the notional boundary of those dwellings, which we have got a plan. It's a bit hand-drawn, but it's effectively an arc from one end, or from the northern end of the orange line to the southern end of the orange line. And so it would be at that point, would be at the latest, prior to that, obviously, that bund would have to be constructed. And then once the floor level of the quarry is dropped 5 metres below existing ground level, then it would no longer be required.
Okay.
So
when you're saying it's an arc, so that means that, because I guess that was one of the questions, was that, does it need to be right up against the boundary?
The bund?
But if it's, so if it's an arc, that means quite a considerable amount of it won't be anywhere. Well, how far back from the boundary would it?
Oh, no, the notional boundary is an arc. Sort of.
Oh, the notional boundary.
The notional boundary, yeah.
Oh.
Yeah.
Oh, I see.
Yeah.
So what's the straight line? Sorry.
So the orange line is a bund.
Yeah.
The notional boundary is a theoretical boundary from a dwelling where if heavy machinery were within that notional boundary, then we would be exceeding the district plan noise permit activity noise.
So does that need to be straight, that bund?
It needs to be straight in order to track with the quarry staging. The quarry staging, it comes quite close to that boundary, as you would have seen on the images today.
Okay, I think I understand it.
Does that make sense?
Yeah, sort of. If the notional boundary is in an arc, that means there is a point where you're furthest away from the actual boundary.
Sorry, I can
which is in the
probably,
middle of the arc.
yeah, sorry, I can probably assist. So the notional boundary for noise measurement is directly normally 20 metres from the facade of
Yeah,
the
yeah,
house.
yeah.
So that's normally what we'd call a
Yeah.
notional
Yeah, no, I
boundary.
understand that.
I think what Mr. McDean's talking about is there is an arc which runs from the miller's house 100 metres in every direction,
Mhm.
which creates an arc. Once heavy machinery gets within that area, the bund needs to be in place. So it's
Ah,
a
I see what you mean.
proximity
Yeah,
to the
yeah, yeah,
house issue, not a, that, I think
Okay.
that probably.
Yeah, thank you. So,
Okay.
yeah, because I mean, that was one of the questions, is does it have to be right in the boundary? Can it be further back so that it has somewhat less of an effect in terms of a shading effect, for example, an amenity effect? That was one of the questions.
Well, I guess it can be. I think we've heard from Mr. Holland today that
Yes.
we need to be 10 metres off the boundary. The bund is quite large.
Yes,
Um,
exactly.
You know, but I guess it's something we're keen to discuss further with the millers.
Yep.
Well, I believe there's a number of them coming tomorrow.
Yeah, okay, thank you. Thanks, Chair.
Just one question for me, Mr. Dean, just in regards to tangata whenua. The CIA talks about kaitiaki being present during the initial earthworks of the topsoil. And I didn't see anything reflected in the consent conditions to enable that to occur, because it's pretty standard practice now, especially on the expressway developments.
Yep, you're right. There is no condition on that. It is, I believe, within the MOU. It will also be a requirement of our archaeological authority. Every archaeological authority I've seen has required kaitiaki monitors to be in place, but you're right, it could also be a consent condition.
Happy to make it a consent condition. Mr. Fulton just confirmed it is in the MOU, which is signed as well, so.
Thank you.
Just been looking at this quarry sequence, bund sequencing plan, and it's quite useful in terms of the way it's conveyed the quarry detail as well as the bunds. And I wonder if this might, I think you probably picked up through the hearing that, well, one, there needs to be a change to the staging plans to accommodate the change that's been discussed today. But it just highlights a couple of things. Well, I guess the main one is just getting back to that gully E and how close it comes up to that ephemeral stream. And I wonder if there's a need for a little bit more of a buffer to that area as part of any new plans that you might be preparing. Just something to consider. Certainly from walking it yesterday, it looks like the white line of the edge of that quarry would run straight down the gully itself. I'm not sure that's quite what you've intended.
Yeah, okay.
I had a question for you based on your evidence in chief as to what your overall conclusion was in terms of effects. I think you reached an acceptable was the way you qualified it. My question was going to be around the fact that Mr. Mansa had clearly reached more than minor, quite high effects in some cases at that point. And I was going to be interested as to what your conclusion was having regard to that. I think that's resolved today because he's gone back and he's looked at it, and no doubt you would adopt his findings.
Absolutely.
And I think you're using the word acceptable in a Section 104 context. You're not falling back on whether it's minor, more than minor. But it's just to have it clear that that is your conclusion on effects as things stand at the moment.
Yes.
Is that they are acceptable.
Yes.
Yeah, your assessment. Okay. My other questions were really, and I've indicated some of them earlier, just around conditions. And you've already said that you're going to be talking to the regional council about those. And I mean, there's things like we talked about the ecological management plans and the way they could tie together. I mean, the regional council functions are different and they're dealing with different things, but I think it does need some coordination to make sure they're not saying different things, and that you might be able to do one quarry management plan, not two, depending on what the different conditions say.
I think council would, Stevenson's would prefer less management plans
Yes.
than more.
Well, you've got quite a list at this point.
They do.
And I appreciate in that discussion that you only got the district council's conditions reasonably recently, so that's fully understood. There are things like complaints provisions, and you have a different arrangement for receiving and dealing with complaints between the two councils. And I think a neighbour wanting to make a complaint, if that should happen, won't really know who's the right organisation to go to. Some sort of coordination of that. I talked to Ms. Matheson earlier about just sorting out the lapse, expiry and duration consents, because you've got regional discharge, you've got regional land use, and then you've got actual land use. And I think your AE was quite clear that it sought 35 years where you're required to.
Yep.
So you sought the maximum, and that's understood, and that would be effectively the limitation on the consent
That's right.
if it's not going to be 25 years.
I guess I shouldn't, but I will speak for the regional council a little bit. When you mentioned the earthworks consent or the land use consent, I have had this discussion with the
Yes.
regional
Oh,
council
what's the answer?
many times.
Yes.
That they consider that it's also it's a hybrid rule.
Right.
So it allows discharge.
Okay.
And on that basis, they tend to issue an expiry.
Right.
It's not a
okay.
pure land use consent.
Yes. Okay.
The term for it is hybrid rule.
Right. Okay. Very good. I didn't think it affected section 13. So I just, but okay. No,
been a
I'm
lot of
sure there
debate.
must have been a reason for that. Thank you. So I'll just see if I can give you some high level comments. The rehabilitation management plan at 48 of the the regional council conditions seem to be dealing with 48 was the only part relevant to site rehabilitation, whereas the remainder, and that was 44 to 46, were all transpower requirements. So they seem to be doing quite different things. And again, I think with all these management plan conditions, you've addressed it with the TARP now, but they need an objective in some context for the reason that they've been imposed. And they're provided in some, but just not all. And I think for someone coming back to this however many years hence, it just helps people understand why the management plan is required. Again, quite a difference between the section 128 provisions between the two sets of conditions. And I think ideally they would be quite consistent so that if there is a 128 review, that it might be across both consents and it's been done in a coordinated or consistent manner. And I felt, I wondered why the regional, I think it was the regional council one, had bands of 5 years specified. Or was that the district council ones?
No, I think that
one of them.
was
And I think if we were looking at them as part of a consent, we would allow the council to undertake a review at any time.
Oh, just on that,
Yes.
it's a legal point. I've never understood the logic of it, but there is a requirement to specify a time period in the review condition. So
Yeah.
you can't just say review it at any time. That's why they have wording like every March of every year or something. So it became an issue 20 years ago, and so people sort of get around it by specifying quite a strange time frame. But yeah, I mean, the difficulty from a review condition perspective is, the WRC and WDC have the standard review conditions, which are different. So it's just I'm glad you, I thought you were at one stage talking about council integration there for a while, and I thought that'd be a bit much to do by Friday, so.
that earlier, this journey management plan could be cast as a travel management plan, and we did wonder whether I think you've made it in good faith, the idea that truck drivers would be brought in for an information evening. That seemed to be probably more than what would be required in terms of what you're trying to achieve with that condition. So that seemed, as I say, it could be combined into a travel management plan, it would seem, dealing with both the city access and the way in which trucks are turning out. I think I'll leave my other comments. You're obviously going to be working with the councils on them. The points that I think were made earlier are just around, and we understand the reason why the ecology mitigation plan is not at that level of detail at this point, but I think what we're looking for is quite a bit of certainty as to tying stages, what's required before a stage gets underway, as to what's expected to occur in terms of that mitigation, particularly if it's prior to commencement or being undertaken during that stage.
You mean the quarry staging or the ecology restoration
Sorry,
stage?
quarry staging, but what I mean is the ecology staging and the works.
Yep.
There's a certain amount that's to be done at each point that needs to tie to the stage. And I don't know if
Do you have a preference? I mean, my understanding was on the time frame, but I mean, presumably it would be cleaner for the condition to simply say that all the restoration planning shown in Plan X shall be completed by year X, with minimum standards of A, B, and C. And I guess that would be cleaner than trying to link it to the actual quarry staging, unless there was a definite link between the two, because the restoration planning is all happening off-site. So, I mean, I think the cleaner way would be to separate that. There's a separate issue with the rehabilitation on-site, and that needs to link. So, but I think if that's what you mean, and we can certainly separate those things out.
Again, it's just so that the timing's clear and I think you've got objectives for those, but what has to happen and when, and how that's tied into the stages.
I don't actually think that's tied into the mitigation planting, or the offset planting is not tied into the staging.
It's just a time period that we need.
Which I think we have. I think Mr. Baby has mentioned 5 years, having it completed within 5 years.
Possible, I haven't interpreted the way that they're cast properly, so I appreciate that. There's two different EMP type conditions between the two consents. So I guess it's a matter of rationalising those. When all the subsidiary plans, they're kind of already almost there because they're in the EMP already, but when they're required to be certified by. But I also appreciate you working within the framework of conditions that have been developed before for quarries. So it's just me looking at them afresh and going, why don't you do something different? Okay. Well, look, I think, yes.
Yeah, I mean, just following on from that, I'm sure you'll pick this up, but I'm not sure if you're aware that in the Waikato Regional Council conditions, it says the EMP is prepared at least 40 days prior to commencement of sand extraction activities. And in the District Council, it says at least 20 working days prior to the commencement of activities authorised by the consent. So it's quite a huge difference in timing. So I assume it basically will be at the beginning, especially considering that Dr. Baber mentioned that planting will occur in that first winter following, if granted, consent is granted. So
I think we'd realistically have those plans in a long way prior to that 40 days before we wanted to start, appreciating that the councils have a bit of work to do to certify those. So
it wasn't so much the days, it was when. One was sand extraction activities and one was basically when consent was granted, which is a big difference.
Yeah.
But it's the planting can start for extraction. So.
Yeah.
Okay. Yes, 9 o'clock tomorrow. I mean, that's kind of the end of your case, unless you're proposing to present anything at the start tomorrow.
No, I don't think so. we'll have a think about it overnight, and if there's anything useful, we are getting some good graphics done that will I think assist the discussion we've had. So they've been underway today. So yeah, so certainly heard the Commissioner's helpful comments around that staging issue. So, but it's probably better to roll into the submitters, and then we'll just keep working it up.
Well, on that basis, we'll consider your case closed. Just for Mr. and Mrs. Powell, have been sitting here patiently today. Got you scheduled 3:15 tomorrow? That is?
We might come on earlier at 2:30.
2:30, okay. And I think you were here at the beginning. I just want to reiterate that when we're asking questions about conditions, it might seem very detailed and getting into what conditions we might put on a consent. It's just that it's our chance at the moment to talk to the applicant about the conditions that they're proposing. So that's why we're asking about them and making sure that they're workable. All right, so yeah. Okay, thank you, everybody. Didn't keep you as late as I might have, but have a good evening, and we'll see you tomorrow at 9 a.m. Thank you.